meeting. This is Kathleen Drew, Chair of the Energy Facility Site Evaluation Council, calling this meeting to order for the adjudicative hearing for the Wautoma Solar Energy Project. Ms. Owens, will you call the roll of the Wautoma Council?
Yes, Chair. Department of Commerce. Department of Ecology. Department of Fish and Wildlife.
Mike Livingston, present.
Department of Natural Resources.
Lenny Young, present.
Utilities and Transportation Commission.
Stacy Brewster, present.
For Benton County, Dave Sharp. For Washington State Department of Transportation, Paul Gonset.
Paul Gonset, present.
Chair, we have 3 from the regular council and 1 from the optional councils. Is that enough for a quorum?
That is. Thank you. Judge, I will hand it over to you.
Thank you. Good morning, everyone. Let me go ahead and begin by setting the record, and then I'm going to describe the process for today's proceedings, and then we'll get into the adjudication itself. We are on record in the matter of Wautoma Solar, OAH docket 279466. And the date is September 25th, 2024, and the time is 9:02 a.m. Pacific. And we are recording this hearing by audio methods. In addition, I do believe we do have a court reporter on this meeting. Court reporter, if so, would you go ahead and speak up, please? Perhaps we don't have a court reporter. If the court reporter does join at a later time, I would ask that whomever arranged them have them announce themselves. Ms. Owens?
The court reporter is John Patello. I'm not sure why he is not able to speak.
Okay, parties are automatically on mute when they join the proceedings, so if he is present, I would ask you to go ahead and unmute yourself and just announce it, just so we're all aware that you are present.
This is Dave Sharp. Can you hear me?
I can. Mr. Sharp, are you acting as the court reporter today?
Excuse me?
Are you acting as the court reporter today?
No, I'm just trying to get on to the adjudication.
Mr. Sharp, we just started the adjudication. We're setting the record, so I'd ask you to go ahead and put yourself on mute if you would, please. Thank you, sir. All right. So, as I was stating, my name is Dan Gerard. I'm an administrative law judge with the Washington State Office of Administrative Hearings, and I will be the presiding officer in today's adjudication. Yes, Chair Drew?
A couple of things are coming in from the chat. Ms. Osborne from the Department of Commerce has noted that she's having trouble with Teams, but she is present. And our court reporter has reported that he can't unmute himself on this.
Okay. Let me see if I have the functionality to unmute Mr. Lothello, and then we'll have him announce himself for the record. Thank you for the clarification.
Also, if I might, Dave Sharp is the community member from Benton County on the council.
Thank you.
So he is present as well.
All right. I'm unable to actually mute somebody with the functionality that I have. Let's go ahead and proceed. I do believe there is an ability to unmute yourself if you can't do so with your computer. I don't recall the exact mechanism. I don't usually deal with that particular portion of it. Ms. Owens, I don't know if I don't know who is actually on behalf of VASAC controls these, the technological aspects, but if you could find out how to unmute or someone to unmute themselves, if beyond just the function, that would definitely be beneficial.
This is Ms. Owens. I did try to unmute them myself, but it also does not give me the option, and I'm an organizer. It might be best if they leave the meeting and re-enter. That might fix the issue.
I don't believe so, actually. I think because everyone comes into the meeting itself muted from the get-go, So we're going to have to find a way, because obviously if that's the case, then none of the participants are going to be able to speak up either if we can't get a workaround for that. So before we get too far in, because I'd like to hear from the parties, I'd like to make sure that those who are currently muted can unmute themselves, and I'm going to pick someone randomly just to get a sample. Ms. Holt, you represent Benton County. Can you unmute yourself and speak up if you can, please?
I'm able to. Thank you.
Very good. And Ms. Anderson, are you present on behalf of Wautoma?
Your Honor, this is Andrew Lewis, also representing the applicant with Ms. Anderson. She is currently unable to join the meeting and trying to get in, so we're working with IT on trying to figure that out.
Let's hold off on setting the record and getting started until we get everybody who's a participant joined. In that way, we have the sufficient quorum, we have the parties who are going to participate, so we don't have to repeat the process. So the participants I need to make sure are present are all of the council members who satisfy the quorum. I also need the representatives from the respective parties of interest. That is Benton County, Wautoma Adjudication, as well as Council for the Environment. The rest of the parties, if they're simply observing, they don't need to speak up through the adjudication, so we don't need to concern ourselves with the technological aspects of theirs. So let's give everyone a moment to make sure that fully joined, then I'll describe the process, then we'll get started with the adjudication. And Mr. Bartholo, given that other parties are able to unmute and mute themselves, Ms. Owen's suggestion that you disconnect and reconnect may be a workaround. So if you go ahead and do that, and we'll wait for you to join as well as the rest of the actual participants. Okay. While we're waiting for the other parties to participate, I'd like just to make sure that the other party participants are present and can unmute themselves. Ms. Holt, are there any other representatives? We'll talk about your witnesses in just a minute. On behalf of Benton County besides yourself?
No, Your Honor. It would just be myself and my witnesses.
Okay. And Mr. Lewis, when Ms. Anderson is able to join, would you please speak up just so we have a cue?
Yes, Your Honor. Sorry, do you want me to discuss our witnesses who are present as well at this moment?
No. I want to wait until everyone's here. I just want to handle the logistics of getting everyone connected. Who are the representatives first? We can deal with the witnesses once we get to that part of the hearing.
Thank you, Your Honor. We are still... Ms. Anderson is sitting right next to me in person, and we are trying to get this sorted out on the laptop as quickly as possible.
All right. If you are going to be in the same room when you finally do get connected, I would ask that you keep one line constantly muted. Otherwise, there will be feedback from the proximity of the computers.
Absolutely. Thank you, Your Honor.
And Mr. Kroll, are you present on behalf of the Council for the Environment? If so, go ahead and unmute yourself, please.
Yes, Your Honor. I'm present.
Thank you. You have it labeled as Robin. Is there someone else present with you besides, or is Robin a pseudonym to go by?
This is Robin Robert. Yes, I'm present.
Oh, Okay, it looks like you spoke up at the same time that.
Oh, sorry.
No, good. And those of you who are not participating, I would ask you to go ahead and put yourselves on mute, just so we can avoid any unnecessary or superfluous background noise. So go ahead and do that. Mr. Bothello, can you hear us?
Good morning, Judge. John Bortello, I can hear you.
Bortello, thank you, sir. Very good. Thank you for doing that as well. So it looks like we're just waiting for Ms. Anderson at this point. Mr. Lewis, I'm kind of at a loss as to why you could connect and she couldn't. I'm not sure. Unless you're using different technology, the length should have been the same between the two of you.
And, Your Honor, I apologize that I am not technically savvy enough to speak to that.
Okay. But you are using the same code that you use, though, correct? Not a different
Yes.
one or from a different document?
Yes, Your Honor, we are using the same link that was provided.
Okay.
Your Honor, it's been suggested that potentially an admin on the council side may need to admit Ms. Anderson as she is trying to join the meeting. I don't know if council IT could exhaust that as a potential issue.
Yes, so if whoever the organizer is, if you go ahead and I think Ms. Owens, I believe you said that was you. It looks like Ms. Allen is also listed. I don't see anyone attempting to join the meeting, and usually there is a notification for that.
If you can put her email or phone number in the chat, I can try to dial them in directly.
We will try that. Thank you so much.
Yes, Treasurer?
If I could correct the record for who is present at the meeting, since we had kind of a rough technological start. Ms. Osborne from the Department of Commerce is present, and Dave Sharp, Mr. Sharp from Benton County Representative is present. So the only council member not present is Mr. Eli Levitt from the Department of Ecology. Is that correct, Ms. Owens?
That is correct.
Thank you.
Thank you, Treasurer. And thank you, Ms. Owens, for sending it to them. I will discuss the use of the chat, too, in just a moment. Mr. Lewis, do you have a status of Ms. Anderson?
We're still working on it, Your Honor. My apologies.
Can she hear you on your end if I set the record, or is she too busy trying to figure out the technological part?
Your Honor, Ms. Anderson can hear the court and can you restate your question, please?
I'm trying to see if we can start now if she can hear us. Or otherwise, if she's otherwise too busy with the technological issues, we'll still give them a moment. But I'd like to get the proceedings rolling if we can.
Your Honor, we are going to switch laptops entirely, so we expect that Ms. Anderson will be available momentarily.
Thank you, sir.
All right, Your Honor. Could you this is Erin Anderson using somebody else's laptop. Can you hear me okay?
I can. Thank you, Ms. Anderson.
Oh, very good. Thank you so much for your patience.
Okay. It looks like we do have the party participants present, so let's go ahead and begin. I'd just like to confirm one last time that everyone is present and can hear me. Ms. Anderson, you have, just as the representatives portion, not your witnesses, Mr. Lewis and yourself present on behalf of the applicant. Is that correct?
That's correct.
Very good. And Ms. Holden, we did confirm it earlier. It's just you on behalf, at this point, on behalf of Benton County?
That is correct, Your Honor.
And Mr. Kroll, you are the one representative on behalf of the Council for the Environment. Is that also correct?
That is also correct, Your Honor.
Okay. And I don't believe there's been any changes within the quorum. Chair Drew, were you ready for me to go ahead and reset the record and begin?
Yes.
As I was stating, we are on record in the matter of Wautoma Solar, OAH docket 279466. I'm Administrative Law Judge Dan Gerard with the Washington State Office of Administrative Hearings, and this adjudication is being held on September 25th, 2024 at 9:18 a.m. As I said before, I am Administrative Law Judge with OAH, but I am just the presiding officer in today's adjudication. This means that I will oversee the conduct and the flow of today's proceedings. I'm going to start today by describing the process in which we will follow, and then I will go around and see if there's any questions before we move on with the actual hearing itself. As the hearing progresses, I would ask those of you who are just observing or are witnesses to mute yourself until it is your time to either testify. The party participants, obviously I would ask that you keep yourself unmuted if possible. That way, if there are any objections, you can do them timely. If you are going to leave yourself unmuted, I would ask that you turn all cell phones off so we don't get unnecessary artifacts into the record. As we had confirmed earlier, too, we also have present today a court reporter. We are recording the hearing in addition to the court reporter's services. In light of that, I would ask that all parties speak loudly and clearly today when they are speaking. And we are only recording the audio portion of today's proceedings and not the video. So today I will instruct all witnesses when they answer to answer orally with yeses or nos, not head shakes or nods, or any other visual cues that will not be captured by the record. If any time today the court reporter cannot hear or understand you, At this point, they have my permission to ask the party to repeat themselves. If the court reporter does need a break, as it is an exceptionally taxing job, I would ask that they speak up to let me know. Otherwise, if I don't hear from him, I will assume that they are capable of continuing on. We are going to start today by giving the parties an option to make opening statements of no more than 5 minutes. An opening statement is a party's preview of what they believe the evidence will show. An opening statement is not evidence, however, and cannot be relied upon unless that evidence is presented either in the exhibits or through sworn testimony. I also would remind the counsel, who are the decision maker in this case, that any pre-hearing briefs are also just argument and not evidence that they can rely upon unless that evidence is solicited through sworn testimony today or the documents that were entered into the record. The same thing applies to post-hearing briefs and closing arguments. After the parties have been given an opportunity to give an opening statement, we will then move on to the presentation of the cases, starting first with the applicant. The applicant may call the witnesses in whatever order they deem appropriate. The applicant's attorneys will be given the chance to question their witnesses. After they have finished questioning each witness, the party participants, and that is to say Benton County, as well as the counsel for the environment, will also be given the chance to question the witnesses provided by the applicant. And also the council members may also ask questions after all the party participants have been given the chance to question those witnesses. That process will repeat through each of the witnesses that are all called, and that process will also repeat with each presentation of a party's case. After the applicant has presented all of their witnesses and the rest of their case, we will then move on to allowing Benton County to present their case in chief. Again, they may call their witnesses in whatever order they deem appropriate. We'll be allowed to question those witnesses. The applicant, the counsel for the environment, and the counsel also may ask questions of those witnesses in due order. After Benton County has rested their case, we will finally at that point allow the counsel for the environment to present any testimony or argument at that point if they wish to do so. Please note that any time the parties may object to any question asked by the attorneys or by the counsel. I will instruct the witnesses to stop answering a question if a party objects. I will hear the objection and make a ruling on it. Depending upon my ruling, either I will instruct the witness to answer the question, or I will instruct the party not to answer the question and tell counsel to move on to the next question. If the witness answers before I give my ruling, and I sustain the objection, I may indicate that the answer is stricken from the record and instruct the counsel to disregard that response. After all parties have rested their case, we will then move on to closing arguments. A closing argument is a party's opportunity to tell the counsel why they should find in that party's favor. A closing argument may only refer to the exhibits entered into the record and the testimony given under oath. If any party refers to anything outside of the record, another party may object, or I may simply strike that part of the argument from the record, and again, which the counsel may not consider in making this decision. After parties... Yes, sir.
And again, it got garbled after that.
After which part, sir?
Simply strike that part of the argument from the record.
Yeah, if a party does mention anything outside the scope of the admitted exhibits or the testimony, I either may strike it from the record or another party may object, at which point the counsel may not consider that in rendering their decision. Did you hear that clear?
I do, yes.
Very good. After all parties have been given the chance to make closing arguments, we will adjourn the hearing and close the record. The parties will then have 1 week from the close of record to provide post-hearing briefs to the counsel. The deliberations regarding the outcome of this matter may begin as soon as we adjourn today and will not wait until the briefs are received or after the submission deadline. In addition, I will create a draft of proposed facts and a summation of the applicable law to the counsel following today's adjudication. but the council is under no obligation to ratify or accept my draft findings, and the council makes the final decision in this case. To use common parlance, the council is the jury in this matter, although they will take a more active role in questioning witnesses than are customarily understood in common law proceedings. It will be the council's decision to determine the weight given to the evidence, and by evidence I mean both the documents entered into the record and the sworn testimony. It will also be up to the council how to rectify any conflicts in the evidence and to determine the credibility of the witnesses. We will plan on taking a break today around noon after a logical stopping point of a party's presentation of the case. If it looks like we will not finish today, I would propose that we take a 30-minute lunch rather than an hour. That way we can finish up the process. We will take that discussion up when we get closer to that particular point. In addition, I do have the capability of setting up breakout rooms if the parties do request. If you are going to make that request, I would ask that you give me a few minutes to figure out the technological aspects of it, and we can set those up. Also, I would ask that parties refrain from using the chat function in today's proceedings, as it is neither picked up by the audio recording or by the court reporter. If there is an emergent situation, parties can simply use it. Use the chat function. I will repeat what's on the chat function for the record, but the better practice is simply to not use it unless absolutely necessary. So that is a brief summation of how the hearing is going to go. After I ask if there's any questions, I'm going to confirm with the parties, the council rather, what was received, and then we will segue into opening statements. So starting first with the parties, yes, Ms. Anderson.
Does Your Honor wish for us to turn our cameras on when we're doing direct and cross, or would you prefer us to leave the cameras off?
If we're holding a video hearing, the preference is for people to utilize it with the functionality. I'm not going to require it, but it would be better for them since we've all agreed this would be the method. So my preference would be yes. We keep the cameras on when we are participating, so I know you're present, but I'm not going to require it.
Thank you, Your Honor.
Okay. So, Ms. Anderson, any other questions about how we're going to conduct today's hearing?
No, sir.
Ms. Holt, any questions?
No, sir.
And Mr. Kroll, any questions?
No, Your Honor.
Chair Drew, any questions of the proceeding or the manner in which we can hold the proceeding today?
No, thank you.
Okay. And rather than go throughout the entirety of the council, if anyone on the council, sitting on the council, has any questions, please unmute yourself and go ahead and raise that question. Okay. Ms. Owen, can you please repeat back to me who is currently present on behalf of the council, so when I allow them to ask questions, I can logically scroll through the names?
Yes, absolutely. Chair Drew, of course. Elizabeth Osborne. Mike Livingston. Lenny Young. Stacy Brewster. Dave Sharp. And Paul Gonsath.
Thank you. All right. Last week, we conducted a pre-hearing or a second pre-hearing conference to pre-admit evidence, as well as to take any objection to the proposed witnesses. In that pre-hearing conference, I pre-admitted applicants' exhibits 2 through 6, 8 through 12, and 14 through 27. I would like to confirm with the council that they have all received those exhibits and not had access to or read anything outside the scope of those exhibits I just named. Chair Drew, did you receive and have you reviewed applicants' exhibits 2 through 6, 8 through 12, and 14 through 27?
Yes, I have.
And did you review or see anything else besides what was entered in the record on behalf of the applicant?
No, I have not.
Okay. I'm going to ask the same questions of all the parties. Mr. Osborne, same question for you for the applicant's materials.
It's Ms. and yes, I have. Thank you.
Sorry.
Not at all.
I knew that. I'm sorry. Please confirm your answer. Ms. Osborne.
Yes, answering in the affirmative.
Yes, you did receive them, review them. Did you
Yes.
Did you review anything else from the applicant's material besides those?
No.
Very good. And
Thank you.
Mr. Livingston, please also answer the question to both parts if you may.
Correct. Yes, Your Honor.
Yes, you did receive the material, or yes, you reviewed material outside the scope of what was admitted? I'm just making sure I know what you're answering yes to.
I apologize, Your Honor. I did receive the material, and I did not receive anything outside the record. Thank you.
Thank you. And Mr. Young, same question for you, sir.
Yeah, I have not reviewed the materials, and I did not receive and haven't seen anything outside the record.
Okay. Although you didn't review it, have you been made available to you to review?
Yes.
Okay. And Ms. Brewster, same question.
Yes, I did receive and review the materials. I have not reviewed anything outside of the record.
Very good. And Mr. Sharp?
Yes, I have received and reviewed the materials. And the second question, some of the exhibits referenced back to the application, and I went back to that part of the application in several instances to look at what they said.
Okay. The application is the foundational document, so I don't have any concerns with that. I'm more concerned about anything else beyond the application that was not reviewed.
No.
Very good. Mr. Gonseth, same question for you, sir.
I have received the materials, reviewed them, and I have not reviewed anything outside what has been submitted.
Okay. In addition, I did enter Benton County's Exhibits A through E in their entirety. I'm going to ask the same question in both parts. Did you receive, review it, and did you review anything else outside of the scope of that? Chair Drew?
Yes, I did receive those exhibits. I did not review anything outside of those exhibits. I did ask our staff to separate the exhibits in our list so we could easily access them because they were combined into one list. So that's now what's available online for the information of the council members. It made it a little difficult to separate out the different exhibits as we looked at them. So,
okay.
But I did not review anything outside of that.
Thank you, Chair Drew. Ms. Osborne, same question for you on Benton Counties.
Yes, Your Honor, I received and reviewed those exhibits and have not seen anything outside of what's been submitted.
Mr. Livingston?
I have received and reviewed all the exhibits, and I have not reviewed anything outside of those. Thank you.
Mr. Young?
I have received all the materials. I have not reviewed them, and I have not reviewed anything outside the record.
Ms. Brewster?
I have received and reviewed those exhibits. I have not reviewed anything outside of what was submitted.
Thank you. Mr. Sharp?
I have reviewed and have received and reviewed the exhibits and have not reviewed anything else.
And finally, Mr. Gonseth?
I have received the exhibits and reviewed them. I have not reviewed anything outside the exhibits.
And lastly, for the Council for the Environment, they did not submit any exhibits for consideration. I just need to confirm with the Council. They did not receive anything from the Council for the Environment. Chair Drew, can you confirm it did not receive anything from the Council for the Environment for today's adjudication?
I did not.
Thank you. I'm going to go around last parts of the Council with the same question. Ms. Osborne?
I did not.
Mr. Livingston?
No, I did not.
Mr. Young?
I have not reviewed anything from Council of the Environment.
Thank you. Ms. Brewster?
No, I haven't received anything.
Mr. Sharp?
No, I have not received anything.
And finally, Mr. Gonseth?
I also have not received anything.
Excellent. Okay. So with that, In addition to both the applicant and Benton County did submit pre-hearing briefs. Again, those are not substantive evidence. If the council members have not received those, they can reach out to their staff to get those to review after the proceedings. But let's go ahead and segue into the opening statements. So, as I said in my initial opening, we will begin with allowing the applicant to present an opening statement, no more than 5 minutes if they choose to do so. So, with that, Ms. Anderson, do you wish to make an opening statement on behalf of the applicant, Wautoma Solar?
Yes, sir.
And please begin.
Good morning, Your Honor, Madam Chair, and council members. Can you hear me okay?
You're a little soft-spoken, but we can hear you okay. Yes.
I'll try to speak louder. Thank you for that.
Thank you.
My name is Erin Anderson. My colleague Andrew Lewis and I represent the applicant, Interjax Renewable Development USA, in this matter. There is only one topic before the council today, and that is land use. The reason we're here discussing land use is because the Wautoma Solar Energy Project is inconsistent with the Benton County Code provision 11.17.040 and Benton County Comprehensive Plan provisions. And when FSEC project is found to be inconsistent with local land use provisions, two questions arise. One is preemption, and two, what conditions can be put in a site certificate that recognize the preempted local land use provisions. Those two issues, preemption and conditions, are the only two issues for you to resolve here today. Unlike recent matters before you, there are no environmental impacts for the council to wrestle with here, because FSEC's SEPA responsible official has already issued a final mitigated determination of non-significance under the State Environmental Policy Act. Now, the council is familiar with Benton County and its Growth Management Act Agricultural District, or GMAD, zone from a recent project proposal. When that prior matter was before you, both wind and solar nature were allowed uses in the GMAD zone with the conditional use permit under Benton County Code 11.17040. However, Benton County has altered its land use code since you last saw them. Today, those uses have been removed from the Benton County Code. Due to land use inconsistency, Interjax is asking that this council recommend the governor preempt the county's conflicting land use provisions to allow this important clean energy project to move forward. There is clean authority and precedent for FSEC to recommend preemption based on the court case of residents opposed to Kittitas turbines versus FSEC, or Rocket versus FSEC. As in this case, Kittitas County conducts its planning and zoning under the Growth Management Act. In an effort to thwart the siting of a wind facility there, Kittitas County adopted zoning ordinance that precluded the Kittitas Valley Wind Project. However, FSEC implemented the policies of RCW 8050-010 by recommending preemption and proposed conditions in the site certification agreement to recognize the preempted regulations. On appeal, Kittitas County argued that the Growth Management Act takes precedence over FSLA and therefore preemption was not allowed. In a unanimous 9-0 decision, the Washington Supreme Court rejected the county's argument and expressly found that FSLA takes precedence in the face of a contrary planning and zoning provision under the Growth Management Act. This remains the law today. Tellingly, Benton County's brief does not address this holding in Rocket versus FSEC, and instead, like Kittitas County, it insists that the Growth Management Act and indirectly Benton County can unilaterally thwart statewide energy policy. This it cannot and frankly should not do. Now, moving on from issue 1, preemption, to issue 2, what conditions can be imposed in the SCA, the council is going to hear ample evidence about what those conditions are. Both the applicant and participating landowner representatives, one of whose land has been in his family for over 100 years, will testify how those conditions will not only render this project compatible with the GMAD and comprehensive plan, but also how this project is in fact supportive of their ability to continue in the business of agriculture. Their testimony will show you why this project is well sited at this precise location, and how the conditions for the site certification also satisfy all of the conditional use permit criteria that would have applied had Benton County not banned major solar in the GMAD zone. In fact, Benton County, in its own brief, agreed to the applicant that if the council should recommend preemption, those are the conditions that should be imposed here. In sum, EFSLA commends reducing our dependence on fossil fuels and recognizes the pressing need for more clean energy facilities. There are no environmental issues to balance the project against due to the SEPA and DNS. The applicant and EFSAC's own staff have developed robust conditions that serve to address local regulations. The county agrees that these are the correct conditions should you preempt, and for these reasons the council can be confident in recommending that the governor preempt and approve the Wautoma solar energy project subject to that rigorous set of conditions, which will recognize not only preempted local regulations, but will also give effect to the mission of EFSAC, which is to site energy facilities. Thank you.
Thank you, Ms. Anderson. Ms. Holt, do you wish to make an opening statement on behalf of Benton County?
Yes, sir. So I'm Leanne Holt. I'm counsel for Benton County. It's nice to meet you all. Today the council is faced with two primary questions. First, should it recommend to the governor that he should preempt state and local use regulations? To recommend preemption, the council is required to create a draft certification agreement that contains conditions that protect state, local, and community interests, which will be affected by the project, as well as conditions designed to recognize the purpose of the laws, rules, or regulations that are being preempted. As testimony will show, Benton County is a largely agricultural-based community with approximately 58% of its lands making up the Growth Management Act Agricultural District, or the GMAD district. The purpose of Benton County's GMAD code is to reflect the state and local interests in protecting a finite resource of agricultural lands. Lands where, once converted, are presumptively permanently converted. While applicant claims the project is compatible with agricultural uses, such claim mistakenly relies on criteria for conditional uses located in past versions of Benton County's code, which did not apply at the time of the application. The purported benefits to the leasing landowners, energy needs of the state, and potentially surrounding properties don't address the taking of the subject property itself out of agricultural lands for current and prospective production. In fact, applicant concedes in its application that it proposes no conditions which directly address the land use. You'll hear testimony on Benton County's position, which is that there are no feasible conditions that sufficiently protect its interest during the life of the project and potentially beyond, as the creation of new GMAD lands to make up for this potential loss is unlikely. If the standard set will be that no offset of the presumptive permanent loss of GMAD lands is necessary, then counties essentially lose the ability to preserve their own agricultural lands, the majority of Benton County's lands. One of the applicant's considerations when citing this project was the open nature afforded by agricultural lands, a consideration that's likely going to be attractive to other applicants. Lack of limitation could open the floodgates for private industries to consume bite by bite Washington agricultural lands with no upper limit. The decision the council makes today on this issue will have a lasting future effects on all counties' abilities to protect their interests, and we ask the council to recommend against preemption. If the council disagrees with Benton County's position, the second question is what conditions the council should impose on the project. As I already stated, Benton County's position is there are no conditions proposed at this point that make up for the loss of land use. However, the applicant has agreed to follow the environmental conditions set forth in the revised MDMS and Table A5 of their application. And to the extent that those are agreed, Benton County would ask that those be imposed. because that will at least increase the possibility that one day the lands could be suitable again for agricultural use. Thank you.
Thank you, Ms. Holt. Mr. Kroll, do you wish to make an opening statement on behalf of Council for the Environment?
No, Your Honor. Thank you.
Then with that, let's go ahead and begin with the applicant's case in chief. Ms. Anderson, please call your first witness.
Thank you, Your Honor. My first witness is Laura O'Neill.
Ms. O'Neill, are you present? If so, go ahead and take yourself off mute. And if you have video capability, go ahead and turn it on, please.
Yes, Laura O'Neill for the applicant present.
Do you have the video capabilities? And if so, can you turn it on?
It looks to me like my video capability is on. Can you not see me?
I personally can't. If someone else can see it, it may just be something on my end.
Yeah, I see.
Yeah, this is Councilmember Livingston. I can see her. She's on the next screen over in the Teams.
Thank you, sir. I see it now. I appreciate the direction. Okay, very good. Ms. O'Neill, have you been present throughout the explanation of the process?
Yes, I have.
Okay. I'm going to repeat just briefly. Speak loudly and clearly. No head nods, no ahs or ahs. Yes or no's, if you can, in full articulation. We are only recording the audio portion, not the video. If today you cannot hear or understand when someone is asking you a question, please let me know, and I'll have them repeat the question. In addition, if you hear any of the parties say object, please stop your answer at that point so I can rule on the objection without having to get the answer potentially on the record. Any questions?
Thank you. Understood. Thank you.
And I'm going to swear you in as a witness. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, and the penalty of perjury?
I do.
You are under oath. Ms. Anderson, please begin.
Thank you, Your Honor. Ms. O'Neill, would you please state your name and occupation for the record?
Yes, my name is Laura O'Neill, and I'm an environmental manager.
And who do you work for?
I'm employed by a company called Interjex Renewable Energy. We operate exclusively in renewables. We develop, own, and operate 88 clean energy facilities within the United States, Canada, France, and Chile, with many more projects in development.
What can you tell me about Interjex's values and approach to business?
Well, we are exclusively a clean energy company, only hydro, wind, and solar facilities. And we principally hold and operate our own facilities. In this way, whichever agency or jurisdiction cites a project knows who it will be dealing with.
Just a moment. Ms. O'Neill, something's going on with your audio. You faded in and out from when you initially joined. Can you speak up, or if there's a speaker getting closer to you so we can hear you clearly?
Sure. I see the speaker inching closer, so I will also try and speak up.
Thank you.
Okay. And would you please describe your professional experience?
Sure. I've worked in the renewables business since 2008, beginning my career as an environmental coordinator. In this role, I was doing regulatory assessments for operational projects, developing permit applications for our construction and operational projects. This work evolved into working with landowners, stakeholders, agencies, indigenous groups, and consultants through the project development process, as well as coordinating the environmental assessments and major permitting efforts for our development projects within Western Canada and the U.S. Pacific Northwest.
Okay, and Ms. O'Neill, what is the purpose of your testimony today?
I'm here to support the Wautoma Solar Energy Project's approval process. I will describe the project, the application for site certification, and why the project is well sited in this location so that the council can recommend approval with preemption of local land use provisions, confident that it can include conditions that will ensure that this facility reflects those community interests and remains consistent with the purposes of those local land use provisions being preempted.
Are you able to answer questions under cross-examination today?
Yes, I am.
Okay, Ms. O'Neill, how would you describe your work on the Wautoma project specifically?
To date, I've led the environmental assessment and siting of the project with FSEC, and I will continue to be responsible for ensuring that the development occurs in accordance with all the requirements and conditions imposed upon it.
You mentioned the application for site certification. What was your role in preparation of the site certification application?
I oversaw the application and sponsored its preparation.
Did you alone prepare the ASC?
No, it's, as you've seen, it's quite voluminous, covers many subjects in great detail. We used a company called Tetra Tech, an environmental consulting firm with numerous experts across multiple disciplines, to prepare the various parts and put it all together.
Who did you principally work with on the ASC and how?
Tetra Tech's project manager was Linnea Fossum. Ms. Fossum and I worked together closely and with their various subject matter experts to develop and author each section of the ASC. We worked closely with a land use planner and environmental planner at Tetra Tech named Leslie McLean, who provided senior review of Attachment D to the ASC, which addresses land use consistency. Ms. McLean will testify later in greater detail about land use issues.
So what is included in an application for site certification?
Just a moment. Hold on. I'm sorry, Ms. Anderson, you're very, very faint. I want to make sure that the council hears the question so they can put it in context of the answer. Can you speak up and repeat the question, please?
Yes, I will. What is included in the application for site certification?
At a high level, the sections address all requirements of Washington's Energy Facility Site Location Act, or EFSLA, all those laws and regulations and how the project complies with them, and also why the county should preempt Benton County's ban on major solar facilities in the GMAD zone. In addition to the main body, it also contains 19 attachments.
Ms. O'Neill, you referenced the Energy Facility Site Location Act. And this is EFSLA, which is referred to as Revised Code of Washington 8050. Is that correct?
Correct.
Okay, I realize I'm likely to use a lot of acronyms today. Are you comfortable with me using acronyms such as SEPA for the State Environmental Policy Act, ASC for the application, FSEC or Council for the Energy Facility Site Evaluation Council, and so on?
Yes, I am.
Okay. Regarding whether to recommend approval of the application for site certification, you are aware that the only topic before the council in this adjudication is land use, namely, A, whether the governor should preempt local laws inconsistent with EFSLA, and B, what conditions can be placed in the SCA to reflect the purpose of local land use provisions that are preempted. Is that correct?
Yes, it is.
Okay. And when was your application for site certification received at EFSEC?
That was in June of 2022, as can be seen on the website.
And has that ASC been updated since then? And if so, why?
It has been updated. Revisions were made.
Speak up, Ms. O'Neill, please.
Sure. It was revised because FSEC regulations require that an updated ASC be filed with FSEC before this adjudicative hearing in order to show additions and edits that were made to the application in response to FSEC questions and input from other stakeholders such as Yakima Nation and other agencies.
Do you know when that updated ASC was filed?
Yes, that was on August 23rd of this year.
All right. Your Honor and Ms. O'Neill and Council, I'm going to have what is marked for identification as Applicant Exhibit 2 put up on the screen. My colleague, Mr. Lewis, will put that up in the share screen. Please let me know when you can see that.
And Your Honor, I'm sharing Exhibit.
Exhibit 2, is that correct, Mr. Lewis? Mr. Lewis, you've now overlaid the screen with the participants on there. Would you please remove that from that specific screen? All right. Ms. Anderson, we can see the document. If you wish to continue, or if you want to wait for Mr. Lewis to do whatever he's doing, we can do that as well.
I can see the document. I'm ready to proceed. Ms. O'Neill, can you identify what this document is for me?
Yes, it is the revised application for site certification. Now, my understanding is due to technical issues, one of the attachments.
O'Neill, I really need you to speak up and be consistent with it. I'm not sure why there's an ebb and flow with the volume.
Okay. This is the most current revised application for site certification. I understand that due to technical issues, one of the attachments to the revised ASC was not able to be incorporated within that exhibit.
And Your Honor, if I have Mr. Lewis put up applicant's Exhibit 3 on the screen, I would ask Ms. O'Neill to identify it once it appears.
Yes, that is the exhibit that could not be combined electronically, and together Exhibits 2 and 3 comprise the current revised ASC.
And are you sponsoring the Wautoma Solar Energy Facility as presented in the ASC marked as Exhibits 2 and 3?
Yes, I am.
Your Honor, if you would like me to move to admit exhibits, I'm happy to do so and would do so now.
They've already been admitted. That was the purpose of the pre-hearing conference last week.
Very good. Ms. O'Neill, are you expressly asking that the FSEC Siting Council recommend that the Governor preempt and approve the project with conditions that will be discussed later in your testimony to ensure that the project is consistent with Benton County land use plans that would be preempted?
Yes, I am.
Very good. Would you please give the Council a brief overview of the Wautoma Solar Energy Project?
Certainly. The project is a 470 megawatt solar photovoltaic energy generation facility with a 4-hour battery energy storage system.
Ms. O'Neill, can you speak please to the volume, please? Again,
yeah.
Thank you. And Mr. Lewis, would you take down the exhibit if we're not going to reference it at this point? Thank you, sir. If you go ahead and pick up from the beginning, please, so we can all hear you clearly.
Sure. The project is a 470 megawatt solar photovoltaic energy generation facility with a 4-hour battery energy storage system. The PV system will consist of a series of solar panels mounted on a solar tracker racking system aligned in what we call arrays. The system includes the solar panels, the racking system that rests upon posts set in the ground, buried collector lines, and power conversion systems. The batteries can either store energy for future use or move power directly onto the grid. The project also includes a substation to increase the voltage from the collector lines to a level suitable for the grid, a short overhead 500 kilovolt generation tie transmission line, an operations and maintenance building, project access roads, and the perimeter fencing.
What are the general location and parameters of where this project is proposed for siting?
It's located in a rural, sparsely populated area. It's about 12.5 miles northeast of the city of Sunnyside and 1 mile south of the state route 241 and 24 interchange within unincorporated Benton County, Washington.
And how many acres are involved in the Wautoma project?
Intergex has leased 5,852 acres of land that is owned or controlled principally by two families, the Robert family and the Keeler family, representatives of which are testifying today. However, this number is not the final number of acres that will be involved. The way solar siting is done, once the general area is identified, leases are entered into so we can access the site and assess it in more detail. Those 852 acres that were initially leased gave us the ability to conduct studies to identify the most suitable footprint within and what areas to avoid. The preliminary studies led us to narrow in on a smaller area. We've called that the official project area, which is smaller at 4,573 acres. And within the project area itself, only 2,978 acres will be fenced in and therefore unavailable for agricultural use during the operational term of the project. So once the facility is built, we revise the leases to reflect the smaller number of acres actually used. So the unused acres will no longer be encumbered by the leases. I wanted to note that Benton County, in its opening brief, mistakenly used the initial lease figure of 5,852 acres. The area unavailable for ag use during the life of the project is actually only about half of that amount, given the steps I just described to eliminate development in the unsuitable areas within the larger leased area. I'll also note that the combined holdings of the two families in this area are over 12,000 acres, and over 9,000 acres will still be available to the landowners for continued ag use adjacent to the project.
Thank you. So what surrounds this project site?
As noted, Highway 24 is to the north. Steep slopes up to Rattlesnake Ridge lie to the south. To the east is the Hanford Nuclear Reservation, and Highway 241 is to the west.
Will this project feature hilly ground or prominent elevated geologic features?
It will not. It will be constructed on relatively flat terrain with average slopes of less than 3%, and there are no prominent elevated geologic features or tall vertical features.
What about wetlands?
No wetland disturbance. It's a very arid part of the county.
Oh, pardon me.
So did the presence...
This is the court reporter. I didn't hear. It's a very...
Arid or dry?
Oh, was there more to the sentence? I didn't hear any of it.
The full sentence was, this is a very arid part of the county.
Thank you so much.
Yeah.
Thank you, Ms. O'Neill. Did the presence or absence of such features inform how this site was chosen?
Yes. We did examine the county's critical areas ordinance and design the project to avoid these areas, such as steep slopes, wetlands, and the like. These areas will continue to be protected throughout the project layout, as well as through the conditions we have imposed upon the project ourselves. This is found in Section A5 of the ASC, which can be referenced on pages 27 to 38. This contains the mitigation measures that we proposed in the application. FSEC has also recommended additional measures in the MD&S based on their consultation with various natural resource agencies.
Ms. O'Neill and Your Honor, if I have Exhibit 2 put back up on the screen and turn to page 27 of the ASC, is this the Section A5 of your application that you are referencing?
That's correct.
And you are asking the council to apply these measures as conditions in the SCA?
Correct.
Okay. We can take that exhibit down. Can more information about critical areas be found in the ASC?
Yes, it can be found. In fact, the county's critical areas regulations are referenced 68 times within the ASC.
And does the ASC speak to decommissioning?
It does. That is part of the proposal. In addition to the preliminary decommissioning plan in the ASC, we will have to submit a more detailed site restoration plan to FSEC prior to the start of construction.
So if this project is approved, will Interjex restore the site to the substantially same agricultural condition that it existed prior to the project?
Yes, we will. During the review process, FSEC solicited agency, tribal, and stakeholder comments. One agency that commented was the Washington Department of Agriculture, which focuses exclusively on agricultural issues. They commented to FSEC about potential effects the project could have on the land beneath it and whether that could be restored to a condition that could be made available for agricultural purposes. So in response to that comment, FSEC required us to prepare a draft soil monitoring plan addressing those concerns, which was shared with the Department of Ag. Additionally, in the decommissioning plan, we decommissioned the facility to a level below ground, which will require restoring the soil. We also have to post a security bond that will ensure that decommissioning and restoration are performed so the land is returned to a condition available for ag use at the end of the facility's life. These conditions are on top of measures already discussed built into Section 85. These include other measures to protect soil and groundwater, including spill prevention, control, and countermeasure plans, requirements for the use of EPA and Department of Ag approved herbicides, as well as primary and secondary spill containment measures.
Now, you heard and you understand that the county has taken the position that the ASC does not contain any conditions related to land use. Did you hear that this morning?
I really can't hear you particularly clearly. I'm really struggling to hear, so please be mindful when you're speaking to speak very loudly, even if it sounds like you're speaking louder than normal.
Very good. You understand, Ms. O'Neill, that the county has taken the position that the ASC does not contain any conditions related to land use.
I did read that and hear it in the opening statement. However, I wanted to clarify that while mitigation measures related to land use were not expressly categorized in that way in the ASC, there are numerous measures proposed throughout under other topic headings that do mitigate land use impacts. In addition, FSEC has identified these and other mitigation measures in the MD&S under the category titled Land and Shoreline Use.
All right, Your Honor, Ms. O'Neill and Counsel, I'm going to have what is marked as Exhibit 16 on the screen. Would you please identify this for me?
Is that one,
yes, this is...
You broke up. Is that 1-6 or 6?
1-6.
Thank you. Please continue.
Yes, I can identify this as the revised MD&S for the project, which was issued in June of this year. It is FSEC staff's final revised set of conditions that it recommends the council place on our project if it is going to recommend approval. And again, these conditions are in addition to those in the application at Section A5.
What is an MD&S?
In short, it's the staff's final determination that the project's impacts on the environment will not be significant if the conditions contained in it are imposed on the project.
And does this MD&S address impact to agricultural soils, agricultural land uses, and the like?
It does.
Now, I recognize you didn't testify that you are a land planner. However, can you identify examples of how the MD&S conditions promote land use consistency with the GMAD district?
Yes, I can. If we could scroll through the document.
Are you referring to Exhibit 16?
Correct.
We'll have that put back up on the screen.
Okay, so we see on page 2, there's a condition prohibiting soil disturbance following major.
Please speak up, ma'am.
Okay. Yeah, on page 2, we see a condition prohibiting soil disturbance following major precipitation events to limit soil erosion. Also on page 2, there are reduced speed limits. This will reduce dust emissions and soil loss, also helping to avoid conflicts with agricultural equipment. These slow speeds will also help to minimize interaction with other vehicles. For example, schools and churches are allowed in the GMAD zone, which can draw a lot of traffic. While there are no schools or churches currently in the area, these are preventative measures to ensure consistency in the future.
Any more examples that you would call out?
Sure. Again, not a land use planner, but I can call out on page 4. Yes, the vegetation and weed management plan will prevent proliferation of weeds that could otherwise interfere with crops grown in the area. So I think I've addressed the significant soil monitoring and restoration conditions.
Well, how can the Robert and Keeler families, and for that matter Benton County, be sure that Interjex will restore this site?
Thanks for asking. FSEC doesn't simply take our word for it. FSEC has the authority to establish those conditions to ensure we comply with restoration. The MD&S contains a stringent set of conditions related to decommissioning and soil restoration that should be placed in the SCA if the project is recommended for approval. Those conditions include periodic soil monitoring through the life of the project, monitoring for compaction, topsoil depth, water holding capability, organic carbon content, organic matter, nutrient content, pH levels, productivity, and soil structure.
So if the council recommends approval of the project subject to all of these MD&S conditions, would Interjex be done with the project once it has performed all the decommissioning and soil restoration?
No. In fact, you can see on page 4 under restoration plan, the MD&S, are we there yet? Okay. The MD&S here requires that Interjex do 5 years of post-restoration monitoring to ensure that the measures taken were effective.
And Interjex agrees that the council should impose all of these conditions in the SCA?
We do.
Very good. Ms. O'Neill, do you know if these conditions are less, equal to, or more robust than soil monitoring and restoration found in MD&Ss for other solar projects FSEC has approved in Washington?
They are actually more robust. I reviewed SEPA conditions developed by FSEC for other approved solar projects, such as High Top in Austria and Goose Prairie Solar in Yakima County. The conditions proposed for Wautoma are far more comprehensive and longer in duration. It's clear to us that FSEC takes this topic very seriously. They asked for lots of information and then crafted comprehensive conditions to address the agricultural nature of the land, and they included those provisions to hold us to account not only during construction, operations, and decommissioning, but for that 5-year period thereafter.
Now, before the revised final MD&S was issued, was the first draft of the MD&S issued by FSEC?
Yes, it was. That contained 15 pages of information and draft conditions over a range of topics.
All right, Your Honor, Counselor Ms. O'Neill, I'm going to have put up on the screen Interjex Exhibit 14. Can you see that, Ms. O'Neill?
Yes, I can.
Does this document include directions that tell people how to comment on it if they have concerns about it?
Yes, it does.
Thank you. Beyond distributing the initial draft of the MD&S, did FSEC staff explain its analysis and how it arrived at the conditions it was inviting comment on?
Yes. At the same time, they issued a SEPA staff memo, which explains the staff's thinking on why the measures were proposed.
All right. I'm going to show you and the Council and Your Honor, Interjex Exhibit 15. Is this the staff memo?
Yes, it is.
All right. I'm going to move on to this specific project. Why did Interjex choose this state for its solar and battery facility?
There were multiple reasons. First, EFSLA, the Energy Facility Site Location Act. This act itself focuses on the need to reduce dependence on fossil fuels.
Ms. O'Neill, you just cut out that last part of the testimony. Need you to repeat, please?
Okay, so the other state policies, including CETA, the Climate Commitment Act, and the Energy Independence Act, all are driving a rapid transformation to non-carbon emitting electricity. These state laws reflect that Washington consumers have been demanding clean energy for years. We see this by many requests for proposals put out by various utilities over the last 2 decades, seeking more and more clean energy.
So when did Interjects first focus on this site in Benton County?
That was in 2020.
And
why? Again, a variety of reasons. First, Benton County has a clear, sunny climate that allows generation of lots of solar electricity. Also, we have landowners willing to lease some of their land and water to us while being able to remain in the business of agriculture on lands we have not leased. The site is sparsely populated with very few residents surrounding. It is also flat and does not feature prominently on the landscape. However, the site is large enough that we can site the arrays far back from the property boundaries, minimizing visual effects, as well as avoiding those critical areas and also providing for wildlife movement through the site. There are also relatively close substations to the project, which means shorter transmission lines to get the power to the grid.
You mentioned leasing water. What are the project's needs for water during construction and operations?
The project will require a small amount of water during construction and for cleaning panels during operation. It was important to us that we avoid bringing water in by truck if possible to minimize traffic and associated emissions and dust related to those truck trips. The landowners here, the Keelers and Robert family, have 4 separate water rights covering their collective acreage. They're going to make a small amount of us available to the project. They're in the process of modifying their own rights to reflect their future ag activities and changed ownership structure.
Can you explain a little bit more what you mean?
Yes. So it's my understanding that originally the Robert family held approximately 12,000 acres. As the land was passed down through generations and through the sale of some of it to the Keeler family, the ownership is now in 2 blocks, Robert Ranch and the Keeler family. And amongst that land are 4 water rights. So the 2 families need to realign those rights so that certain amounts are apportioned to the individual owners. Now, all of this water is drawn from a single aquifer, which has been declining for decades. The Robert Ranch family is actually planning to invest some of the revenue from our solar leases into changing its ranch operations from a focus on the less profitable but more water-hungry crop production to focus on a more profitable and less water-demanding livestock operation. Similarly, the Keelers are changing their ag operations to focus their water use on their viticulture operations, which has a plan for expansion. So in this process, both families are willing to assign the small portion of water we need for the project to the land leased. As a result of this overall water strategy, once the changes are complete, there will be less water used between the Keelers, Robert Ranch, and the project, less than what is used today to irrigate crops, which are not terribly profitable. This will also allow some of the water to remain in a trust administered through the Department of Ecology. It's my understanding that because water will go into trust and go unused until a future date when it is needed, this could help the aquifer recharge. So, in summary, our project will generate an additional stream of income for the landowners and at the same time enable them to use the water more responsibly by reducing overall usage, putting some into trust, giving relief to the aquifer, and allowing the landowners to expand their agricultural activities.
Thank you for that fulsome explanation. What else made Benton County and this site attractive to Interjects?
Well, it's important to note that in 2020, when we began investigating this project, the Benton County Code did allow commercial solar with a conditional use permit in the GMAD zone, which is where this project is proposed. It is only since December of 2021 that facilities such as this became prohibited.
Now, did Interjex go about engaging with the county for this proposal? And if you did, tell me how.
We did. In summer 2021, we reached out to both the county planning department and its board of county commissioners, as well as to FSEC. We sought to introduce the company and the proposed project and wanted to talk with them about their respective permitting processes. At this time, we also reached out to other surrounding stakeholders.
All right, Your Honor, Counsel Ms. O'Neill, I'm going to have Interjex Exhibit 4 put up on the screen. Would you please identify this for me, Ms. O'Neill?
Sure. This is our pre-application outreach log. We use this to track who we reach out to, responses received, how to follow up on tasks, all to ensure robust engagement with the community. As an example, on page 1, the first line in green, we did reach out to Benton County. Also, the first line in blue, we reached out to the Warm Springs tribe, as an example. The list continues covering various parties, county officials, state legislators, tribes, landowners, the local farm bureau, and so on.
Okay. Now, I noted in the fourth row there's an entry on July 21, 2021, titled LO''N. Is that you?
That is me. This line refers to outreach I initiated to the Benton County Community Development Director, Greg Wendt.
Why did you want to speak with Mr. Wendt?
As mentioned, I wanted to discuss permitting options, also explain what was going on with the site in terms of agriculture, how we would obtain water rights, how micrositing is done to reduce amounts of land used within the larger leased area, how we had incorporated county codes, including the critical areas ordinance, into our design. In short, to make an introduction to the company, to the solar facility in general, and describe the project, and also to answer any questions the county might have.
Did Mr. Wendt respond to your outreach?
He did not.
Tell me about engagement that Interjex undertook with various communities and stakeholders.
Well, in addition to what's shown in the log, in general, we try to provide the public at large with good online access to current information through our website, which has a dedicated page to this project.
Did you reach out to Native American tribes?
Yes, we did reach out to all tribes identified by the Department of Archaeological and Historic Preservation as tribes with interest in the area. Throughout the application process, FSEC works as the liaison between tribes and DAP regarding tribal interests on the project. I will note that DAP has concurred with the measures in our proposal, and we will continue to engage with interested tribes pursuant to the MD&S conditions, calling for ongoing tribal engagement.
Did Interjex reach out to any underrepresented communities or other stakeholders?
Yes, we've held multiple live and virtual community meetings. We send routine updates to neighboring property owners. Through that, we've advertised in Spanish about the open house, and also on the website there's a link that can convert materials automatically from English to Spanish. So members of the Spanish-speaking community will have access to the same information as in English.
Now, at some point, Benton County removed solar generation.
Ms. Anderson, I need you to speak up and repeat the question, please. Again, I'm not sure why it keeps up and down with it.
All right. At some some point, Benton County removed solar generation facility major from the uses allowed in the GMAT zone, correct?
That is correct. That was on December 21st, 2021. The Board of Commissioners adopted Ordinance Amendment 2021-004, which, among other changes, removed wind power generation facility major and solar power generation facility major from the list of uses allowable with a conditional use permit in the GMAT zone.
Since passage of that ordinance, have you learned anything further about the then or current Board of County Commission members' opinions of this project?
Yes, I've both read their comments in the minutes of that December 2021 public hearing and also read comments in the newspaper. Nothing I read indicated that it was this specific project that was driving the legislation. In fact, I had the impression they viewed Wautoma as a good project in this location. It was my impression that opposition to a different proposal led the county to ban future clean energy projects.
All right, Ms. O'Neill, Your Honor and Counsel, I'm going to have put on the screen Interjects Exhibit 11. Can you see that, Ms. O'Neill?
Yes, I can. It is the minutes of that December 2021 public hearing at which they revised their code.
So if you look at Exhibit 6 and we turn to the recounting of the minutes, what did any of the commissioners say about siting of solar in Benton County?
If we could scroll to page 6. We can see on page 6, we can see Commissioner McKay stated that solar is less of an eyesore than wind farms. In bringing this up specifically and comparing the two suggests to me that commissioners were concerned with the visual effects of wind energy. This is consistent with what I read in a newspaper interview with then Commissioner Small, who commented there that he actually supports Interjects' proposal to place solar panels in a remote part of the county.
Ms. O'Neill, Your Honor, Counsel, I'm going to put up Interjects Exhibit 27. Ms. O'Neill, can you see that?
Yes, that is the article I referred to in which Commissioner Small commented favorably on the project.
Where is that in that exhibit, if you can tell?
This is on page 4, and I understand that the county has not decided to take up any examination of where solar might be sited in the county, despite comments to the contrary. But in this article, Commissioner Small's reference to the Horse Heaven project continues to suggest to me that the elected officials of Benton County were more concerned about locating wind in Benton County rather than solar.
Thank you. Did you stop trying to engage with the county after it ended its role as the permitting agency for major solar in Benton County?
No, we continued outreach with the county. We invited the county and the surrounding community to a virtual open house presentation in April 2022, which was during the pandemic. This meeting was attended by the Benton County Planning Department staff, and we also made a presentation to the Board of County Commissioners about the project in May 2022.
Your Honor, Counsel, Ms. O'Neill, I'm going to put up Interjects Exhibit 17. Can you see that?
Yes, I can. This is the minutes from the meeting in May 2022 when we presented to the county.
What did you learn from the commissioners about the county's view of your project from this meeting?
Okay, so we see on page 3 where we have completed the presentation, you can see that Chairman Small said he was in favor of solar since it had far less impacts than the windmills. Commissioner McKay said that he liked that this project was out in no man's land and had low visibility.
Now, it is true the county has not changed its zoning code, notwithstanding these comments.
That is true.
Okay. So why did you present to the county even though FSEC was reviewing the project?
Well, even though the county had relinquished its authority to approve projects like this, we wanted them to know about how and where we had designed the project to minimize impacts to ag uses and, in fact, even enhance them. The project can and will coexist with and be supportive of agricultural interests in the area. We wanted to reassure the county of these features and benefits of the project.
Thank you. You mentioned earlier that Interjex has designed the project to comply with the provisions of the Benton County Land Use Code and Comp Plan, and today it meets those zoning provisions except for the single subsection that eliminated this use in the GMAD zone with a conditional use permit. That's correct?
It is, and don't misunderstand, I'm not a land use planner, and you'll hear from Ms. McLean later who will answer more detailed questions. But yes, the ASC acknowledges that we are not consistent with subsection 11.17.040 of the Benton County Code. However, we can see in attachment D of the ASC, there's a lot of detail about ways the project is both compatible with agricultural activities and supportive of them. As I understand it, the Benton County Comprehensive Plan envisions uses that are compatible or supportive of agriculture in its agricultural zones. This project is supportive of agriculture. It will help support the landowner's ability to continue with ag practices and conserve water in this era of a depleting water supply. We're confident that FSEC staff has recommended comprehensive conditions that, if placed in the SCA, will recognize the purpose of the code provision that we are requesting for preemption.
And was a land use consistency hearing held on your application?
Yes, that was in August 2022, the same night as the Council's public informational hearing on the project, and both events were held at the Community College in Pasco.
Did the Council enter an order to the effect that the land use was inconsistent and therefore a hearing would be held to consider conditions that could reflect any preempted local regulations?
Yes, that order was issued on November 16th, 2022, and that's really why we're here today, to assess the conditions that could reflect the county and community's interest in the GMAD zone should preemption be recommended.
So once the order on land use consistency was issued, how did FSEC go about reviewing your application?
We received many questions from FSEC staff, including several written data requests that we responded to, and FSEC saw input from other agencies also.
Did you engage with other agencies yourself about review of the ASC?
Yes, several times we spoke with WDFW about potential wildlife and habitat impacts, design changes in response to their input, and mitigation measures to minimize impacts. As shown in the MD&S, there are mitigation ratios for habitat impacts, and those reflect our discussions with WDFW. We also worked extensively with FSEC and DAP about tribal interests. However, I will limit my comments about engagement with DAP out of respect for the fact that tribes are sovereign nations and much of the information about tribal interests is confidential.
Thank you for that. But to clarify, DAP has concurred with your classification of identified cultural resources and approach to avoidance buffers proposed by Interjex on those resources, correct?
They have. The letter of concurrence was provided on May 17th of this year.
And was it after DAP's concurrence that FSEC staff issued its initial SEPA determination that if the council imposed the conditions as recommended, the project would not have a significant adverse environmental impact under SEPA?
That's correct.
Had you talked previously with FSEC staff about conditions that might be recommended on this project?
Yes. As mentioned earlier, Section A5 of the ASC.
No, please speak up, Ms. O'Neill. Again, I can't hear you. Thank you.
Okay. As mentioned earlier, at Section A5 of the ASC contains a long list of measures proposed as part of the project to minimize and prevent environmental and land use impacts. So the discussion started there with FSEC staff.
But did the MDNS add additional conditions on top of the conditions that you proposed in Section A5?
Yes, it certainly does. The staff doesn't just include the conditions from the ASC and issue a determination of non-significance. They added mitigated conditions to address items raised by staff as well as others during the 2-year review period for this proposal.
Interjex is willing to accept all of those additional conditions put forth by FSEC staff, correct?
Correct.
And does this specifically include all of the measures to reduce impacts on adjacent ag landowners, like weed control, slow speeds to manage dust, and visual screening?
Correct.
And does this include all of the requirements related to ensuring the project land is returned to a condition that will allow ag uses at the end of the project life?
Yes, it does.
All right, just a few miscellaneous questions. Ms. O'Neill, does your ASC ask FSEC to approve any project other than your own?
No, we're not asking for approval of anything other than this Wautoma proposal, and we expect that this project be evaluated on its own merits.
Do you have any reason to think that this council is planning to use your project in order to set the stage for any other project's approval?
No, I don't.
And did the FSEC staff ignore the potential for cumulative impacts in Benton County's GMAD zone that could possibly result from other potential projects?
No, they addressed it head on in the staff memo.
I'm going to ask you to pause there. Council, Your Honor, I'm going to put back up on the screen Exhibit 15 and turn to page 31. Ms. O'Neill, you can proceed.
Okay.
And speak up, please.
Okay. Here, you can see that they have acknowledged that future projects, when combined with Wautoma, could have cumulative impacts. FSEC staff stated that for any future projects in close proximity to the project area, FSEC will consider whether the cumulative impacts from those projects, when combined with the Wautoma project, could be reduced through mitigation.
Ms. O'Neill, do you have any reason to believe that FSEC will not do what they say?
No, I do not.
Why not?
Well, it's my understanding that SEPA review is required for all energy facilities at FSEC, and I am unaware of a scenario where counties or other parties would not be given notice and an opportunity to comment on FSEC's evaluation of future cumulative impacts from any other proposed project.
So as for your own project, would you kindly give me a brief summary of what Interjex has done to minimize the impact to the GMAD land use in Benton County and the measures that you've taken to render your project compatible with other area uses?
Sure. We have made efforts to reduce project impacts on ag lands as much as possible. We've condensed the solar array through micrositing to reduce the overall footprint, leaving as much of the project area free of fencing as is practicable. We will perform regular soil testing for a variety of soil characteristics. There will also be a technical advisory committee that can recommend adaptive management measures to the council, and this is a significant mitigative action to maintain the agricultural nature and character of the lands throughout the operational term. In addition, our detailed site restoration plan will include commitments to restore all ag lands to the pre-project condition. This will include minimizing use of and then removal of gravel and aggregate material, performing localized grading and disking to match the surrounding elevations. We will replace topsoil from where it has been stockpiled on site. Conditions also require us to revegetate disturbed areas with an appropriate hydroseed mix. And as discussed, we will be required to post a security bond to ensure decommissioning and restoration is completed. And of course, there is the 5-year monitoring program after restoration to make sure we get it right.
So Ms. O'Neill, with these and the other conditions in the MDNS and the ASC, are you confident that the project will be conditioned to ensure the project can be sited without adversely affecting the GMAD zone in the event that Benton County Code 1117-040 is preempted and the land will be returned to a condition for future ag use?
Yes, I am.
Thank you, Ms. O'Neill. I have no further direct questions for you. However, other parties to this matter, as well as the chair, counsel, and judge, may have questions, so remember you're under oath to answer those questions.
Understood. Thank you.
All right. Thank you, Ms. Anderson. At this point, Ms. Holt, do you have any questions of Ms. O'Neill? And if so, go ahead and begin.
I do, Your Honor. Thank you. Good morning, Ms. O'Neill. I'm Leanne Holt. I'm counsel for Benton County. Can everybody hear me okay? Am I talking at a reasonable volume for you?
You are. Thank you.
Okay. Thank you. So, Ms. O'Neill, I'd like to touch on a couple things that you talked about earlier. You talked a little bit about the size of the project. What was the total acreage of the lease?
It was 5,852.
And you mentioned that lease or that acreage amount is malleable. Is that going? Do you foresee that amount changing in an upward trajectory or a downward trajectory?
Downward.
Okay.
As I explained, that was the original lease area. Essentially, the big blob that we studied to determine what the most appropriate solar array area would be within that area.
So now that there's been some research and observations made, what is the proposed project area that you believe will likely be taken out of ag use on the
We proposed 2,978 acres will be fenced in, and that will be the area unavailable for ag use during the term of the project, and which will be returned to availability for ag use following decommissioning.
Does the lease allow for ag use on the properties or the acreage surrounding that 2,000 acres?
Yes, it does. And as discussed, once the project is built, we will only be leasing that smaller amount. The rest will be returned to the landowners for their own agricultural practices.
Are you aware of any plans or intent to utilize that land around the 2,000 acres during the life of the project for ag use?
I am, as you will hear from our two landowners who will testify later. Ongoing agricultural activities will occur adjacent to the project. The Keeler family operates a vineyard essentially within the project area, or immediately adjacent to. They actually have plans to expand that vineyard, and the Robert family will continue their cattle ranching operations adjacent to the project. As mentioned, there will be 9,000 acres held by those two landowners that are available for their ag use.
As a point of clarification, you mentioned adjacent to the project. When you're talking about the cattle ranching and the viticulture, are you talking about the 5,000 acres or adjacent to that?
I'm speaking about adjacent to the roughly 3,000 acres that the project will occupy during operations.
Correct. My question is, when you say adjacent, I'm asking how adjacent. Will that be within the 5,000 acres that were originally leased or outside of that?
Sorry. Yes, it will, in addition to other lands held by these landowners that were not under lease.
So you also talked a little bit about the attractiveness of this site location. Did you consider other sites within Benton County?
Not that I'm aware of. Our development team is always looking at sites throughout the country, but I'm not aware of any other specific sites in the county.
Once you guys became aware of the change in Benton County Code that would no longer allow for site usage, were there any efforts to look at other areas within Benton County at all, or outside of Benton County?
Not that I'm aware of.
Okay. Just a second here. I believe you testified that you reached out to Benton County. What was the method of the initial contact?
That was by email.
Okay. And did you receive a response from Benton County on that?
I did not.
Did you follow up with them by phone call or additional emails?
Well, yes. When we learned of the proposed ordinance change, removing solar and wind from the GMAD zone, Intergex followed up with several letters to the Board of County Commissioners to encourage the county to not take this action and to continue to maintain their ability to site within their own county to evaluate projects on their own merits. We also attended the public meeting on December 21st, 2021.
Okay. And in terms of calendar dates, about when did that occur, the follow-up?
I would have to review my records. I would say, I couldn't pinpoint the exact date, but it was in the lead up to the December meeting.
Perhaps more generally, would it have been during summer still, into the fall?
I don't have that date available.
Okay. In your efforts to follow up with the county, did you ever ask the county about where in the county you might be able to site this in accordance with Benton County codes?
Not specifically. It's our understanding that solar and wind major are allowed in the industrial zone. However, there's not really enough acreage available in that zone to adequately site such a project.
Okay. I would like to share with you, I believe you had touched on Exhibit 11. I can pull that up for you. Sorry, this is not... Okay. Sorry, technical difficulty here. Are you able to see that Exhibit 11?
I can't. So if you're able to enlarge it slightly, that would be appreciated.
Has that helped?
Yeah.
Okay. Could you read that first sentence for me?
Commissioner McKay discussed growing up on a farm?
Correct.
Okay. Commissioner McKay discussed growing up on a farm and understood farming circumstances, but indicated that solar and wind power are not consistent resources. He mentioned that even if the county went by a case-by-case basis, applicants could go to FSEC, which would ultimately have the final decision. Commissioner McKay also indicated that at this time, he would be in favor of possibly revisiting in the future, as solar is less of an eyesore than wind farms, and he was looking out for Benton County's future growth.
Were you aware of those comments back in the fall of 2021?
The comments made that I just read from December 2021?
Correct.
You mentioned the fall, so I wasn't sure.
Oh, I'm sorry, I misspoke.
Okay. Yes, I am aware of the minutes of this meeting and the comments within.
So Commissioner McKay seemed to indicate the possibility for future growth in the area of solar in Benton County. Did you reach out to the county at all to talk about what that might look like and how that might work with the project?
Well, yes, as testified, we did continue to reach out to the county. We made the presentation in May of 2022 to continue to provide project updates and information about the project.
So in that follow-up, you provided information to the county, but did you seek information from the county?
Seeking information from the county on what exactly?
On potential future solar provisions.
No.
Okay. Can you read the second paragraph there on that exhibit?
Yep. Commissioner Devlin indicated that he did not want Benton County to become the dumping site for renewables here in Western Washington. Commissioner Devlin indicated that he understood the plight for farmers and viewed this as a moratorium which could be looked at again in the future. Commissioner Devlin saw this as an opportunity to review our ordinances and identify areas within our region for boundaries to see what the future approach could be. He stated there was time to plan.
Okay. With these comments from Commissioner Delvin, do they seem to indicate that the county is willing to work with renewable energy sources on future approaches?
They do not indicate that to me. They indicate that they intended to review in the future whether they would continue with the ban or revisit that decision.
Okay.
And to my knowledge, that decision has not been revisited.
Okay. I am going to stop sharing that. Hopefully we can see your face again. And I'll move on to other questions. I can pull up Exhibit 22. I will attempt to share that with you. Are you able to see that exhibit?
I can see it. It's quite small. I don't think I could read it properly. Okay, I think we can go now.
Any better?
Yeah, I think I can manage that. You would like me to read it? Oh.
Are you familiar with this statute?
Yes, I am.
Okay. Is it fair to say that, based on your prior testimony, your interpretation of that statute is that Benton County's code, which does not permit the proposed project, is already preempted?
Yes, it is.
How do you reconcile that with other provisions of Chapter RCW 8050 that state the council may limit topics to whether the land use planning should be preempted?
Your Honor, I'm going to object at this point. Ms. O'Neill has not been established as an attorney and is not in an appropriate position to evaluate the comparative effect or relevance of various statutes. If Ms. Holt wants to inquire about Ms. O'Neill's legal prowess, she may do so, but until then, I think this is an inappropriate line of inquiry.
Ms. Holt, response?
Yes, I believe we have heard testimony that they believe the law allows for preemption. I'm simply asking what her understanding is of the laws that allow FSEC not to recommend preemption. If she can testify one understanding of the law, I don't understand why she can't testify to her understanding of a different statute.
Wait, Judge.
Yes, hold on. Ms. Anderson, any response before I make the ruling?
Your Honor.
No, Your Honor.
Yeah. Sorry, this is the court reporter. Could you repeat that, Judge?
Yes, I asked if Ms. Anderson, if she had any response prior to making my ruling.
No, Your Honor, provided we establish that Ms. O'Neill's legal experience is limited, I don't have an objection.
All right. The objection is sustained. Establish a foundation first for the witness to opine on the inner workings between those two. Once you've established a foundation for it, you can re-ask the question. If there are objections at that point, we'll take them up.
Thank you, Your Honor. Ms. O'Neill, you've talked about your education and training. Do you have any legal training?
I do not.
Okay. In the course of your employment, have you familiarized yourself with Chapter 8050 RCW?
Yes, I have on a basic level.
Okay. And on that basic level, are you aware of RCW 8050-90, which states the council may limit topics to whether land use planning should be preempted?
Is that something you could pull up for my reference?
I would have to ask leave of the court to do so. I don't believe we have that as an exhibit.
My understanding is that is the statute that was called out in the order commencing adjudication because the project received an MD&S and environmental impacts would be mitigated to a level that's non-significant. This hearing could be limited to land use. I believe that's what you're referencing.
My question is, would you agree that the council has the ability to recommend for or against preemption?
I would agree with that.
Okay. We'll stop sharing that document. And when it comes to preemption, what is your understanding of limitations with that recommendation? Are there conditions that need to be imposed?
Yes, if preemption is recommended, the council should impose conditions to render the project compatible with the local codes which are being preempted. And in our case, we've seen substantial discussion of the conditions in Section A5 and in the MD&S that will support this.
And I would like to transition to A5. So again, if I may share a window, I would like to share what has been marked as Exhibit Number 2, the Wautoma Revised Application. Let me try and enhance that a little bit so you can see better. Are you familiar with that table?
Yes, I am.
Okay. Looking at the heading there in gray, can you tell me what mitigation measure is addressed there?
The one on the screen is titled Implementation of Geotechnical Recommendations.
And they're in the gray space.
Oh, sorry. The header is Earth.
Earth, okay. I'm sorry. I'm going to scroll down just a little bit here. In the section discussing best management practices, can you tell me a little bit about what those look like and how that will affect the subject property that you're asking preemption on?
Okay, so there is a description of BMPs here in section A5. The sediment and erosion control plan will be implemented, a construction phase, construction and operation phases management plans. These address stormwater runoff, erosion measures, potential flooding, although that's not much of a risk in this area. I'm not sure what you're asking me beyond what is written.
I guess I'm trying to focus, in terms of best management practices, how does this address the loss of agricultural land if the land is to be preempted?
Well, it's undisputed that those almost 3,000 acres will be temporarily lost for agricultural purposes during the operational term of the project. The measures we've proposed here and those in the MDNS mitigate effects of the project itself during the operational term, like soil erosion, dust control, that kind of thing. But we're not stating that. We're conceding that that acreage will be temporarily unavailable to ag use.
Okay. If I move down to page 48 there, in the section titled Land Use in gray, could you read that for me?
No. Based on the information provided in section 4.14.c and in the Land Use Consistency Review, see attachment D, the project will have no significant adverse effects on land use. Therefore, no land use mitigation or monitoring measures are proposed. Mitigation measures specific to other topics, example wetlands and surface waters, wildlife habitat, or geological hazards, are addressed in their respective resource sections in Part 3 and Part 4 of this application.
So if I understand your prior testimony, you're conceding that the project area of approximately 3,000 acres will not be available for agricultural use during the life of the project. Is that correct?
That is the area that will be occupied by the project for its solar farm purposes. So, yes, within the fence line, it will not be available for agricultural use during the term of the project.
And if I understand this section on page 48 discussing land use, you are proposing no conditions that would offset that loss of agricultural use.
Well, I think that's a little misleading. As discussed, many mitigation measures are proposed to render the project compatible with agricultural use in the area. Those measures are listed throughout A5, just under different headings, as you saw in Earth. And in the MDNS, land use mitigation measures are under the heading land and shoreline use. So those are the measures we've proposed and that have been implemented by FSEC onto the project.
Okay. Mr. Halapa, would you go ahead and mute yourself, please, sir?
Ms. O'Neill, do those measures, which you allege make the project compatible with local ag use, create additional ag lands to offset the loss of this 3,000 acres?
I'm not sure what you mean by create additional land, but we will be occupying close to 3,000 acres of land, and the remaining land holdings of our participating landowners will be available for their agricultural activities.
Okay. And if this project were not approved, would the remaining acreage for the landowners be available for ag use?
If this project were not approved, the landowners would retain control of the entirety of their land holdings.
Okay. So approval of the project, would it be fair to say, does not impact whether the landowner's other holdings would continue to be ag land?
Approval of the project would approve us to operate our solar farm on the 3,000 acres, and yes, the remaining land holdings would be available to the landowners for whatever purposes they wished.
And that would be the same if the project was not approved. Is that correct?
Correct.
Okay. Are there any conditions in this table A5 that would allow Benton County to have an additional 3,000 acres available for ag use that are not already slated for ag use?
I think you're suggesting, or I think you're asking if our proposal includes a provision to rezone other land within the GMAD. I'm not quite sure what is meant.
Any method of making 3,000 other acres of property available for ag use that is not already
no, it does not.
Oh, pardon me, the last part of the question, that is not already
marked as ag use.
And may I have the answer again, please?
No, it doesn't. What I will note is that the area unavailable for ag use during the operational term of the project, as conditioned by FSEC, will be returned to the landowners and restored to a condition making it available for agricultural use following decommissioning.
Okay, well, let's talk about restoration here. I'd like to share with you what's been marked as Exhibit 16. This is, can you identify this document for me? I'll move up to the top.
Yes, I can. That is the revised MD&S.
Okay. I'm looking at page 2 of the document. There is a section called SEPA Threshold Determination. Can you read what that determination is for us?
It was a mitigated determination of non-significance. Sorry, would you like me to read the whole section?
Yes, please.
Okay. FSEC has issued a mitigated determination of non-significance, or MD&S, under WAC 197-11-350, based on a determination that the enclosed mitigating conditions, along with required compliance with applicable county, state, and federal regulations and permit requirements, would mitigate any significant adverse effects on the environment. An environmental impact statement, or EIS, is not required under RCW 43.21.c-030, Section 2, Section 3, Section C. This determination was made after review of the application and other information on file with the lead agency and existing regulations applicable to the proposal. See attached memo from FSEC staff. The environmental
sufficient.
Okay.
in that threshold determination,
Wait, hold on.
would it be fair?
Hold on, Ms. Holt. I think the court reporter needed clarification.
I figured it out afterwards. I think it was that would be sufficient. Is that correct, counsel?
Correct.
Thank you.
Please continue.
Is it fair to say that based on that paragraph, the focus of this revised MDMS is environmental concerns?
That is correct, although it does state, at least in the staff memo, that the county's input on land use consistency was considered.
Okay. Is there anything in this threshold determination regarding land use as it relates to Benton County's potential loss of ag acreage?
Well, there are several mitigating conditions that will be imposed on the project to, render the project compatible with the measures in the comp plan and in their zoning. In fact, as discussed, soil monitoring, erosion control, slow speeds, etc. I'll note that we have demonstrated that we will be compatible with all Benton County codes and provisions, barring the one, the purposes of allowable with the CUP.
Okay. Does that compatibility offset the potential loss of ag acreage?
Well, the loss will be temporary during the operational term, and I'm not sure if you're asking again whether we are proposing offsetting 3,000 acres or creating new acres. That is not part of the proposal.
Have you looked into any options that would allow you to do that, to impose such conditions?
Do you mean have we discussed with the county how to create new ag land?
Either through discussions with the county or independent investigation?
No, we have not.
If I can move down to page 9. Just a second here to find what I was looking for. I'm looking at the section titled Land and Shoreline Use. Give me just a second here. Starting with the section that says, if future site conditions, could you read that sentence?
Ms. Holt, I'm going to stop you there. It's in the record. If there's a specific point you wish to address the witness on, ask it directly. We don't need to repeat what's already in the record for that specific portion. Thank you.
Very good. I will do that. Ms. O'Neill, does this section consider the possibility that even with the conditions in this revised MDNS, that the property may not be suitable in the future for the return as ag producing land?
It does consider this.
And counsel, that was for the what as ag producing land?
I think my question was, give me just a second to remember.
May not be suitable in the future for the blank as ag producing land.
For return as ag producing land.
Thank you.
The witness has answered, Ms. Holt. If you're waiting for that, you can go ahead and move on to your next question.
Yeah, sorry, that threw me off a little bit. So, Ms. O'Neill, would it be fair to say that it is not a foregone conclusion that the property will be returned to ag producing land, even if all these conditions are followed?
We are committed to the success of restoration. EFSEC has also through the FDNS, applied a technical advisory committee that will be comprised of agency experts and the like that can recommend adaptive management if there are issues with the restoration. In addition, we will have a bond securing our completion of these. And this is really a question for the future. This is an enforcement issue. If we were to not complete our restoration as mandated, as shown in this measure, we would work with FSEC to figure out what to do at that point. FSEC may require that the applicant provide additional mitigation to offset impacts.
Okay. So even if that worst case scenario were to occur, that even with all of these efforts, the land was not suitable for ag producing land, has Interjex thought of any conditions that would repair the damage to the county in terms of loss of ag lands?
As stated in this condition, that is something that would be discussed with FSEC at the time, and if additional measures or mitigation are required at that point, we would follow that direction.
In any of the documents from the applicant or through FSEC, are you aware of any proposed land use mitigation conditions that address the loss of subject properties as actual or potential ag during the life of the project?
Again, if we're considering the temporary loss of the 2,978 acres within the fence line, those acres will be unavailable for ag during the operational term. And within the fence line, we've discussed at length the mitigation measures that will condition the project to a consistent state with adjacent ag.
Is Interjex proposing any conditions that recognizes the county's interest in having the total number of ag lands that it has designated?
Your Honor, I'm going to object. This has been asked and answered multiple times at this point. This is badgering the witness.
Sustained. Though I don't think it's badgering, but I definitely think it is asked and answered. Please move on to your next question.
That is all the questions that I have for you. Thank you.
Thank you.
Okay, thank you.
All right. Mr. Kroll, does the Council for the Environment have any questions of Ms. O'Neill?
I do not.
Okay. And at this point, the Council is allowed to ask questions. Chair Drew, I'd like to first consult with you in front of everybody, obviously. As the Chair, would you prefer to ask the first question, or would you prefer to ask it after the rest of the Council members have had their opportunity? I'd like to see your preference on that.
I would prefer to ask them after. At this point, I have no questions. If I might suggest, Judge, I think that a way to go about this would ask the council members to raise their hand if they have any questions, so we don't have to go through asking each one.
Sure. If that is a preference, as long as everyone can hear me, I'm agreeable to that. So, based upon that, Chair Drew's suggestion, do any of the members of the council have questions? Please raise your hand, and I will allow you to speak in turn. Let me see if I can find the hands as they go up. Here we go. Mr. Sharp, it appears that you've actually had your hand up first. Please go ahead and ask your question. If you're asking a question, you're on mute, sir.
Let me turn my camera on, too. I wanted to ask the applicant if they had considered a situation where if there was a fire on the site. And as I understand it, there are items on site that could cause a fire, which could damage the soils and the land, and that might be pertinent to the line of questioning that we just heard. But I wanted to find out if the applicant had considered that.
Yes, we certainly have considered fire and emergency response in our project planning. At this point, we have engaged a specialty consultant to advise us on fire response measures and emergency response. We've certainly discussed with our landowners the conditions in the county. We have entered into preliminary discussions with the county emergency response department, with the fire marshal, and they have advised us that they'd be happy to speak with us about fire protection measures following the project's approval.
So if there was a situation where the soil was contaminated or damaged, does the project include restoring that land or removing it?
Yes, absolutely.
Okay. Thank you.
Any other questions, Mr. Sharp?
No, thank you.
All right. Mr. Yeo, please ask your question.
Thank you. I have a couple of questions about the outreach log. Would it be possible for Interject's Exhibit 4, the page of the outreach log we looked at previously, to come back up on the screen?
Ms. Anderson, can you please do that?
Yes, sir. One moment. I believe that was Exhibit 4, but I'm pulling it up now.
Thank you. My first question is this outreach log comprehensive? Does it include all efforts by the company or its contractors to do outreach, or is this just selected outreach events that are entered into the log?
I couldn't say that it's fully comprehensive. I'm sure we have multiple departments feeding into this log between community relations, indigenous relations, environment, development, government relations. So I could not represent that it is 100% comprehensive.
I'm just looking at, for example, the what's shaded in blue. Initially, it looks like contact to 4 different tribes,
Yes.
and no response was received, and that's in August 11th. And then the next chronological entries are up in November. And where I was thinking about this was, does that mean that when an initial contact was made to the tribes and no response was received, that 3.5 months later there had been no follow-up, no attempt to recontact the tribes?
Well, that initial outreach, as you can see, was an initial outreach and informing them and soliciting feedback on our cultural resources survey. But as I may not have discussed this explicitly earlier, but once the project really gets going and engagement with the lead agency takes place, i.e. FSEC, all communication with tribes runs through FSEC and through DAP. It's our understanding that applicants do not engage directly with the tribes at that point. So that is the reason for perhaps you've seen a gap in our direct outreach, but the agencies certainly were in contact with interested tribes. And I will note also that no tribes provided any comments on our MD&S or identified themselves as parties to this proceeding.
Okay, that's I think kind of what I was after, but the initial contact was by the company or your contractors in August, but after that time, when you didn't get an initial response, the company or the contractors did not recontact the tribe, but FSEC or DOP may have done so. Is that fair? Is that correct?
Go ahead.
Interjects provided the initial outreach, and then subsequent, the agencies took over communication.
Okay.
Your Honor, I'm loath to interrupt, but I believe that the witness said this was, to the best of her knowledge, not a comprehensive, because she manages a variety of teams. So I just want to put this in that context.
Ms. Anderson, you'll have ample opportunity to clarify that with your witness on redirect, so please don't interrupt at that point. You have your opportunity at that.
Was the company or contractors ever again in direct contact with tribes after the August 11th initial outreach?
Yes, we were. In fact, our attorney, Ms. Anderson, was contacted directly by the attorney for Yakima Nation earlier this year. The tribe wished to speak directly with our company about the project.
Okay, so there was a response in 2024 after this initial contact in 2021?
That is correct.
Thank you. I don't have any other questions about this at this time.
Okay. Mr. Livingston, do you have questions of the witness?
Yeah, thank you, Your Honor. A couple of them, real quick. First, and it's a follow-up to Mr. Sharp's question. Can you tell me which fire district you talked to? Because the way I understand that area is in a no man's land as far as fire coverage goes. So who are you in discussions with there?
I was in discussions with the Benton County Fire Marshal.
Okay.
We'd reached out. It's probably in the outreach log, but one of my colleagues had reached out to the fire marshal a couple of years ago at the outset of our application, just to gather more information and introduce the project. And earlier this year, I reached out again to the fire marshal. I apologize, I can't remember his name offhand. We spoke, and actually during that conversation, the fire marshal related to me that he had discussed my request for a meeting with the director of planning, and the fire marshal was advised not to engage with interjects because of the prohibition on solar projects enacted by the county. We continued to follow up with the fire marshal and attempt to engage with them, and eventually received a response that they would engage with us, but only after the project approval was completed.
Thank you.
So that's our status. We're waiting for the resolution of this process, and then we will re-engage with the fire marshal.
Thank you. That area we've discussed for years about the fact that we don't have fire coverage, and there's large fires that often get started on the Yakima Training Center at the Army's post there, and I just curious if there would be ever the potential to have a discussion between perhaps the other solar projects that are going in the vicinity about helping establish a local fire district. I understand there needs to be community support for that, but this large investment in area seems like it would be a worthy conversation to have.
Mr. Livingston, I'm going to ask you and the rest of the council to limit your correspondence with the witness to just questions. This is testimony, and this is not a dialogue. This is an adjudication. So if you have questions that the witness can answer, you're certainly welcome to ask it. But I would ask that you don't interject testimony, which is akin to what you're doing at this point.
Appreciate that, Honor. My question is, would they be interested and willing to have that type of conversation in the future about establishing a local fire district in the area?
Yes, we would be interested.
Okay, thank you. And then one other question is, you mentioned that the Roberts family will be pursuing more agricultural activities related to cattle grazing versus irrigated agriculture, and that you mentioned that that was more profitable. Can you explain that a little bit more? From my understanding, typically irrigated agriculture yields more per acre economically than cattle grazing.
Mm-hmm. Well, a representative from the family, Robin Robert, will be testifying later, so he will certainly go into greater detail. But my basic understanding is that due to the declining aquifer, it's taking more and more water to produce the same yield from the irrigated crops, and that is partially driving the reduction in economic viability of the irrigated ag practices.
Thank you.
All right. Mr. Young, we'll get to you in just a moment. Ms. Holt, you're not part of the council, and I limited this to council, so to the council's questions. If you have an objection, you can speak up to those any time. What was the purpose of your hand being raised before I allow Mr. Young to ask questions?
Thank you, Your Honor. I did not want to interrupt the council, but I did have an objection to the statement regarding what the fire marshal told her about engaging with interjects. I believe that is a hearsay statement that should be stricken from the record.
Okay. Fortunately, your objection is untimely. It's already been stated. And two, this is an administrative proceeding governed under RCW 3405. So hearsay statements are admissible so long as they're inherently reliable. You can certainly make the argument in closing that that statement was not reliable, or how the department should rely, or the council should rely upon it. But the objection is overruled for hearsay. Secondarily, it was also untimely. So in order to preserve your record, it is in your best interest rather just to object at the time before the witness answers the question.
Understood.
Thank you. Mr. Young, any questions or any follow-up questions of Ms. O'Neill?
Thank you. Reflecting upon your responses to questions from Ms. Anderson and Ms. Holt, it seemed that in some places the company has gone ahead and put certain things into the application for site certification that are different types of mitigations or measures to reduce impacts. But in other places, your response was that more or less the company is relying upon FSEC to properly condition the application. How did you distinguish what things the company was going to put forward proactively versus the things you'd just take a more passive approach and wait to be conditioned by FSEC?
I'm not sure if I would characterize our approach as passive. The measures put into the ASC were based on best management practices and results of our studies and advice from our subject matter experts at Tetra Tech, our consulting firm. FSEC's additional mitigation measures, as I understand them, are based on their review of the ASC, their consultants' review, other subject matter experts from various agencies. So those are concerns that have been expressed and mitigated through FSEC's review. There was not a strategy to sit back and wait. We proposed what we thought was appropriate, and we certainly appreciate FSEC's review and the additional mitigations that have been recommended in the MD&S.
Thank you. I have one final question for you. We've been talking, or I've heard a little bit about decommissioning. How realistic is it to assume that this project will be decommissioned and the land returned to agriculture 30 years from now? Is something going to happen in the next 30 years that makes the 400 megawatts of energy that the project will produce no longer needed at that point in the future?
It's a bit of a hypothetical, but we intend to contract the project for a power purchase agreement that those typically last around 30 years. And we've certainly been, the conditions have been imposed upon us to restore the land at the end of the operational term. So we are happy to comply with all the conditions imposed.
Thank you.
Mr. Sharp, any follow-up questions of Ms. O'Neill?
Yes. I wanted to ask, is washing the panels 20% of the panels a year, is that a standard practice in a dusty environment?
That is what has been advised by members of our Interjex team who work on operational projects. I don't have firsthand knowledge of the normal schedule, but that is what has been advised based on our other operations. And definitely some of those other operations take place in dusty environments or deserts even.
Any other questions?
Well, I just was somewhat surprised at that level of cleaning based on other stuff, but no.
Very good.
I don't have any more.
All right. I don't see any other hands raised. Any other questions from the council before I allow Ms. Anderson to redirect her witness? Chair Drew.
Thank you. I do have a question, and going back to your testimony, and this may be appropriate also for the property owners, but there's an assumption made by the county that without your project, the same agriculture would take place over the next 30 years on the land that you are leasing, and a discussion of how many acres would be in agriculture. I guess I would ask, with your knowledge of the land and perhaps what would take place, is that accurate?
I would say it's accurate that acreage would be available for agricultural use if the project were not approved. Obviously, it would be up to the landowners what they wanted to do with that land, and certainly they will be testifying later to their future intentions. As briefly discussed by myself and will be discussed further, the aquifer is declining and irrigated agricultural practices are becoming less of a profitable operation. So in the absence of the project, it would be up to the landowners to decide what practices they would take on the land.
Thank you.
Any other questions, Chair?
No further questions.
All right. Ms. Anderson, any redirect of your witness?
Very briefly. Ms. O'Neill, I want to make sure I understand the answer to one of your questions. Of the 5,000 acres that you have leased, all of those acres that are not part of the project area will become available for ag activities. Is that correct?
That is correct.
All right. If this project goes forward, are there any benefits to the landowners in regard to wise use of their water?
Yes, there are. As discussed, the aquifer is declining. The water needed for the project's construction and operation is less than what is currently being used for their irrigated agriculture. So the water strategy, as I described briefly and will be discussed in greater detail later, is to put the bulk of the water into trust while the project operates. We will use some for the project, and the landowners will use some water for their ongoing agricultural activities, but we expect that putting the water in trust will allow the aquifer to recharge and improve conditions for future agricultural use.
Does this project generate revenue to them to be able to pursue that strategy?
Yes, and I think you will also hear later the lease payments will support their efforts to continue and even expand their agricultural activities on their adjacent land parcels.
All right. Briefly in regard to engagement with Native American tribes.
Speak up, Ms. Anderson, please.
I'm sorry. In regard to engagement with Native American tribes, can you describe for me how many exchanges occurred at FSEC between various parties and tribes without disclosing the content?
I probably couldn't name the exact number off the top of my head, but there were numerous exchanges, in particular with Yakima Nation. They commented multiple times on the application and throughout the review process. We responded to several inquiries of theirs via FSEC and DAP.
Did you make changes to the project as a result of their input?
We did. Yes, we did.
And does the MDNS commend continued engagement with them?
Yes, it does.
And you're committed to that?
Yes, we are.
All right. Insofar as fire measures, are there other fire measures contained in the conditions that FSEC has advanced for this project?
There are. We will be holding a 10,000-gallon water tank on site. We will be relocating an existing watering pond that will be within the fence line. We are relocating that outside of the fence to maintain that source of water. And we will be working with WDFW to develop what they call green strips around strategic perimeter areas of the project to provide fire breaks around the project. In addition, the project access roads will all be graveled and also provide a fire break.
All right. I have nothing further, Your Honor.
Okay. Thank you, Ms. O'Neill. We're at 11:40. I'd like to discuss where we are with the case and concluding today by 5 p.m. before we take any sort of break. We still have 5 witnesses that are listed. 3 for the... I'm sorry? 3 for the applicant and 2 for Benton County. We spent a little over 2 hours with that particular witness. Ms. Anderson, do you see any concerns of us finishing on time today with the remainder of your presentation of the case, but being done by 5 plus closing arguments?
No, I don't, Your Honor, although I think I would like to take advantage of the offer or consideration of a half-an-hour lunch break.
Okay.
To be sure of that.
Yeah, that's what I want to get the consensus of everybody before we do that, including FSEC. Ms. Holt, the same question is for you. Do you see any concerns with us finishing on time with the time we do have remaining?
I do not. If we take the half-hour lunch, I feel like the remaining witnesses will go a little bit faster.
Chair, do you have any objection to us taking a half-hour break and perhaps a little over and rejoining at 12:15?
I do not.
Okay, and let's go ahead and break at this point rather than get partway into a witness and have to break it up. So let's reconvene at 12:15 p.m. I'm going to stop the record and disconnect, and then everyone is welcome to join if you stay on if you have technical difficulties. Otherwise, we will reconvene in 35 minutes. All right, thank you.
Thank you, Your Honor.
All right, we're back on record in the matter of Wautoma Solar, OAH docket 279466, and FSET docket EF-220355. The time is 12:16 p.m. on September 25th, 2024. We were off the record for about 35 minutes. I do need to confirm with all parties that I did not have any communication with them in either substantive or otherwise during that break. I would ask that anybody who believes I did have contact with them to go ahead and raise your hands. We'll have you speak up for the record. If there are no hands raised, then we will assume that there were no communications. So if anyone does believe I had communication with them during the break, please raise your hand. Otherwise, we'll go ahead and continue. All right, seeing no hands and my representations, I didn't speak with anybody. Let's go ahead and move on. Chair Drew, would you like me or Ms. Owens to take a roll call of the council before we allow Ms. Anderson to call our next witness?
Yes.
Would you like me to do it?
Ms. Owens, would you like her to do it?
Yes, please. Go ahead. Thank you.
Thank you. Chair Drew?
Present.
Department of Commerce,
Elizabeth Osborne is present.
Department of Ecology, Department of Fish and Wildlife,
Mike Livingston, present.
Department of Natural Resources,
Lenny Young, present.
Utilities and Transportation Commission,
Stacy Brewster, present.
Benton County,
Dave Sharp, present.
Washington State Department of Transportation.
Paul Gunseth, present.
I believe that is all the council members.
Okay. And before we did restart the recording, I did confirm that Ms. Anderson is back for the applicant. Ms. Anderson, can you please confirm that?
Can you hear me? I am here.
Thank you. Ms. Holt, also for Benton County, we did confirm she's present. Would you please confirm?
I am present.
And finally, Mr. Kroll for the Department, or Counselor for the Environment. Would you please confirm that you're present?
I'm present.
Very good. So with that, unless there's any order of business we need to take care of before, applicant, please call your next witness.
Thank you, Your Honor. My next witness is Ms. Leslie McLean. Good afternoon, Ms. McLean. Would you please state your name?
Wait, I still have to swear her in and get her instructions. I was just writing notes. Give me a moment, please. Thank you. Good afternoon, Ms. McLean. Have you been present throughout the proceedings so far?
Yes.
Have you heard the instructions I've given the other witness?
Yes.
Do you have any questions based upon those instructions?
No.
Okay. Please raise your right hand. And do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, and the penalty of perjury?
Yes.
You are under oath. Ms. Anderson, please begin.
Thank you, Your Honor. Ms. McLean, would you please state your name, occupation, and where you live?
My name is Leslie McLean. I reside in White Salmon, Washington. I'm employed at Tetra Tech, which is an environmental consulting firm, which, among other things, serves the renewable energy industry.
What is your background and work experience?
I have a Bachelor's of Art in Environmental Studies and Public Administration from Carroll College. I've been a professional land use and environmental planner for over 16 years. I've worked extensively on land use permitting, environmental review, project management, primarily on infrastructure projects in Washington, Oregon, and Hawaii, including several solar projects.
Ms. McLean, Your Honor and Counsel, I'm going to put up Interjects Exhibit number 20. Ms. McLean, can you identify that?
Yes, this is my current resume.
Thank you. Please describe for the council your work.
Counsel, I'm not seeing the document shared.
Yeah, we're getting the document. Okay. My apologies.
There you go.
Thank you. Please continue.
Please describe for the council your work on the Wautoma Solar Project.
Sure. So I helped author and do a senior review of Attachment D, which is the land use consistency review analysis for the ASC.
And are you able to answer questions under cross-examination?
Yes.
All right. Ms. McLean, what is the purpose of Attachment D to the ASC?
It's required by the Energy Facility Site Location Act, or EFSLA. It's intended to inform EFSEC on how the project's either consistent with the local land use regulations or how it can be conditioned to recognize the purpose of the local regulations that may be preempted.
So are you saying that if a proposal is not consistent with the land use regulation, EFSEC can exercise discretion to authorize a project?
Yes.
Okay. And what is that process called?
It's called preemption.
Do you know why preemption is granted to the council?
Yeah, my understanding is that through EFSLA, the legislature has recognized that there's a need for clean energy in the state of Washington and has authorized EFSEC with the authority to cite clean energy facilities, including the authorization to preempt local regulations if they're in conflict with the purpose and intent of EFSLA.
And does EFSEC separately have regulatory standards that an applicant has to meet for their project to be approved?
Yes, there's an entire regulatory chapter under the Washington Administrative Code. I believe it's chapter 463-60.
Okay, and to the best of your knowledge, has the applicant Interjects submitted an application that addresses each of those requirements?
Yes, the Wautoma Solar Project's ASC addresses how the project meets all the standards of that chapter. The ASC is quite large because that section of the rules is quite thorough.
So if a project applies for site certification, they must demonstrate they can comply with the standards?
Yes.
Okay. And if locally adopted regulations prohibit a use in a specific zone?
But then, as we kind of touched on earlier, then the state has the choice to preempt those local regulations.
And why is that?
Because as energy is a statewide concern, I understand that the legislature has given FSEC that authority to preempt.
Okay. Do you know what policies the council should look to in making their decision to preempt?
Yeah, so my read of ESLA, RCW 8050, it's the policy of the state to reduce dependency on fossil fuels, and it's also the policy of the state to increase renewable energy facilities. So if a local jurisdiction prevents FSEC from carrying these policies out through the passing of, for example, passing of bans on renewable energy facilities in certain zones, then FSEC would have the authority to preempt these ordinances if they find them inconsistent with the statewide policy under ESLA.
Okay. And what is your purpose in testifying today?
So today I'm testifying in my capacity as a professional land use planner regarding the project, that the project is substantially consistent with the applicable sections of Benton County's Land Use Code and Comprehensive Plan, and to explain why this project should be conditioned so that the council can recommend preemption to the governor.
And can you state why Interjects then is here today?
So in summary, Benton County's Code, Chapter 11.17070, was modified by the county in December of 2021 to remove solar power generation facility major from its list of conditionally allowed uses in the Growth Management Act agricultural district, which is what we reference as the GMAAD or the GMAD, and that's where the project's located. And so since it's no longer conditionally allowed in the Benton County Code, Interjects has requested FSEC consider a recommendation to the governor to preempt this specific section of Benton County's code for the Wautoma Solar Project.
And am I correct in noting that I earlier incorrectly referenced the Benton County Code when I referenced 11-17-040, and it's really 070, correct?
That's correct. 040 of the code lists the outright permitted uses in the GMAD, and 070 references the conditionally allowed uses in the GMAD zone.
All right. Does the application for site certification also explain how the project complies with the Benton County conditional use criteria?
Yes.
Okay. Why do you think this facility should be permitted where it's proposed?
I think that this facility is really well sited. I think that it is compatible with the other agricultural uses that are going to be occurring right outside the solar fence line. And I think that it's consistent with the county's comprehensive plan, and I think it will be supporting the local landowners' ability to continue to do agricultural at the site.
Does preemption occur without any regard for the local regulations that are superseded?
No, not at all. If the council decides to preempt in this case, then per my understanding of the rules of preemption, they need to consider what conditions that they should include with an approval that acknowledges the local land use codes and comprehensive plan.
So based on your review of the Benton County Code, what is the purpose of the GMAD zoning district?
Yeah, so if you go into the Benton County Code and read Chapter 11.17, it spells out what the purpose of the GMAD is, and it's to protect agricultural lands in the county in accordance with the Growth Management Act, and that includes lands of long-term commercial significance. And it does this by limiting non-agricultural uses in the district to those that are compatible with agricultural uses, and also by establishing minimum lot sizes.
Okay. So does the GMAD zone only allow ranching and farming?
No, not at all. If you look at the Benton County Code, like we just referenced, that subsection 040 lists outright permitted uses in the zone. Several of these are not agricultural related, such as schools and churches, single-family homes. Those are permitted in the GMAD. And then also under the conditionally allowed uses under subpart 070, there are non-agricultural uses listed there, such as gravel pits or sand and gravel pits, solid waste disposal facilities, commercial airstrips, just to name a few.
Do you know how big the GMAD zone is in Benton County?
There's a table in the comprehensive plan, and I believe it lists just under 650,000 acres, which I think is just under 60% of the total land mass of the county.
Okay. Did you listen to Ms. O'Neill's testimony earlier today?
Yes, I did.
Do you recall how many acres the project proposes to take out of agricultural production based on her testimony?
Yes, they plan to take out just under 3,000 acres, which I believe, if you do the math, is approximately half of 1% of the total GMAD land mass.
Okay. And where would one look to find information about how this project can be conditioned to be compatible with the GMAD zone?
I'd point you to the applicant's land use consistency analysis, which is Appendix D.
All right. Your Honor, Counsel, Ms. McLean, I'm going to show you Exhibit 2. We'll bring up page 283 of the PDF. Where in Appendix D to the ASC would the Council find that information about land use consistency analysis?
Yeah, I would point the Council to two sections of this document. The first one would be Chapter 2, which walks through the applicable goals and policies of the comprehensive plan, and then Section 3 walks through the applicable sections of the development code. And in this, we cite under 11.17.070, we have in strikeout the old language of the solar generation major that was previously in the code as a conditional use, but we struck it out just to show that at the time of the submittal of the application, that was no longer listed allowed use, but we wanted to include that so that we could show that if it was still included, that then the CUP criteria would apply, and then we walk through the CUP criteria.
Thank you. So we're going to touch on both comprehensive planning and land use zoning. Let's start with the comp plan. Under the Growth Management Act, cities and counties are required to develop plans to identify how what? What do we do in a comp plan?
Okay, so under the Growth Management Act, all cities and counties are required to develop a comprehensive plan as a guidance document to basically make a vision for how they want the lands in their county to be used. And so these comp plans have a variety of goals and policies, and that's the case in the Benton County Comprehensive Plan. It includes a wide range of topics, including economic opportunities, management of natural resources, management of water resources, utilities, public lands, parks. Lots of different topics are covered in the comprehensive plan.
Okay. Is it your professional opinion that the Wautoma Solar Energy Project is consistent with the Benton County Comp Plan provisions?
Yes, that's consistent with the applicable provisions.
And how is that?
So there's quite a few goals and policies that are discussed in Section 2 of the land use consistency analysis that's before you. I'm not going to go through all of them, but unless you want me to, but I'll go through a few. So if you scroll down to land use goal 1, let's see. Land use goal, yeah, there we go. So the goal says to ensure that the land uses are compatible with surrounding uses that maintain public health, safety, and general welfare. And then there's some applicable policies under that. And so I think that there's plenty of evidence that we provide in this document, but also in the ASC that make the case that the project will be compatible with the surrounding uses. In particular, the surrounding uses in this case are agricultural uses. So we have lots of best management practices and mitigation measures that we cover in the ASC, but are also captured in the MD&S that relate to the control of dust, traffic, weeds, soil erosion. There's also mitigation measures specific to soil health, in the water quality, like stormwater runoff. All these things are captured so that we can ensure that the project can be made compatible with its surrounding uses. I also want to point out land use goal 2, which is a little bit further down in the document. And this land use goal talks about private property rights. And so this policy 1 says that it's a policy of the comp plan to prevent regulations that create undue adverse economic impacts or unnecessarily restrict the use of private property. And so in this case, this is where the comp plan is again, like lots of different topics are covered in it. In this case, one of them under land use is private property rights. This, like, one of the implementing, like, the way I see it as a professional land use planner is that the counties and cities will enact zoning ordinances to implement the comp plan. And so one of the things is that there are specific uses that are envisioned for different zones. So like in the GMAD, it's agricultural uses. But the comp plan and the zoning ordinance also acknowledge that other non-agricultural uses in this case, or uses that aren't the primary use, can be allowed in the zone as long as it's consistent with the primary use. So in this case, being able to site a solar facility in the GMAD allows private property owners to pursue economic opportunities that are also compliant and consistent with the agricultural uses of their land. There's other examples of that too, like somebody wanting to site a event facility, which is also conditionally allowed use in the code, is they're looking to diversify their income streams with having wedding venues on their land. And so that would be conditionally allowed with conditions to make it compatible with agricultural use. And then I just want to maybe touch on the natural resource goals. They're a little further down in the document. The natural resource goals 1 and 2, these ones really capture what the Growth Management Act requires of the county in terms of protecting the agricultural lands. So again, these goals and underlying policies, when you read through them, they're not prohibiting non-agricultural use, but rather they're encouraging that non-agricultural uses in the zone are not incompatible with agriculture. So there's substantial evidence that we've presented in the ASC and then also in the MDNS that the project, as if it's appropriately conditioned, can be made compatible with adjacent agricultural uses. And then also I'd like to point to policy 3 in particular under here, because it says recognize that only uses related or ancillary to, supportive of, complementary to, or not in conflict with the agricultural activities are appropriate in areas of the GMAD. So in that case, they specifically talk about supportive of, complementary to. And so, you already heard a little bit from Ms. O'Neill, but you'll hear this from the landowners later in the proceeding. This project very much is supportive of and complementary to the agricultural uses that they are currently doing out there and are planning to continue to do and invest in further on their lands outside the solar fence line, including from Mr. Josart, who's going to be representing Wautoma Farms. He's going to talk about their vineyard and their planned expansion to it and how the solar facility is going to support that. And then Mr. Robert of the Robert Family Ranch, who's been managing this land for over 100 years. He's going to talk about their cattle operations, how this project's going to support that, and how they're going to be able to continue to do some limited alfalfa growing outside the solar fence line to support their cattle operations. So you'll hear more from them, but the point I'm trying to make is that this project's not just compatible, but it's also supportive of agricultural operations in the GMAD. And then the last goal in policy I want to point you to is some of the water resource goals in the comprehensive plan. And there's, I think that it comes to no surprise to probably anybody in the county that there is a scarcity of groundwater in the Yakima Basin, and that's for sure true for the underlying aquifer in this area. And so some of these goals are to promote, appropriate management of groundwater resources and to protect the long-term sustainability of the aquifer. And so we've already touched on this a bit, but the landowners are looking to creatively manage the limited groundwater that they have for their ongoing agricultural uses.
So if the county points to other goals and policies in the comp plan that they contend conflict with the project, can those be harmonized with the ones that you just described that endorse the project?
Yeah, I mean, it has to be a balancing act with, looking at, uses in the use of land in the county and in the state. And so in this case, this project tries to really harmonize the intent of the GMAD by supporting and being compatible with the agricultural uses in the area.
All right. Does the Benton Benton County Comp Plan and Development Code envision only ag uses in the GMAD zone?
No, as I mentioned before, there's many non-agricultural uses that are outright permitted in the GMAD zone, and then there are other ones that are conditionally allowed.
Okay. Can you give me examples of uses that are either allowed outright in the GMAD or allowed with the CUP?
Yeah, so some non-agricultural uses allowed outright include single-family residences, schools, churches. Some of the non-agricultural uses that are conditionally allowed are gravel pits, landfills, asphalt manufacturing. There's others, just the ones that come to mind.
Okay, and are these uses, landfills and asphalt manufacturing, gravel pits, are those compatible with an ag zone?
Well, for the outright permitted uses, Benton County has determined them to be compatible because they're just outright permitted, and for the conditionally allowed ones, that the assumption would be that if someone were to propose a conditionally allowed use, that they'd come to the county and that conditions would be applied to make it compatible. But I'd say that some of these uses could potentially be more difficult to make compatible than a solar facility. For example, like a stone or a gravel quarry would have a pretty permanent impact to the land, where in the case of course the solar project, the Wautoma solar project, is going to be required to restore the land to substantially similar conditions as it is today at the time of decommissioning.
Okay. So are all GMAD lands considered the same, each acre of land the same?
No, there's variations in, the productivity of different agricultural lands in the GMAD.
Okay. And what makes land most productive?
Well, I would say especially in areas like this where it's super dry, there's not a lot of, I think there's like 5 to 6 inches annually of rainfall. The number one factor of production is whether or not there's adequate and reliable irrigation water.
And is this your opinion alone?
So, no, because the other piece that the comprehensive plan points to is also the soil productivity classifications. So the Natural Resource Conservation Service, or the NRCS, they inventory all the soils in the state, and then they apply different productivity criteria to each. And so the soils in this specific area of the Wautoma Solar Project, a good number of them are designated as prime farmland if irrigated. So in this case, the soils are acknowledged as prime farmland if they have irrigation water, and if they don't, they're not considered prime farmland.
And when land doesn't have adequate water, what happens?
In really arid places, that really limits what you can do agriculturally with it. So if you don't have irrigation in a place like this, it limits if you're even able to grow row crops, or if you can, if it's really dry, it's probably not going to give you nearly the amount of yield that you would have in areas with more rainfall.
Okay. What do you know about the availability of water on the lands that Index has leased?
Yeah, so first off, the landowners will be able to talk to this in more detail, as they know their land the best and their water rights the best. But I was able to review the aspect report, which I believe is included as an exhibit, and also talk to the landowners a bit about their agricultural practices, so I can speak to that a bit here.
Okay. Your Honor, Counsel Ms. McLean, I'm going to put up on the screen Interjects Exhibit 19. Is this the aspect report you're referring to?
Yes.
All right. What is your understanding of the purpose of this report?
So my understanding is the landowners commissioned this report from Aspect Consulting to support them with a request that they have to the Department of Ecology to amend their collective water rights so that they better match up with their delineated parcel boundaries, and then also to support a strategy to manage their water as they're facing a declining supply in the underlying aquifer, the water that's available in their primary irrigation well. The other thing I understand is that in order to modify a water right, they must prepare information to support the modification request, and so that information is in this document, and it's in a form of a draft report, because I understand that that's how it's submitted. It's submitted as a draft to the Department of Ecology, and they review it to make a decision of whether or not to approve an adjustment to the water right.
All right. What is so significant about this report insofar as the ag land that's involved in this case?
So this report is really interesting and informative because it provides information regarding the historic irrigation use of these properties, but also the historic well levels of their primary irrigation well.
Okay, and showing you page 19 of this exhibit. You see that?
Yeah. Thanks. Yeah, this table right here shows you what the historic water levels were in our, up until, I guess, about 2017, based on the records Aspect was able to acquire from Department of Ecology. So well number 1 is their primary well, which is in the blue dots. And you can see that back in, about 1974, 1975, the water level, and that's, I understand based on within the information in this report, is that that's about when that well was installed, that the water level was just over 100 feet below ground, and you can see the trajectory of the dots. It just has continued to decrease over time to the point where it's, over 400 feet deep, the water level in 2013. And in I think it says 2017, it was maybe 375 feet deep is what I'm reading here. So the important takeaway from here is that the trend is that the water level is going down, and that the aquifer and the water source isn't keeping up with the extraction of water for the irrigation uses.
So when you say going down, does that mean that an irrigator has to go deeper and deeper and deeper in their well to reach water?
That's right. And I also, after talking to the landowners, and they can talk about this more during their testimony, but they recently spent, I think, over $100,000 improving the well to allow them to continue to go deeper and still, obtain water out of this well.
Does the report also show how many acres Ecology believes they have water rights to irrigate today?
Yeah, so it's not just about what the water rights, the number of, acre feet that they are granted in their water right, but the Ecology also needs to see where the water has been spent or where irrigation has occurred over the past 5 years. And so the Aspect report provides that information, and it basically points to about 750 acres are what is currently being used, or that they can point to for proving out that that's how much water right that they have based on current and recent use. But my understanding is that at one point they irrigated more acres than that, that they've had to diminish that number of acres because of the lowering of the access to water out of their wells.
Okay, so if there are 750 acres of valid water rights, how much of the underlying land is left without water rights?
So there's about 12,000 acres total between the two landowners' land holdings, so that leaves just over 11,000 acres that don't have irrigation.
And am I correct that under the Benton County Comprehensive Plan and their hierarchy for valuing productivity of lands, this is not prime farmland under the NRCS criteria because it lacks irrigation?
That's correct.
Thank you. What else does this report reflect on as far as the ag land that's involved in the case?
It basically reflects that that this area is, that the agricultural potential of these landowners' lands is constrained by the fact that they only have limited irrigation water, and that irrigation water is continuing to be less and less as the aquifer can diminish. And so, given that, the trend of their current agricultural operations, which right now they have about 4 pivots. They have a variety of different crops that they're growing out there, but my understanding is like the alfalfa, for example, takes a lot of water, and that they're unable to cut as many rounds of harvest each year on their alfalfa fields because they don't have as much water to put on their alfalfa fields. So there's diminishing returns on their irrigated land, and so they need to get creative with what water supply that they have, diversify their land uses, and find agricultural activities that they can do into the long-term future using the limited water resources that they have.
So how does this project figure into that?
So this project will provide income streams, diversified income streams, that they can use that money to reinvest in their agricultural operations. And it also will help, because they're going to be able to diversify and rethink how they do their agricultural operations. They're going to be using, in total, less water with the hope that they can stabilize their aquifer.
Okay. And what is the significance of this project then in that framework?
So there's kind of a couple different things to kind of consider with this is that, they're using the sun not only to grow a limited number of crops of their vineyard and the alfalfa fields that they're going to continue to have, but they're also using the sun to create energy, and they're going to be making revenues off of those solar leases. So again, diversified income streams off of the natural resource of solar that'll help them keep their agricultural production efficient and economically viable throughout the future. And this is like precisely the scenario that is envisioned based on my review of the comp plan's policies regarding water resources and land use in terms of giving private property rights the ability to seek economic opportunity.
So is it fair to say that in this way the landowner's ability to remain in agriculture and thrive is supported by the solar facility?
Yes, I think that's fair to say.
What other information shows that this project is or can be conditioned to recognize the county's land use regulations?
Yeah, so just as I mentioned, the project's going to be, compatible with and supportive of agricultural uses in the immediate vicinity, but it also meets all the other applicable criteria in the GMAD zone, such as the lot size criteria, setback criteria. There's also conditions that will make sure that the compatibility in terms of, like a lot of times there's concerns about, the spread of weeds or dust management. Those both will be addressed through weed management plan, dust mitigation measures that are part of the conditions in the MDNS as well as spelled out in the ASC. There's also, something that I haven't really seen as a commitment for other solar projects, so it's great to see here are some specific soil monitoring conditions that Intergex is going to do throughout the operational period and be reporting that back to EPSEC to ensure that the soils are, in good standing and that it will set the project up well for restoration at the end and implementation of the site restoration plan, which is another requirement under the ASC and the MDNS.
Do you know if those periodic reports are actually going to be sent to the Department of Agriculture as well?
I believe that the Department of Ag will probably be on the Technical Advisory Committee, so I'm sure that they'll have opportunity to review those soil monitoring reports. In fact, I think Department of Agriculture was the one that suggested these soil monitoring conditions, and so they are aware of this and that came through with their comments on the ASC.
Okay. So if the council were to choose to preempt the local land use regulations here, should the conditions in the final MDNS in Section A5 of the ASC be included in the site certification?
Yes.
All right. Thank you, Ms. McLean. I have no further questions for you at this time. Please recall, however, you are under oath for questions from others, so please stay on.
Thank you. Ms. Holt, any questions of Ms. McLean?
A few. Good morning. Ms. McLean, the parties appear to agree that EPSEC can preempt, but what must EPSEC consider when it's making that recommendation?
EPSEC should consider the local land use ordinances in their conditions that they consider to attach to approval if they choose to preempt.
Okay. Does it also have to consider interests of the county?
Did you say interests of the county?
Yes.
Can you, explain what you mean by that?
The purposes behind the creation of those regulations that are being preempted.
They need to consider both the policies, the comprehensive plan, and then they also need to consider the policies of EFSLA.
Do the conditions have to reflect those considerations?
The condition, I think that the way that the phrasing in the WAC is that the conditions need to reflect basically their review of those plans, their acknowledgement of those plans.
Okay. I believe EPSEC has entered a determination regarding the project being inconsistent with local land use codes. But I heard early on in your testimony today that it is consistent. which isn't?
It's consistent with all portions of the applicable provisions of the Development Code except for 11.17.070, which is the list of conditionally allowed uses in the GMAD.
Okay. And being inconsistent with the portion ending in 070, does that make it overall consistent or inconsistent?
Inconsistent. I mean, FSEC made that determination that the project was not in land use consistency, which is why we're in this adjudication.
Okay. And I heard you touch on the CUP criteria, but as the law exists now and at the time of the application, does that CUP criteria apply to a solar energy facility major?
Technically, no, but we included it in our land use consistency analysis because if FSEC were to preempt, that could be a criteria that they might want to look at because if it was, as it was before December 2021, included as a conditional use in the GMAD, it would have applied. So, but it's up to FSEC. I mean, technically, the CUP criteria does not apply.
Okay. To the extent that the project is compatible with adjacent uses, does that fact create an exception for the CUP applying?
Can you restate your question?
I believe we've heard testimony that the project is somehow compatible with the adjacent agricultural uses of the property surrounding the site. Does that fact move this project into a position where it now qualifies for some sort of exception that would allow the CUP criteria to apply?
No.
Are you familiar with Table A5 of the application?
Yes.
Okay. Does it provide consideration or conditions that directly address the county's potential loss of the approximately 3,000 acres of land during the life of the project?
It does. It addresses the compatibility of the use in the agricultural zone, but it does not spell out compensatory mitigation or other ways of creating just under 3,000 acres of new GMAD land. No, if that's what you're asking.
I am. And are you familiar with the revised MDMS?
Yes.
Maybe a good idea to put that exhibit up.
I'm sorry, I couldn't hear that.
Who's asking? Ms. Anderson, are you? Is that you chiming in or somebody else?
My question is, if we're going to ask specific questions, can we put it up on the screen?
I don't think that, unless she's going to reference something specifically from the document, I think her question was general enough that she's familiar with it. If she does get into the specifics, I think it would benefit the witness's testimony. But based on what she's currently phrased, I don't think it's required. So, thank you.
So I have the same question with regard to the revised MDS. Does that document provide considerations or conditions that directly address the county's potential loss of 3,000 acres of ag lands during the project's life?
I think you went through this in quite a bit of detail with Laura's testimony, but there are lots of mitigation measures in there that address the compatibility. And when you look at the comprehensive plan and the development code, there's nowhere that does it say that it's not allowed to have non-agricultural uses in the zone. So there's no requirement in SEPA or otherwise to mitigate for a loss of agricultural land. So the SEPA determination is that they determine non-significance in the topic of land use, as you'll see in the SEPA determination from FSEC.
Ms. McClain, I didn't answer the question you were asked. I would ask that you do answer what was asked. If you don't understand it, and the council can rephrase it.
Okay.
Please re-ask the question, Ms. Holt.
So my question was, with regard to the revised MDNS, does that document provide considerations or conditions directly addressing the county's potential loss of approximately 3,000 acres of ag lands during the project life?
No.
No. Is Interjects in any of its documents or here today making any recommendations that addresses that issue?
The temporary loss of 3,000 acres, no.
Hold on one second, everyone. And Ms. Anderson, we're getting feedback from, I think, your line in conjunction with Ms. McLean probably being in the same room. If you're not going to object, can you go ahead and mute your line during your testimony?
My screen is muted.
I'm getting feedback from somewhere that I'm not sure where it's coming from. We'll go ahead and continue. If it becomes too onerous, then we'll have to track down what the issue is. So,
those are all the questions that I have for you, Ms. McLean.
Okay. So let's move on to the council's question. Following Chair Drew's lead prior, if any council members do have questions, go ahead and raise your hand, and we'll take them in order. All right. Mr. Livingston?
Yeah, just one quick one. There's, I think you said 750 acre feet of water rights have been determined to be on the property currently. Do you know how much water will be used when the project's implemented on the property as a whole between agriculture and the project?
I don't off the top of my head, and it's 750 acres of land that are being irrigated. Acre feet's a bit different.
Yeah.
I know one number I have at the top of my head is 120,000 gallons annually during construction. I know it's quite a bit less that's anticipated for the solar operations, but as far as the solar plus the ongoing ag that's planned by the property owners, I don't have those numbers in my head, but I know that when we looked at it comparatively to what they're currently using, it's like in total 4% of what they're currently using out there.
So 96% less water use than currently.
That will be left in the aquifer, or in the well, yeah. And it will be put in trust. Yeah.
Oh, pardon me.
No, so reserve your questions so we're not bouncing back and forth. It just confuses the matter.
This is the court reporter.
Oh, I thought that was Mr. Young. My apologies. Go ahead.
I'm sorry. That will be left in the aquifer or in the well. Was there more to that sentence?
And it will be put in trust, the Department of Ecology trust.
Thank you.
Mr. Livingston, do you have any follow-up questions before I allow Mr. Young to ask a question?
I'm all done. Thank you, Judge.
Mr. Young, apologies for accusing me of interrupting. Your hand was raised, and that gave me the visual cue. Do you have any questions of Ms. McLean?
No problem. I have one question. Is this solar project contingent upon Department of Ecology approving the proposal from the landowners for transferring and updating water rights?
No, my understanding that the description in the ASC for sourcing water for the solar project is that there's multiple options being pursued, including purchasing water from nearby municipalities.
Thank you.
Yep.
All right. Any other questions from the council? And Chair Drew, any follow-up questions from you directly as the chair before I allow a redirect?
I do not.
Okay. Ms. Anderson, if you have any redirect of your witness, please go ahead and do that at this point.
I do not, Your Honor. Thank you.
Okay. Then with that, Ms. Anderson, please call your next witness. Ms. McLean, thank you for your testimony.
Thank you.
Thank you, Your Honor. The next witness that I would call is Mr. Wally Jossart.
All right. Mr. Jossart, are you on the call, sir?
Yes, I am.
And have you been present throughout the entire proceedings?
Not the entire proceedings, no. I've been present for most of it, though.
Did you hear the portion where I explained what was expected of a witness during his participations, or was I going to go over that with you?
I was not on during that.
It's a very brief description. I'll give it to you. Today we're only recording the audio portion of today's proceedings. It's being auto-recorded as well as taken down by a court reporter. The video portion is not. So when you are answering today, please don't respond with head nods or head shakes, as they will not be picked up either by the recording or by the court reporter. Also, please avoid using ahas or ahs when responding. Those can get confusing for the record. Say yes or no if you can. If any time today you cannot hear another participant or don't understand a question, just let me know. We'll have them repeat it. If you hear objection from any of the parties, please stop your answer immediately, as I do need to make a legal ruling on it. And if the court reporter can't hear you, he may interrupt in order to get a clarification of what you said. So that's the general expectations. Any questions?
No, sir.
And raise your right hand. I'm going to swear you in as a witness, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, and the penalty of perjury?
Yes.
You are under oath. Ms. Anderson?
Thank you, Your Honor. Would you please state your full name and spell your last name for the record, please?
Wally Jossart, Jossart.
Mr. Jossart, are you generally familiar with the Wautoma solar energy project proposed for siting in Benton County by Interjex?
Yes, I am.
All right. Are you familiar with Wautoma Farms?
Yes, I'm familiar with Wautoma Farms. It's the operating lands for the family, the Roberts family, and the Keelers. So, yes.
Okay. And do you refer to the owners and the land as Wautoma Farms?
Yes, that's how I refer to them, correct.
Thank you. How many acres does Wautoma Farms own in Benton County insofar as the Keelers?
About 1,500 acres.
And what is your relationship to that?
I'm the investment manager for the family. I oversee the investments across multiple asset classes for them, and this property is one of those investments.
All right. Does Wautoma Farms have leases with Interjex for some of their land?
Yes, it does.
And do you know when those properties were purchased by Wautoma Farms?
In 2021.
Okay. Were the leases already in place at time of the purchase?
Yes, they were.
And who were these lands purchased from?
We purchased the farm, the Wautoma Farms, from members of the Roberts family.
Okay. And why was Wautoma Farms interested in this property?
Well, a combination of reasons. First off, the vineyard was, we were looking at the vineyard as an investment that would be complementary to other assets that we own in our portfolio, but also for the solar lease revenue that would come from this project with Interjex.
Okay. How does that solar income factor in the acquisition here?
Well, both are important. We anticipated the investments in the vineyard based upon both the revenue we could earn from selling the fruit, the grapes that we would grow, but also the revenue from the solar lease as a source of capital to invest in the vineyard.
Okay. Does the land also include 2 irrigated pivots and lambing sheds?
It does.
Okay. And lambing sheds are where mother sheep are brought to have their babies?
That's correct.
Okay. Was the vineyard mature with vines and producing marketable grapes at the time of acquisition?
No, it was not.
Why not?
The member of the Roberts family who was farming the grapes at one point experienced a pretty significant frost due to the climate out in and around the vineyard. And after experiencing that loss, decided not to replant or reinvest in the vineyard.
What has Wautoma Farms done on the property since it was acquired?
Since we purchased it, we've revitalized those plants that we could save and replanted those that were we're unable to revitalize. We've hired a professional farm manager. We have seasonal staff, a member of six farm workers that work throughout the growing season. We've invested in the infrastructure, trellises, wires, things of that sort, wind machine to combat frost and other tools and equipment. We've also just really quick earlier this year, we've in partnership with the Roberts also had to make a significant investment in our well that helps to irrigate both our grapes and the crop circles on the property.
So all told, how much do you think Wautoma Farms has invested in this property to date?
Between $1.7 and $1.8 million.
And what kind of...
That's in addition to what we paid for the property. So
I see. So those are separate.
Yes.
Okay. What kind of returns have you seen on the vineyard since the land was purchased 3 years ago?
We haven't seen any yet. So the vineyard was in a condition where it wasn't producing marketable fruit. For those that may be familiar with wine grapes and the cultivation process, it takes several years. We're expecting it to take about 3 years before we have a marketable crop. So we haven't seen any return yet. Our first sellable crop will likely be next year.
All right. How did Wautoma Farms decide that acquiring land that included a 60-acre vineyard that required replanting would provide you an adequate return on your investment?
Well, we didn't look at it just as from the perspective of the vineyard individually. It was a combination of the revenue we would earn off of the vineyard in addition to the lease revenue that was anticipated from the leases that were already in place with Interjex.
All right. Now, does Wautoma Farms have any plans for expanding the vineyard?
We do. We have 25 acres adjacent to the existing vineyard that we are anticipating investing in the future.
And will the vineyard be adjacent to the solar facility?
It will.
How about the expansion area? Is that also adjacent to the solar facility?
Yes, that's correct.
All right. Are you counting on the solar lease revenue being part of the funding plan for the expansion of the vineyard?
Absolutely, yes.
Okay. Now, are you also dependent on irrigation water to cultivate grapes on this land?
We are.
All right. Where does your irrigation water come from?
There are two wells on the property. It comes from one primary well, which I believe was previously described by one of the former people that testified. I think Leslie testified.
Okay. Has Wautoma Farms spent money drilling the well deeper or somehow deepening the well since you acquired this property?
Yes, we have. We've spent about $200,000 earlier this year on going deeper and upgrading the well, given the decreasing aquifer and the difficulty in getting enough water to irrigate the crops that are currently on the property.
All right. And do you share these water rights with the Robert family as your adjacent owners?
Yes, we do.
All right. And I hope you heard Ms. O'Neill testify earlier. You're in the process of reallocating those water rights?
Correct.
All right. I'm going to put up on the screen what's already been admitted as Interjex Exhibit 19. Do you recognize this? And I'm going to have one moment for it to get up on the screen. Do you see that now?
Yes, I do.
If we turn to page 19 of this exhibit, what does this table show?
This is a graph of the depth of the water table. I think from both well 1 reached, that water table has been declining.
Okay. And are you working with the Robert family and Interjects on a water strategy to reallocate the rights to allow all parties enough water from this aquifer?
Yes, we are.
Okay. Would the solar facility interfere with your ability to operate and manage the 60-acre vineyard?
No, it would not.
Would it prevent Wautoma Farms from expanding?
No, it wouldn't. In fact, it will help fund that expansion. They're both critical together.
Okay. Should the land that is being leased be returned to Wautoma Farms in substantially the same condition as it is today once this project is decommissioned?
Yes.
All right. And should the FSEC Council put conditions on any approval of the solar facility to make sure that that happens?
Yes, I think they should.
I have nothing further at this time. Thank you, Mr. Johnson. You're still under oath, and there are other individuals that may ask questions of you, so please remain on the line.
All right. Ms. Holt, any cross-examination of the witness?
Just a few questions. Good morning, afternoon now, Mr. Johnson.
Good afternoon.
Want some clarification? What is the scope of assets that Wautoma seeks out? You had mentioned this vineyard, you had mentioned the solar, but are there any other projects or types that Wautoma is seeking to invest in?
Not under the, entity of Wautoma, no. Just this farm and this vineyard.
Was the decision to invest in this vineyard independent from the possibility of the solar project?
When we purchased the property, the leases had already been signed and were already in place.
Before you signed the leases, did you reach out to Benton County at all to talk about permitting?
The Roberts family signed the leases in 2020 when this was an allowable use. So when we purchased the property, those leases were already signed by the prior landowners and transferred to us.
What are Wautoma's plans for the vineyard if the solar project application is not approved?
Well, we'll continue to lease the farmland, I would imagine, to existing tenants. We have a couple of crop circles on property. We have looked at the possibility of expanding the vineyard, but again, the water table and the amount of water available to us is in great decline, so we have obvious concerns about its viability moving forward.
Does Wautoma have any concurrent plans to expand agricultural operations onto the leased property outside of the project's immediate site? Outside of the 3,000 acres?
Oh, could I get that question again?
I believe the question was, did Wautoma consider have any current plans for agricultural use on the project site outside of the immediate fencing?
No, we do not.
All right. Hold on one second. Ms. Holt, I think we've kind of narrowed down the issue with the reverb, and for some reason when people are speaking, when you're unmuted, that's when the echo's happening. Is there any chance you can ask the question, mute it, let them answer so we don't get that feedback and see if that fixes the issue? It's inconvenient, but it will certainly clarify the audio recording.
I can do that, yes, sir.
Thank you.
I do not have any further questions for him.
My timing is good as always. Yeah, actually, too late. Okay, so with that being said, let's move on to the council. If council members do have questions of Mr. Jossert, please raise your hand and we'll take you in order. Seeing no hands raised, I'm going to offer it up to Chair Drew for one last opportunity, and then we'll move on to the next witness. Chair Drew, any questions of Mr. Jossert?
No questions, thank you.
Very good. And Ms. Anderson, any redirect of Mr. Jossert?
No, sir.
Mr. Jossert, thank you very much for your testimony, sir. You can obviously stay on if you choose to do so, but we're going to call the next witness. All right. Ms. Anderson, please call your next witness.
Thank you, Your Honor. I would call Mr. Robin Robert.
Mr. Robert, are you on the call, sir? I'm sorry. Actually, Robin is an androgynous name. Robert, are you on the call? And we'll determine the gender in just a moment.
Yes.
Thank you. Mr. Robert, it sounds like. Okay. Have you been present throughout the entirety of the proceedings?
It's Robin. Oh, it's... Yeah, Robin Robert, yeah.
Yes, sir. Very good.
Yes.
And have you heard the instructions I've given to the remainder of the witnesses?
Yes.
Do you have any questions about what's expected of you today?
No, sir.
Then let's swear you in as a witness. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, under penalty of perjury?
Yes.
You are under oath, sir. Ms. Anderson?
Thank you, Your Honor. Mr. Robert, could I ask you to please state your full name for the record?
Robin Robert.
Okay. And are you part of the Robert... Oh, go ahead.
Do you want me to spell my last name?
Sure.
Okay. R-O-B-E-R-T, no S.
Robin Robert. Okay. Are you a part of the Robert Ranch 5+1 LLC?
Yes.
Okay. And who else is a part of Robert Ranch 5+1?
There is a total of 6 of us. Actually, the 5+1 means 5 brothers and 1 sister. And our sister passed away about 7 or 8 years ago, so her daughter, Sammy, now represents her mom. So
and does Robert...
Oh, pardon me, this is the court reporter. Now represents her mom. Was there more to that?
No, just Sammy Mesman represents her mom who had passed away.
Thank you. Does Robert Ranch own property in the Wautoma Valley?
Yes.
How much land?
The Robert Ranch 5+1 has 6,000 acres.
Okay. Do your cousins own land out there as well?
Yes, they had 6,000 acres at one time.
Where is this located generally, Mr. Robert?
The ranch is about 12 miles or more north of Sunnyside, close to Highway 241.
And what is the climate like there?
Usually pretty dry and hot.
Like, how much rain do you get in a year's time?
Approximately maybe 5 to 6 inches of rain a year.
All right. And what is on either side of your property?
Well, excuse me. Our south boundary meets the top of the Rattlesnake Hills with Jeff Wiersma, who runs a cattle ranch. East border Hanford Reservation, and then north of us we meet Joe Balmelli, who runs a cattle operation, and then west of us is pretty close to Highway 241.
All right. When did your family first acquire this land?
Our grandfather, Emil Robert, who came from France back in 1890, came to the United States. He traveled through the United States to California, and eventually he moved into the Yakima Valley, probably back in the roughly 1920s. He started out as a sheep herder, eventually bought his own sheep, started a flock of sheep, and he started buying the hillside, the Rattlesnake Hillside.
Were there I'm sorry, I interrupted.
Sorry.
Go ahead.
It's been in the family since probably 1920.
Okay. Were there other ranching or farming families in the Wautoma Valley when your grandfather was there working the land?
Yes, there was probably maybe 10 to 12 families in the valley, in the valley itself.
And are they still farming and ranching today?
No, they left a long time ago. They couldn't make a go of it.
All right. So what happened to their land? Is that how your grandfather acquired more acreage?
Yeah, they just couldn't raise any crops. I think most of these settlers were from the Midwest where they had higher rain. And here we don't have much rain, so they really couldn't raise a crop. So they eventually moved on. My grandfather would buy some of their ground and eventually bought pretty much all the valley.
All right. Why couldn't they get water from an irrigation district like the Sunnyside Valley Irrigation District or Rosa?
Well, there's no irrigation district, at least Sunnyside and Rosa, until probably maybe around the 1940s, and they're probably at least 10 to 12 miles away.
I see. So your grandfather ended up owning 12,000 acres, correct?
Yes.
All right. And what was that farm or ranch originally called?
It was called Robert and Sons Sheep Ranch.
And did it ever have its own brand?
Yes. It was ER.
And was that on your family brand?
Yeah, on the sheep, and then later on when we bought cows, we went on to the cows.
Do you still use the ER brand today?
Yes.
All right. Did your grandfather farm and ranch with his children?
Yes. Our grandfather, Emil, he was a sheep man, and that's the reason he bought the hillside, Rattlesnake Hills. He had about 5 or 6 springs, so he just needed water sources for the sheep, and they grazed the hillside. Later on, the last family that had left, he had bought that and had a small well, and they did do a little irrigation back in the 50s.
Okay. And did your dad ultimately leave his land to his children?
Yeah, my grandpa did, yes. And he turned it over to Emil Robert Jr. and then my dad, Victor Robert.
I see. So, you said you were one of 5 brothers, correct?
Yes.
Do any of the brothers work full-time on that property today?
Yes, my brother Gene Robert.
How long has Gene worked on the ranch?
Probably getting close to 50 years.
And how much is Gene paid per month?
Well, he gets $1,000, but also he does have some irrigated ground with the ranch, gets some income, and then he also runs some of his cows with our cows too, so he gets that income.
Okay. Is the $1,000 a month what he's always been paid by the ranch for the work he does for Robert Ranch?
Yeah, pretty much. Yeah.
Does he get any paid vacation, retirement benefits, or health care benefits from that?
Well, no health care benefits. He is 68, so he's on Medicare, and he's got supplemental insurance. When you're a farmer, you have to make vacations when you can. That's kind of how it goes.
Does the ranch employ anybody outside the family?
Yes, we have one employee. His name is Chris Tucker. He's kind of the young guy on the farm. He's 58 years old. He's been with us 36 years.
All right. Has your family ever tried dryland crop farming, such as dryland wheat?
Yes, we did in the past, but it wasn't, there again, with only 5-6 inches of rain, we only got maybe 20 to 25 bushel wheat, soft white wheat.
Okay. What equipment do you need to even raise wheat?
Well, usually a big tractor to disc it, probably a rod weeder, which kind of undercuts the weeds. Then you got to have the grain drills to plant the seed, and then later on a combine to harvest the grain.
All right. Are there other areas of the state of Washington where dryland wheat is more productive or highly productive?
A lot of times people talk about the Palouse. That's a very good area for wheat. They get maybe average 60 or 70 bushels. Sometimes on a real good year, 80 or 90 bushel.
So where do they get more than you?
Well, I'm guessing they probably get maybe 15 or 20 inches of rain.
All right. So where is the price of a bushel of soft white winter wheat today?
I believe it's around $5.80 roughly right now.
All right. What was it when you were actually farming dryland wheat?
Well, back in the middle 70s, it was probably $5.50, almost $6 a bushel back then.
Okay, so the price of wheat is flat.
Yes.
All right. Has the price of farm equipment, seed, and fertilizer stayed flat since the 1970s?
Your Honor, if I can object, in the interest of time, I'm not really sure where this line of questioning is going in terms of relevance to land use.
Ms. Anderson, response, please.
Yes, this is entirely relevant to land use. It's the county's position that this is agricultural land of long-term commercial significance, and therefore it should not be preempted by FSEC. This goes precisely to the heart of the county's argument here.
Ms. Holt, response?
Yeah, I believe the record herein shows that the applicant has agreed it is categorized as GMAD lands at this time and at the time of the application. I do not see any argument that it needs to be decommissioned as ag land. I don't believe that that is an issue before the council today.
Your Honor, if I may.
Yes.
We've already heard Ms. McLean talk about the various Benton County comprehensive plans that a solar project in conjunction with the Roberts' other activities on their land is not only compatible but supportive of agriculture. That goes to the heart of the county's argument here, that is why this project cannot go forward, that they cannot be compatible or supportive. That is precisely what Mr. Robert is here to share his family story about. It is entirely relevant.
The objection is overruled. You can ask the question. Don't answer to the legal ruling, please, sir. Yeah. The objection is overruled. Please re-ask the question, allow the witness to answer it, if we didn't get an answer to the previous question.
I believe the previous question I asked was whether the price of farm equipment, seed, and fertilizer has stayed flat since the 1970s.
Yeah. Everything's gone up. Everybody can remember back in the middle 70s, a car was $4,000. Now a new car is probably $40,000. So the same with farm equipment. It's probably gone up 10 times.
All right. Would dryland wheat farming on your land today be enough to cover your costs?
No.
Right.
Can I say something?
Certainly.
Well, it depends. If it's response to a question, if it's just an open narrative, then no. If is it an amendment, is an addition to a question that was asked of you, sir, or is it something you just want to say?
Well, I'm just trying to maybe speed things along if you wanted to.
If that's the nature of what you're going to ask, I'd prefer you didn't. And since Interjex is represented by an attorney. But thank you, though, for the consideration.
Sure.
I'll try to speed this up, Mr. Robert. When did the ranch first get irrigation water, and from what source?
There was a smaller well that was on down the valley, and it actually back then was put in the 1920s. Actually, it was artesian. It was several hundred gallons a minute. Eventually, that stopped. It was pretty much just for domestic use for sheep and other things. They did have a little bit of maybe 60 or 70 acres of irrigated for alfalfa. That was it. Eventually, we improved it with wheel lines and was doing about 140 acres. And it was like that until 1975, 76, until the big well came.
Okay, and how much did that newer well produce when it went in?
When it went in, it was producing 4,000 gallons a minute. It was running 4 circles, but we had, since the water was so good, we added on more. We had wheel lines, about 10 wheel lines, and we were probably farming 1,000 acres then.
Okay, and do you recall what depth that well had to go to reach groundwater?
I think that went down 1,000 to 1,100 feet.
Okay. Now, you said that you expanded the farming operations. Did you include alfalfa?
Yes.
And does alfalfa take a lot of water?
Yes, it does.
All right. Since the 1970s, has that well continued to produce the same amount of water?
No, like I mentioned before, the water table has dropped. We eventually kept going down for the water. We had to go with smaller bowls, which is used to pump the water. And then last winter, we had to have the bowls pulled because the last 2 years we've been sucking air. So now we're, instead of 4,000 gallons a minute, we're down to about 1,400 to 1,500 gallons a minute.
All right. And is this issue regarding the declining level of the aquifer unique to you?
That's just the way it is in the area. A lot of wells towards Yakima, towards Coal Creek, the water tables are going down.
Are they not getting enough recharge from snowfall or rainfall?
Yes.
All right. Do you have any idea, just quickly, how much it would cost to replace your current well with a new one?
No, probably maybe 500,000. I'm just guessing.
Do you have that money to put in a new well?
No. This winter when we lowered the bowls, Allison Keeler and us, we had to put in 190, almost 200,000 to get the water, the bowls down farther to get to the water.
Okay. Would a new well make any difference insofar as how deep you have to go to get to the water?
Well, the well we have now is crooked, so I don't think we could really lower our bowls any farther. We'd almost have to drill another well.
Okay. So I want to make sure I understood your description. What is the highest number of acres you've ever had in irrigated crops in the history of farming this land?
It is approximately 1,000 acres.
Okay, and have you reduced the number of acres under cultivation because of dwindling water supply?
Yes, we're probably the total about 740 acres now.
Okay, and that includes both your and the Keeler's land?
Yes.
Has your yield per acre of alfalfa been affected by dwindling water supply?
Yes, we haven't raised as much alfalfa because of the demand for water. So instead of raising alfalfa or hay, we've been raising barley for hay and triticale for hay.
Okay.
And that only has the water April and May. It's only 2 months of irrigation there that need cutting.
Okay. Now, do you know that Benton County has designated your land as Growth Management Act agricultural district, and that it has listed as ag lands of long-term commercial significance, your property, based on factors including growing capacity, productivity, and soil composition?
Probably. If you have the water, you can raise some pretty good crops. But if you don't have the water, you don't get much.
Okay. Do you know if anyone from the Robert Ranch has tried to reach out to the county to talk about the designation of your land without water?
No, not that I know of.
Okay. Do you know if your lands have any promise of long-term commercial significance, Mr. Robert?
Well, what we're really hoping is interjects for solar. That's the main thing for us right now.
All right. What's the value of your land per acre without water rights or for water rights?
Without any water, it's probably worth between $500 to $600 an acre.
And if it has water rights?
Well, I know over towards Sunnyside it's between $10,000 to $14,000 an acre.
Okay. So let's talk about what you're ranching today. How many head of cattle do you have?
We have 160 head.
Okay. And you testified earlier that your cousins ended up owning half of the 12,000 acres that Emil Robert owned. Is that adjacent to you?
Yes.
Okay. And do they grow the same crops as you?
Well, they probably 15 years ago they decided to go a little different direction. They decided to raise wine grapes, 60 acres of wine grapes, and then they were farming their two circles, one for wheat and one for alfalfa. Yeah, that's what they did for a while.
Okay. Do they have the same issue with declining water supply, or do you share those water rights?
We share the water rights 50-50.
All right. Did they have any barns or sheds?
Yes, they had the sheep sheds down by the main ranch, a hay barn, some outbuildings, yes.
Did they own sheep as part of their ag activities?
Well, they didn't. But we had sheep from 1920 until 1988, and then my father, Victor Robert, and my uncle Emil wanted to retire, so they sold the sheep, increased their cattle herd. My brother Gene and I are more farmers than sheepmen.
Okay. Did they also put any land in CRP?
Yes.
For the benefit of the council, what is CRP?
It's called Conservation Reserve Program. You idle your ground. Well, you have to plant it in grass, usually crested wheat or seed car or blue bunch, and then it sits idle for 10 years, and the government pays you. Back then, it was $50 an acre.
So they were, in essence, paid by the government not to farm that land?
Yes. Let the land kind of let it sit idle and let it rest.
Okay. Now, you spoke about the vineyard. Do you know whether the vineyard produced quality wine grapes?
I believe it did, yes. I know two, maybe 3 years into it, had a terrible frost and killed everything, so it had to be cut back and started again. But I believe at maybe its sixth, seventh year, I was told they raised some pretty good grapes for wine.
Right. So how did your cousins fare financially with their farm plan, pivoting from sheep and a lot of crops to 2 pivots and 60 acres of vineyard?
Well, like farming, there's always something goes wrong, so combination, I think they had a frost later on that affected their grapes, and then it got really hard to sell their grapes to anybody, so they didn't have any buyer thing the last 2 years. Their part, I don't know exactly. That was their business. So.
Understood. Do you know if they had financed some of their agricultural efforts?
Yes.
Were they able to make the payment after they lost the vineyard?
Well, pardon me.
No, they were.
After they lost, what was that?
I was asking whether they were able to make the payments after the loss of the vineyard.
They told us, got to the point they owed the Columbia Bank $1.7 million. They were paying the interest, but they could not pay the principal.
So did they secure that debt with the farmland?
Yes.
Did they end up in foreclosure?
No, we almost did. But that was about the same point. Interjects was talking about putting a solar farm on the ranch. And then to keep the project going, Allison Keeler came in to buy around 1,500 acres of our cousins to pay off the $1.7 million, cleared up their debt. And then actually she had, I don't know, it's up to them, say what they were going to do, but it was Allison Keeler was going to share the rent of solar with our cousins.
Okay. So your cousins still have some land. Did the water rights go with the property that the Keelers purchased?
Yes.
All right. Did your cousins have cattle?
Yes, they did for a while.
They don't have them anymore?
No.
They
had to sell them. To say they had to sell them because they're about ready to go to bankrupt. They're trying to come up with any money they can. So they sold their cows to us. We bought their cows.
Okay.
And Your Honor, this is the court reporter again. Once again, I'm missing the end of the question.
Yeah, and just before we go any further, Mr. Robert, I understand you're willing to answer the questions, but I need you to wait until the question is fully answered, and then answer, because right now we're kind of speaking over each other, which the court reporter is having, and the record is having a hard time distinguish from. So please just hold off until you're absolutely sure she's done. No problem, sir. So, Ms. Anderson, please re-ask the question for the court reporter.
I believe I had asked what happened to the cattle.
And I believe Mr. Robert has answered it. So let's move on to the next question.
Okay. So if I understand, your grandfather's 12,000 acres includes the 6,000-acre Robert Ranch, 1,500-acre Wautoma farms of the Keelers, and then unfarmed land owned by your cousins, correct?
Yes.
All right. And the Keelers now own the lamb sheds, the vineyard, and the pivots. And combined you have 700. And combined you have 700 acres in production today and 150 cows.
Yes.
All right. Your brother is paid $1,000 a month, and you have a full-time hired hand.
Ms. Anderson, we don't need to recap what's already stated. So the witness has testified. It's already on the record. Just ask the questions, please.
Thank you. Do you and your other siblings get paid by the ranch?
No.
Have you tried to get other family members into farming and ranching?
Yes, we talked to our nieces and nephews, but they're not interested.
Okay. So, Mr. Robert, if you recall, when you entered into the leases with Interjects, was a major solar facility allowed in this zone with a conditional use permit?
I thought it was back in 2020. I thought it was.
Okay. Did you hear Ms. O'Neill testify earlier today?
Yeah, I probably did, yes.
Okay. Let me ask you, did you hear her testify that the amount of water needed for construction of the facility is small?
Yes, it's small, yes.
All right. And will the water rights that you share today between your family and the Keelers be reallocated to clear up what water goes where, to whom, and what amounts?
Yes.
All right. You'll get revenue from the solar leases, correct?
Yes.
All right. Do you plan to keep the same size herd and operate the same circles, or are there changes afoot?
We would keep the same amount of cows, approximately 150 head of cows, and run those on the Rattlesnake Hills. The irrigated would probably get it down to about 50, maybe 60 acres of alfalfa, which we would need for our cows.
Okay. Do cattle demand as much water as alfalfa?
Oh, no.
Is it a more sustainable practice to run cattle with a diminishing water supply?
It is right now.
Okay. Can you graze your cattle year-round?
Yes, on the ranch, yes.
Okay. Will you be growing anything to feed the cattle in addition to grazing?
Well, we hope the 50 to 60 acres alfalfa, and that hay would be during the winter time while they're calving. We have to provide them hay.
Okay. Will you be putting in any new facilities or improvements or stock ponds on the ranch with the revenue from the solar leases?
Yes, we hope to put in at least 2, maybe 3 ponds, real big ponds for our cows, but also we have elk and deer on our property, so they'd have a water source. But also a big thing would be help in the summertime when they have range fires. They like to come into, we have smaller ponds now, but we like to put in some big ponds so they come with the helicopters and dip into our ponds, help fight fire.
Okay. So if you're shifting away from water-heavy alfalfa and you're focusing on your cattle, will you need less water in the future?
Yes, less water.
Okay. And a small portion of your water rights will be used on the solar facility, is that correct?
Yes.
All right. If I were to combine the two, your cattle operations in the future and the solar facility, will you collectively use more water, the same amount, or less water than you do today?
Less.
All right. Do you know what happens if you use less water? Are you able to keep the excess water that you're not using?
Yes, we hope to bank it into a trust.
Okay. So where will the water go if you're not using it? What happens to it?
Well, it sits there in the aquifer, and we kind of hope it recharges itself. Hope the water table will come up.
Okay. Will the ranch be more profitable with the lease revenue and the focus on cattle?
Yes.
And you'll still grow alfalfa?
Some, yes.
All right. Will this solar facility interfere with your access to your land?
No.
Is it a visual impediment, or will it block your views of scenery, hilltops, or any other high-value view sheds?
No.
Okay. What about construction dust? Is that going to interfere with your farming and ranching?
No, I don't think so. The farming, we're disced and it's dusty anyway when you're farming, so about the same.
Even so, if conditions could be imposed that required injects to keep their construction dust down, would you support that?
Yes.
Okay. Now, as for this facility interfering with area traffic, are there lots of farms and ranches in the Wautoma Valley with trucks, fertilizer trucks, combines, harrow beds, and the like?
No, we're the only ones in the valley.
Okay. Is the area heavily populated otherwise with just residents that create a lot of traffic?
No.
Okay. Are you concerned that construction activities on the project will adversely impact any traffic out there?
Probably only impact would be the employees coming in the morning to go to work. That's probably the only time they'd be impacted on the 241 and Wautoma Road.
Okay. Would you support a condition being imposed on the project that requires them to have a traffic plan?
Yeah, they probably should have something.
Okay. Will the lambing sheds and pastures still be available every spring for the mother sheep and lambs?
Yes.
All right. What about smells? Is this project going to give any odors off?
No, I don't think so.
All right. How about noise? Do you know if it is required to comply with noise requirements of state law or local law?
Well, I'm sure there'll be some noise, but it'll all be down deep into our valley, so up west you probably wouldn't really hear them.
Okay. And by the way, there are already 2 state highways in the neighborhood, correct?
Yes, 241 and 24.
All right. Are there any utility structures in the area now?
Yes, there's probably at least 3 big power lines go through, and then probably 2 smaller power lines that go through our valley.
Okay, and you have the Hanford Nuclear Reservation to the east.
Yes.
Are there any substations in the area?
Yes, north on our property, there's the Wautoma substation.
Okay. Do you recall when that was built?
Not exactly. It was probably built, well, we didn't get, well, that's a good question. We didn't get electricity until the 50s there at the ranch, so probably then.
Okay. Is this project incompatible in any way with the ag uses in the Wautoma Valley?
No.
To the best of your knowledge, is this project going to require any new public roads that have to be built that taxpayers will have to maintain?
No.
Now, does Robert Ranch pay property taxes to the county?
Yes.
Do you get a reduced rate because it's ag land?
Well, when you talk ag land, a lot of people think of, farming, irrigated ground. But most of our ground is range grounds, and that's not worth very much, so the taxes aren't very high on that.
Okay. Mr. Robert, will having the second stream of income from the leases support your family's ability to stay in cattle and farming?
Yes.
And do you expect Interjex to return the property to your family at the end of the lease in substantially the same condition it is today so that it's available for ag use?
Yes.
All right. Would you support this council imposing conditions that require them to do that?
Yes.
All right. Do you want them to have to post security to guarantee that the money is available to do that in the event they don't do it?
Yes.
All right.
Is that right? Could you repeat that? Sorry.
Would you support a condition that requires them to post a bond to guarantee that it gets decommissioned and restored?
Yes.
All right. So my last question is the Wautoma Solar Energy Project putting an end to over 100 years of farming and ranching in your family?
No, it'll keep going. Our farm will still keep going.
Okay. Is there anything else you would like this council to know?
Well, I just want to say, keep talking about 3,000 ag land. Well, that's about 740 of irrigated ag land. The rest of that inside the solar is just either old CRP ground or range ground.
Okay. Thank you, Mr. Robert. I know this was long. We're going to keep you under oath because the judge is going to allow the council and chair and perhaps himself and the attorney for Benton County to ask you any questions. So please don't hang up or disconnect, and you're still under oath.
Okay.
Okay. Before we allow cross-examination, I did need to rectify an oversight with the last witness. Mr. Crowell, are you present, sir?
I am present, Your Honor.
I did not give you an opportunity to cross-examine Mr. Jossard. I went directly to the counsel. If you had any questions for that witness, we can recall them, as you obviously are party of interest and have that right. Did you want me to recall the witness after we finish with Mr. Robert, or did you not have any questions for him?
I don't have any questions for him, Your Honor. And also, for the record, I believe the previous witness as well, the similar thing happened, but I did not have any questions for them as well.
Thank you for the clarification. My apologies for the oversight. That was not intentional by any means. So,
it's quite all right.
Okay, very good. So thank you for clarifying that. Ms. Holt, any cross-examination of Mr. Robert?
Yes, thank you. Mr. Robert, sounds like the property has been in your family for generations. Did you grow up out?
Yes. Well, I moved between 3rd and 4th grade from Yakima to the ranch. Yes.
And this is a question. I think it was muted before the end of that, so it doesn't reflect it in the transcript. Question.
Pardon?
Ms. Holt, I believe, muted before the end of the question made it through, so the transcript reflex, did you grow up out, and then a dash.
My apologies. I'm trying to keep that feedback to a minimum. My question was, did you grow up out there?
Yes.
Okay. Did you go to school out in that area?
Yes, starting fourth grade, I went to school at Sunnyside.
Is your school located nearer to the farm or out in town?
It was in the town of Sunnyside.
Do you live at the farm now?
No, I don't. I live in Grandview.
Okay. Is it common for people in that area to live at their farm or nearby?
At least one person, yes.
Is it helpful? Do you think it's helpful for farm operations to be able to have that closeness between their residents and their workplace?
Yes, especially at this time of year. Somebody's got to be on the ranch. You have to watch out for range fires.
Does your family still keep sheep on your ranch?
No, we got out of the sheep business back in 1988. But the last 3 years, a gentleman, Sean Bryan, is bringing sheep to the ranch at the sheep sheds and been lambing there in the spring.
How come your family moved away from sheep?
Well, my uncle and my dad retired. They're in their 60s, and they wanted to sell the sheep. My brother Gene and I are more farmers and enjoyed cows. And it was getting hard to find sheep herders and go up to the mountains for range. It just got harder.
Is sheep ranching profitable at all?
Not right now. There's good years, bad years.
Does sheep farming take up much water?
No.
How about cow farming? Or ranching, sorry.
No, they figure a cow in the summertime takes about 15 to 20 gallons a day. Well, that's not very much water.
And in comparison, how much would something like dryland wheat farming take in a day?
Our time? Dryland. What? Sorry. Are you talking about water?
Yes. How much compared to...
Mr. Robert Lowe, to fully ask the question, even if you're going to ask. Hold-time feedback is terrible. Can you please mute yourself? Just the interim while we set the record. Mr. Robert, even if you guess what she's going to ask, which is perfectly normal, still wait till she asks it. That way the record's clear, sir.
Okay.
Please re-ask the question, Ms. Holt, then mute yourself, then allow the witness to answer. My apologies for having to do this, but it really is impactful on the record.
And I apologize for that, Your Honor. I haven't really run into that issue recently. The question was, in comparison to cow ranching, does dryland wheat farming take more or less water?
Well, dryland wheat only takes rain. We don't irrigate dryland wheat.
Based on your knowledge of the property, what other crops are appropriate to be grown on your property?
Well, pretty much anything if it had the water. You could raise apples, cherries, pears, mint, all that type of thing. But without water, you can't have those things.
And which kind of crops require less water?
take less water.
Are grain crops profitable?
Not now.
Are there risks associated with farming these various available crops?
Danger? No.
Not necessarily danger, but risk in terms of financial risk.
Yes.
What are some of those risks that you see over time?
Well, if it's a grain crop and you plant the wrong one and there's no price for it, or if you have bad weather, the yields are terrible, then you're in financial trouble.
Okay. Is frost a risk that could affect your crops?
Yes.
Based on your knowledge over time, is frost a risk that happens every year?
No.
Recently, it sounds like you've changed a little bit about your crop choices and your land uses. What are those changes most recently?
The biggest change is from alfalfa to, for hay to grain crops for hay.
Will you continue on farming in accordance with those changes if the project is not approved?
Yes.
If the project is not approved, do you have plans to continue ranching on your property?
Yes.
If the project's approved, would that put you in a better position financially?
Yes.
Would it be fair to say you have an interest then in the approval of this project?
Yes. Yes, we do.
I don't have any further questions.
All right, Mr. Kroll, before I forget, any questions of this witness before we turn it over to the council?
Thank you, Your Honor. I do not.
Very good. And then as before, council, please raise your hands, and we'll go ahead and see if there's any questions. Mr. Livingston, please go ahead.
Mr. Robert, you mentioned the additional ponds you might build would be good for firefighting and also perhaps elk. Do you have an idea of what the elk's behavior will do with the land use change on the property? How will they change their behavior to the new project if it gets built?
Well, they won't be coming into our irrigated fields and eating our crops. I know that'll happen. But they'll just move up more on the hillside.
I think that's all I have for you. Thank you, sir.
Thank you.
Any other questions from the council? We'll go ahead and give you Chair Drew, please.
Thank you. Thank you, Mr. Robert. Appreciate you being here. You mentioned that in 2020, was that the year that Interjects first contacted you about the potential of a solar farm on your property?
Yes.
And at that point in time, it was an allowable use in the county?
Well, that part I don't know. They approached us about solar, and I thought it was something that could be done in Benton County. I guess they didn't. That part I wouldn't know. I guess I thought it was just something you could do.
Yeah, the record shows that that did not change until December 21st, 2021, when the county put a moratorium or banned the development of solar facilities major on ag land. In that time period, when the Interjects first contacted you, do you know of or do you think the county was also aware of the project?
That part I don't know.
Okay. Did, as the ordinance went forward in the county, did anyone from the county reach out to you and ask you about this project or what would happen to you and your property if that ordinance went forward?
No. We just knew if there's sorry.
Go ahead. No, go ahead.
I was going to say, we knew it was going to probably take out quite a bit of the irrigated and some of the dry land ground and the CRP ground. But we knew we already had problems with irrigation, so in some ways it'd be a help for us, the solar.
Right, but no one from the county reached out to you while they were considering that ordinance to ban solar, did they?
No, we just went to a meeting that December there at Prosser and listened to the commissioners and the public and their views of the solar and the wind power.
Did you testify?
Yes, I did.
Okay, thank you. In your knowledge of the county's activities, do you know of anyone who has changed their land use, not farming anymore, but perhaps putting a business or a winery or some other type of business on their property, where the county has required them to replace the agricultural use that was on the land before by perhaps purchasing other land or making other land agriculture? Have you ever heard of that?
No, I haven't.
Okay. Thank you. That's all.
Very good.
Sure.
Any other questions from the council members? All right. Ms. Anderson, any redirect of your witness? Ms. Anderson, you're mute if you spoke. Ms. Anderson, if you responded, I didn't hear you. Do you have any redirect of your witness?
I do not. Can you hear me?
I can hear you now. Thank you.
Thank you, Mr. Robert. I don't have any further questions.
Okay. Ms. Anderson, that was of the listed witnesses. Does the applicant rest?
Yes, we do. Thank you.
Okay. We have been...
Thank you.
Thank you, sir. We're at 2 hours into it. I propose we just take a 5-minute, start back up at 2 o'clock for Benton County's case in chief. If everyone needs to stretch their legs, take care of other business. The hearing's going to continue to run for the next... Well, I'm sorry, it's 2:10 rather, not 1:50. That's the time. Let's rejoin at 2:15, but the record will run during that 5-minute interim. So everyone, please be back at that point.
Thank you, Your Honor.
It is 2:15, so everyone go ahead and reconvene and pick up with Benton County's case in chief. All right, I'm going to confirm that the participants are present. Ms. Owen, once I'm finished, I would ask that you do the same with the council. Ms. Holt, please, appears you're back, and can you hear me? Just nod your head if that's the case. Thank you. Ms. Anderson, are you back as well?
Yes, I am, sir.
Mr. Crow?
Yes, I'm here.
Thank you. And the court reporter, Mr. Botello, are you present as well?
I'm here, Judge.
Thank you. Ms. Owens, if you'd go ahead and do a roll call of the council.
Certainly. Chair Drew?
If she's not back, should I continue or wait till she returns?
Let's wait till Chair Drew returns, please.
Thank you.
Chair Drew, are you back?
I am. Sorry if I was a moment delayed here.
No problem. We just didn't want to start without you. Ms. Owens, if you go ahead and complete the roll call, and we'll go ahead and pick up.
Absolutely. Chair Drew?
Present.
Department of Commerce?
Elizabeth Osborne, present.
Department of Ecology? Department of Fish and Wildlife?
Mike Livingston, present.
Department of Natural Resources?
Lenny Young, present.
Utilities and Transportation Commission?
Stacy Brewster, present.
Benton County?
Dave Sharp, present.
Department of Transportation?
I'll unmute myself. Paul Gonseth, present.
That is the entire council.
Thank you, Ms. Owens. And once again, since we were briefly off the record, even though the recording was still continuing to run, I did not have any conversations with any of the party participants, witnesses, or council members during that brief break. If anyone disagrees with that statement, please take yourself off, or please raise your hand rather, and we'll go ahead and build whatever concerns you have or disagreements into the record. I'm not seeing any, so let's go ahead and move on to Benton County's case in chief. Ms. Holt, please call your first witness.
Thank you, Your Honor. I would call Greg Wendt.
Good afternoon, Mr. Wendt.
Good afternoon.
Have you been present throughout the entire proceedings?
I have.
Do I need to go over the instructions of what's expected of a witness in these proceedings, or can we forego that?
We can forego that. That's fine.
Then please raise your right hand, and I'm going to swear you in as a witness. And do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, and the penalty of perjury?
Yes, sir.
You're under oath. Ms. Holt?
Thank you.
Can you say and spell your last name for the record, please?
Wendt, W-E-N-D-T.
Could you describe for us your educational background?
Sure. I have 2 planning degrees. I have an undergraduate degree from Eastern Washington University in urban and regional planning. And I have a master's degree from Washington State University. It's a master's in regional planning from their environmental department. So, and then, yeah.
What is your employment title with Benton County?
Director of Community Development.
How long have you been in that role?
I have been the Director of Community Development, I believe, for 2.5 years, and prior to that I was the Planning Manager.
What does this role entail?
Well, we deal with a lot of different things here at the county in the Public Services Department. We focus on land use, planning, code enforcement, building, as well as canine shelter services.
Can you describe other past employment experience that might be relevant to municipal planning?
Sure. My planning experience goes back as early as 1994 through different internships with different cities in the state of Washington. And then I started working full-time as a practicing land use planner. I have experience in 3 different states, but I started in 1997. So I have probably 27 years plus of everyday experience and 25 years in the state of Washington.
Switching gears to the project, do you recall receiving the Exhibit 4, the July 26, 2021 email from Interjects to you?
I did find that email when we went back and started in November of that year when we started processing the text amendment to the GMAAD zone. And we had that, we received their public comments from that company. It raised a question with us here in the office, and I did go back into my emails. I did find that old email, yes, at that time.
Was this email your first awareness of the applicant's project, or was it at a different time?
Well, I didn't, back in that time, we received many different phone calls from lots of different companies asking about different projects. I didn't remember that email. And so the first time I learned about this project was in the days leading up to the code change.
Did the applicant ever reach out to you to follow up on that email that you're aware of?
No, I think the only time I ever really spoke to them was potentially at the hearing itself. And I may have spoken to them again very briefly at the FSEC land use hearing. But we've had lots of conversations with different companies, so not sure.
So once you started communicating with them around the time of the code change, were you ever asked by the applicant about how they could work with Benton County to develop this project within our Benton County codes?
I did not ever have that conversation with this company that I'm aware of. No.
Other than objecting to the code change, did the applicant ever reach out to you to ask about modifying the Benton County Code in any other areas that would allow for this project?
Not that I remember, no.
Based on your understanding of the proposed project site, what is the classification of the lands that are subject to these proceedings under the Benton County Code?
Well, the property is currently zoned GMAA, agriculture, and then the comprehensive plan has it designated as GMA agriculture as well. And with that, in our comprehensive plan, it has been designated agricultural lands of long-term commercial significance, or we refer to that as ALTEX.
So the comprehensive plan covers many areas, but with regard to these ALTEX lands, what is the purpose and intent of our comprehensive plan?
Well, our purpose is to have the Growth Management Act came into play in 1990, and it issued a lot of different mandates to cities and counties, of which is to have a long-range planning document to framework and provide on how your lands are going to grow, how your properties in the county are going to grow, how your community is going to grow. And so certainly the long-range comprehensive plan lays that overall foundation that then we can implement through zoning and development regulations that we're all additionally required and mandated to do.
Sorry, I forgot to unmute myself there. What percentage of Benton County is made up of GMAD lands?
I believe it's about 58%. I would have to look in the comp plan. I don't remember all those numbers off the top of my head. Things I can easily look up, I don't always remember, but I believe it's about 58%.
Okay, if I can show you what's been marked as our Exhibit C, perhaps that would jog your memory here. I'll try and share my screen with you. Are you able to see that?
Yes.
Okay. And And in that table, under the Growth Management Act Agriculture, what is the percentage shown there?
I believe that's 58.96.
If I could move on to another page here, what does this document depict?
That is our. That is from our comprehensive plan. It was from our periodic update, and I believe this was showing our comprehensive land use for our previous comprehensive plan, with the next folio map being the current plan.
Can you describe what the light green portion of this map represents?
Sure. That is our Growth Management Act agricultural zone, whether it's our zoning or our land use designation in our comprehensive plan. It's also the lands that have been designated Altex based upon the criteria in our comprehensive plan.
Is the project area located within this light green area?
Yes.
Can you summarize for us how the comprehensive plan addresses GMAD lands?
I summarize, well, our comprehensive plan, was two different parts. Back in 2018, we adopted our Altex memo, and so when we came in and we started working on updating all of our plans, one of the things we really wanted to do is ensure that our Growth Management Act agricultural lands were designated correctly. And so we hired a company, we worked with them, worked with our planning commission, and worked with our community to come up with that memo and that reclassification document that was done in 2018. And that became a big part of our comprehensive plan, kind of the foundation for our 2018 periodic update that we did complete. And it does, we do have our goals and policies in our plan, and it does talk about how our uses are going to be limiting incompatible uses and having the uses that are allowed in our agricultural areas to be accessory to ag, and that's really, really important. And so our Altex and that document that is an appendix in our comprehensive plan really provides the framework and foundation for how those areas are to grow and allow development.
So would it be fair to say that this new information coming in around 2018 impacted the county's views on what is an acceptable use in these areas?
I believe so, yeah, because in 2018, we kind of started that process of evaluating our Altex, reaffirming them, and then that kind of led us to conversations over, from 2018, we did the readoption, and then in 2019 and 2020, we started looking at our different codes and ordinances as we were doing our development regulations, and certainly the GMA Ag Zone and the allowed uses were some of the things that we did look at.
And how did Benton County react to this new information? Did it begin updating its code?
Well, yeah. I mean, as with the adoption of our Altex and the reaffirmation of them, over the first, I believe that was in about 2020, is the first time I can remember us sitting down as a community with our volunteer boards and having the conversation about our agricultural lands and looking at the different uses that maybe don't make as much sense anymore to have in our, whether they're conditional use or an allowed use. And then certainly as we continue to move on in 2021, the decision was made to move forward that, it was determined that legally we were going to really struggle allowing and permitting based upon the compatibility test, continuing to allow wind and solar commercial facilities as a conditional use permit option in our GMA-A&D zone. We knew we had to make that change.
Okay. And so specifically when we're talking about solar facilities major, when did that discussion start?
We started that discussion. We started that discussion in 2020 originally, and then by, I don't know, probably the summer of 21, we had put in works to start the process of evaluating our different zone to see where we could integrate wind and solar rather than in our agricultural lands, because we knew that legally we couldn't permit a wind and solar commercial facility in our GMA-A&D zone. We knew we had to have that removed. There was no way that we could, with the size, scope, and impacts of those projects, as it related to our Altex, they weren't compatible.
And Ms. Holt, this is the court reporter. The interruption there, that last tidbit didn't make it into the transcript. Just want you to be aware that you added at the end.
Understood. So when these discussions started, did you have knowledge of the applicant's project, even generally? Did you have any knowledge about the lease that Wautoma had with the Roberts Ranch?
When we started these conversations, I had no inkling whatsoever about a Wautoma project.
As these discussions started going along, what effort does the county usually make to do public outreach for people that might be affected or allow for public comment?
Sure. I mean, and certainly if there were projects that we had had conversations with people about before we go to make an amendment, we certainly give people a heads up that we'll be doing that. We put notice in our, we do typical notifications that are required under the GMA if you're going to be doing an ordinance amendment. We put notice on our website, we do social media, and we do all the different things. And so certainly, yeah, I mean, in this case with this project, like I said earlier, I had not heard of this project until we started receiving public testimony and comments as we moved into December of that year.
And among those public comments, did the applicant or any of the affected parties reach out?
Not that I'm aware of.
Did the applicant make public comments with regard to the proposed code change?
At the hearing, yeah, there was a group of them at that hearing. Whether they all had any interest in the project, everybody who spoke, they were either landowners, related to landowners. I mean, it was typical what you see, in developer-driven environments like that. And so you have the developer and those people there. There was no other. The only people who showed up at those hearings were people who had an interest. I guess I'll just leave it at that.
So, can you detail the reasoning behind specifically why the county opted to remove the conditional use permitting for these solar facilities major?
Yeah, well, I mean, as I stated earlier, we knew we were going to have trouble approving a conditional use permit for one of these facilities in that zoning district. And so, I'll just go back to what the Board of County Commissioners in their findings of fact. The board has been really resolute in this the last 3 years. They in their findings of fact, they said that they wanted to comply with the state mandates, ensure consistency with our comp plan, which previously, and it's as the code had originally been set up prior to my arrival, it was not consistent with our comprehensive plan. So we wanted to ensure that consistency was there. We wanted to protect our alt-tex, conserve critical areas, habitat, and visual resources, protect our rural character, all while limiting incompatible uses and non-ag uses in our GMAAD zone. And that is what the county commissioners made in their findings. And I thought that was very, they've been very resolute in their thoughts on this.
What makes these sort of facilities incompatible with agricultural use?
Well, I mean, in land use world, the compatibility test in Benton County, you start to look at, you start the test with size, scale, scope, and location. And then you take that size, scope, scale, and location, and you compare it to outright permitted uses. Even if you go back into what is a conditional use, as basic as that, the requirement is no more incompatible than other outright permitted uses in the zone. The use can't be more incompatible than the other outright permitted uses. And so when you go through and look at outright permitted uses, and as it relates to, the size and scope and scale of a 3,000 acre industrial project being dropped in the middle of our agricultural area, it's not compatible. And when you relate it to the other uses are typically small. If you want to look at agricultural activities, all our permitted uses, agricultural stands, single-family homes, adult-family homes, just kind of touching on a few of them, even just an individual cell tower, a meteorological tower, a school, or a church. Those things typically occur on a parcel or two and are, and even if they're non-ag, we allow allowances up to an acre under the state GMA to do so. But it's very clear that the compatibility test isn't there when you relate it back to ag and the other allowed uses.
So of these allowed uses, there are some larger versions than a cell tower. Say, for example, is a private airstrip permitted?
Yes, absolutely. And we do see those. They're typically, they don't take up a lot of acreage, and most of the time they're related to agriculture. Whether they're providing services for that farm, or their spray, their spray feed, their spray airports. But they're typically, if they're out in our agricultural areas, they're typically related to agriculture. And in this case, it would need to be.
But the county did have these solar power generator facilities major as a conditional use permit option. Were those facilities compatible with agricultural use 10 years ago, 20 years ago?
No. Well, I can't say, I can't, in my mind, an industrial use, it's not. And I think that's been well documented. But, for the 2018 comprehensive plan, and that's what I'll just discuss from 2018, it's clearly not, especially with alt-tex and the conversion of alt-tex. That takes the compatibility test is done at that point in time. If you're going to convert agricultural land for proposed use, it's no longer compatible.
So, for some of the allowed uses, like the airstrip, why isn't the county requiring those applicants to create new ag land somewhere else in the county?
Well, typically they are those non-ag uses. There's an exception in the state law and under GMA that allows up to an acre where you can take that out. But the reality is with the example you're using, they're all related to agriculture, so that's never been an issue.
So, as it exists today, which portion of Benton County Code governs these GMAD lands?
Well, we have numerous things. We have our comprehensive plan. We have our zoning ordinance. And it's all under the umbrella of the Growth Management Act.
So, focusing specifically on Chapter 1117 of the Benton County Code, what is the purpose of that section?
Purpose is to, have uses allowed that are compatible with agricultural uses. I mean, I don't have the purpose written in front of me, but I can tell you that, the idea is to limit non-agricultural uses and encourage agricultural uses that are compatible with each other.
Would it help refresh your recollection if I were to share that statute regarding purpose?
Sure.
Are you able to see that? Or
Yeah.
would you like me to make it bigger?
That's fine.
Are there minimum requirements that the county must follow in creating its comprehensive plan and codes?
Yeah, we're under the umbrella of the GMA. So the GMA does lay out the framework that we are to have a comprehensive plan, have development regulations, and within that, we're to preserve and protect our resource lands and our critical areas.
So under the GMA, what is the state's interest in preserving GMA lands?
Well, the state requires us has the mandate for counties to preserve and protect our agricultural lands. And so we've done that in our comprehensive plan, and then we've implemented that through our GMA-AD zone. We've designated our Altex, and we've met that mandate to preserve and protect our ag lands. And that was reaffirmed in 2018.
Now, doesn't the GMA also have a mandate to promote conservation energy projects?
I do believe so, yes.
Is that goal in the GMA mandatory on the county?
I believe so. Certainly, the counties want to, just like everything else, all the other uses, have locations in our county to fulfill those requirements through our comprehensive plan and through our zoning requirements.
Based on your understanding of the GMA, does it require the county to allow energy facilities like solar in GMA ag lands?
No. Every community has the option to determining how, whatever framework you wish to have and guidance you want to give through your policies and through your regulations, you can place those in areas however you wish that make sense for you as a community.
Does the county have areas where these solar power generator facilities can be located?
Yes. We have two different levels of industrial zoning, as well as our unclassified zoning here in Benton County, where those can be placed as well.
Is the county's code stagnant, or is this something that is a work in progress?
It's always changing, and there's always lots of conversations around it. And so certainly we are in the process now of getting a new grant from the Washington State Department of Commerce for our periodic update. And so with that, we will be starting our comprehensive planning process, looking at all of our development regulations and fine-tuning our regulations, because we still have things in our agricultural zone in our CUP list that, to be honest, would be very difficult to approve because of the same reasons as the wind and solar facilities. And so we'll be looking at those and all of our different land use classifications.
If I can you see my screen still?
Yes.
Okay. With regard to the industrial areas where these solar facilities are currently allowed, can you describe where they are on this map?
We have some industrial down around Plymouth and Patterson, I believe, out in Findlay, and trying to remember where else. There's certainly not large swaths of it in the current state. Most of the large swaths that would be available for large acreage would be more in the unclassified areas and working with the out around the Hanford site, out around there.
If I can move forward to page 190, we see a change in the color at the top to dark gray. What is that area?
That is generally an area, it's the Hanford site, which is kind of the name, Department of Energy, but we do have it, it is unclassified in our zoning, and they do have lots of land out there that has been set aside for different developments related to renewable energy projects.
So what does this map depict? What is the purpose of this map?
This is our future land use map. So it has our land use designations providing our future growth in the county that is then implemented with our zoning map. But that is our current map.
If I'm reading this map correctly, the gray zone in the legend is listed as rural industrial. Is that correct?
I believe so, yeah. It's hard to see, but I believe so.
If this is the future plan for the county, would this sort of solar facility be permitted in that area?
Yes.
Stop sharing that and move on. Is renewable energy permitted under this code chapter generally, in any case? And I'm sorry, perhaps I should clarify, under Benton County Code 11.17.
Under 1117, ask your question once again.
Does Benton County Code 11.17 ban all renewable energy, or are some formats of renewable energy permitted?
Yeah, no, just the large commercial facilities. The ones that are accessory to a permitted use, those type we still allow in those areas. The small scale permitted use that are accessory to a permitted use.
Why does size matter when we're talking about compatibility with ag lands?
Well, I mean, you're talking about a large scale. You're talking about it's a compatibility issue between industrial and agriculture. And it falls back to what are those allowed uses, and how a project that is industrial in nature, if you're going to go in and place a 3,000 acre project and do the conversion of agricultural lands that have been designated Altex, that is the crust of the compatibility issue between agriculture and industrial uses.
We've heard some testimony that there seems to be a diminishing ag use for the specific lands in question here. Why doesn't the county just declassify these lands?
They still meet the test. The county in 2018 developed the criteria for our agricultural lands of long-term commercial significance. And as a community, that was adopted, and it has criteria, and the properties in question still meet it.
When we're talking about long-term commercial significance, does the commercial significance ebb and flow over time?
Not from a land use perspective, not from a county land use perspective. We have we have irrigated lands, we have dry land, and we have range land, and we treat them all equally, regardless of values or incomes. That doesn't. I don't know if that answers your question, but that's.
So if a farmer or rancher has a couple bad years, no rainfall, things of that nature, does the county come in and reassess the designations?
Oh, no. And it's not a site-specific evaluation at all. And it's directed at the state mandates us to look at this as a county-wide view of this and not a one project or one property specific evaluation. That's not how GMA is built. So no.
We've heard some testimony earlier regarding environmental conditions in both the application and the revised MDNS. Have you read through those?
Somewhat. I have reviewed them in the past. I haven't looked at them recently.
If this project is approved, would you like to see those put into place as conditions of approval?
Well, certainly anything. I mean, if this project was approved, yeah, absolutely. I mean, if that's what the state determined was the correct requirements under an MDNS, sure. But certainly, it from a land use perspective, it doesn't meet the test.
So are there any conditions in that table A5 or the revised MDNS that address the preemption of the GMAD lands if the application were to be approved?
No.
Are you recommending any conditions that could address that interest of the county?
No, it's unmitigatable. If you're talking about 3,000 acres converting Altex, that's unmitigatable. There are no conditions that can do that. And that was, the applicant explained that earlier, that they weren't planning anything, because you can't.
We've also heard some testimony that surrounding ag lands could actually benefit from the project in terms of being more financially able to farm. Does that address the county's issue with if the subject properties were to be preempted?
No, I mean, those type of conversations aren't taken into land use evaluations on whether or not a use should be placed someplace. I mean, the economics associated with that are not typically evaluated.
Is there anything else that you would like to share with the council today that you believe would be helpful in them making a decision?
Well, I guess, the Growth Management Act, it's in place. It's been in place since 1990. It gives us an opportunity as local communities to have comprehensive plans, to have development regulations, to designate our resource lands, protect those areas in our critical areas. And, the GMA is an effective tool that when it began, one of the major premises of it was to eliminate ideas of reactive developer-driven development, and for 35 years it's been very, very effective at doing that. And my hope is GMA's given the opportunity continue to allow communities to implement their comprehensive plan and have development regulations and long-range plans that make sense for each community.
That's all the questions that I have for you. The others may have some questions.
Good. Ms. Anderson, any questions of Mr. Witt?
Yes, Your Honor, just a few. Good afternoon, Mr. Wendt.
Hi.
Yes or no, do you agree that the first issue in this case is whether the council should recommend preemption?
Yeah.
Okay. And if the county is preempted, who actually makes that decision to preempt?
The FSAC Council.
All right. Would it surprise you if I said it was the governor?
Well, as we sit here today, they will be making a recommendation to the governor, but I wanted to give them their due respect today.
Understood. But who makes the final decision to preempt?
The final decision is made by the governor.
Okay. Thank you. So, now you testified earlier you're concerned with getting into legal trouble about allowing a use such as this in your GMAD zone, correct?
I think that was one of the concerns, is legally, how could it meet the compatibility test under a conditional use permit? Absolutely.
Could you be sanctioned if you violate the Growth Management Act?
I hope to never find out. I haven't for 27 years. I'm assuming they could, yes.
Okay. You said that you had been told that you could legally get into trouble. What were you going to get into trouble with?
Well, I don't know that. Maybe I probably misspoke a little bit, but certainly you open yourself up to challenge legally if you're approving conditional use permits that don't meet the test.
Mr. Wendt, do you know who is authorized to impose sanctions on a county under the Growth Management Act for violation of things like ag lands of long-term significance?
To be honest, I hope I don't find out, but I don't know right off the top of my head. I'd have to do some research.
I'm going to put up interjects exhibit number. Let's see. No. Yeah, but. I need to get into that. Sure. Okay, exhibit. This is for illustrative purposes only. You're pretty conversant with the Growth Management Act, correct?
Wait, tell me what exhibit this is first, please.
I'm sorry. It would be applicant exhibit 29, used for cross-examination regarding the witness. And he's testified extensively about the Growth Management Act, legal requirements.
There is no applicant exhibit 29. One at the 27.
I'm putting it up now for illustration. We didn't know he was going to go there in his testimony.
So it's not. So it's not an exhibit, is what you're telling me?
I would offer it as an exhibit, but I'm not. I am offering it for illustrative purposes.
Okay, if you're offering it into the record, then you need to offer it and see if there's any objections to the admission, and then we do it. If you're doing it for illustrative purposes, then I need to know why it would be necessary. You simply can't reference it without demonstrating the document that's not in the record.
All right, I will offer it for admission. It is part of the Growth Management Act laws, and it is citing statute WAC 365, which is Growth Management Act 196560.
Okay, are you offering it as applicant's exhibit 29, even though the exhibit 28 was not offered?
I can offer it as 28, sir.
It would make better sense if that is the case.
Agreed.
Okay, so I'm going to see if Ms. Holt, any objection to the admission of the citation of the WAC?
I'd like to reserve objection until I understand the relevance of this, but otherwise, no.
Well, if I admit the document, if you have no objection, you can't come back and object to its relevancy to the admission of it. You could object to the discussion of it afterwards, just so we're clear as to what's going to happen if you don't have any objections at this point.
Yeah, I don't have any objections to it being in an authentic summary of that WAC.
Do you have any objections to admission into the record as appellant's exhibit or applicant's exhibit 28?
No.
All right, Mr. Corral, any objection to the admission of that document?
I don't have any objections.
Okay.
Your Honor.
Yes, sir.
Reporter, I don't have a response from Ms. Holt. If there was.
There was. Ms. Holt, would you please repeat your response to your objection to the admission of that document?
Yes, my apologies. I do not have an objection to admission.
Okay. Did you, Mr. Bartholomew, did you get that?
Yes, Your Honor, thank you.
All right. Ms. Anderson, I would ask that you submit that document in the same manner in which you submitted the other documents, and we will make available to the council for consideration.
Thank you, Your Honor. I will do so.
Thank you. Please continue.
Mr. Wendt, would you please take a moment and read the document in front of you, specifically subsection 1?
That's fine. I've read it.
Where in the Benton County Comprehensive Plan and Development Regulations do you accommodate situations where the state has explicitly preempted local land use regulations, for example, citing major energy facilities?
Well, we do allow the citing of major energy facilities in Benton County. And as for that statement, as far as I'm aware, there is no standard for that in a county code.
So let me ask you, this provision says making provisions for all local land use regulations. Doesn't 11-17-070 not account for FSEC's role in citing energy facilities?
Yeah, and we're not arguing that FSEC has the ability to preempt.
But you are, I'll leave it at that. Thank you. You can put that down. You briefly referenced a map that showed a large area that was dark gray, and you identified that as unclassified, correct?
Yes, I believe so.
And that you will make it lawful in the future to put solar here, is that correct?
No, in the unclassified zone, they have the unclassified zone has the ability to have certain allowed uses and conditional uses from underlying zones, such as the industrial zone or different zoning districts. So you could potentially place a commercial wind and solar facility if you met the test in one of those zones in the unclassified zone.
And who owns that land?
The federal government.
All right. Do you know what the standard is in the event of preemption? What should inform the conditions that the council should consider?
Repeat your question.
Do you know what standard the council should embrace if they decide to put conditions on site certification in the event of preemption?
I don't know what there used to be criteria for a preemption in the state law, but that was removed, so I don't know what standards they use.
All right. Would you put up 851 then if I have it? But I'm going to put up a different exhibit, Your Honor, Counsel and Mr. Wendt. Does this help refresh your memory?
Counsel, just for the record, is that Exhibit 22? It's already been entered into the record?
Yes, sir. Yes, sir. I'm sorry. It's Exhibit 22.
Thank you. Please continue.
So, Mr. Wendt, should the conditions that are imposed if the council recommends preemption, should those conditions reflect community interest?
That's not for me to say.
Okay.
I've made the statements that, based upon Benton County Code, that it's not consistent, it's not compatible, it doesn't meet the test, it's converting ag lands. Those things, whatever standards the council wishes to place on this it's their permitting process.
All right. You testified earlier that people comment and engage on development of changes in county comp plans and regulations, correct?
Yes.
And do you recall being at the December 21 public hearing when the Benton County Commissioners adopted the ordinance that removed major solar from the zoning provisions?
I was there.
Okay. I'm going to put up exhibit number 11 on the screen, Your Honor, Counsel, Mr. Wendt. Now, I believe that you said earlier that the only people that showed up that night were the people who had an interest in their property, right?
Yeah, that was what I remembered, yes.
Isn't that how it should be, that people should show up if they care about their property?
Absolutely.
Great. So, how many people that showed up on December 21, and you can move to exhibit page 4, how many people that had an interest in this property showed up that night to support the change?
I don't know.
In fact, if you take a look at the exhibit in front of you, won't you see that everybody that testified about this ordinance opposed it?
I do remember that.
All right. Would you say that that reflects the community interest in the outcome of this zoning ordinance in this neighborhood?
It was a very small fraction of people in the overall county when dealing with a significant change to protect our Altex.
Would you please answer my question?
What's the question?
The question was, doesn't that reflect the community interest of the people?
Well, the people
that testified.
Well, hold on. Ms. Anderson, you just changed the question. So if you want to ask the question, wonderful, and let the witness answer it. Don't move the goalpost when he starts answering, please.
Did all of the people who testified in opposition have an interest in the outcome?
I don't know.
Didn't you testify earlier that the people...
That was my recollection when asked.
And Mr. Wen as well. Please allow her to fully ask the question, even if you anticipate. This isn't a conversation. We still need to make sure the record's clear, sir. So, Ms. Anderson, please fully ask the question, and allow Mr. Wendt to answer.
Mr. Wendt, I'm trying to figure out which is true. That it was the people who were interested that showed up at that hearing because they had an interest in the land? Or was it the people who were interested at the hearing because they had an interest in the land? I asked that two ways, the same question. Because earlier you testified that only people who had an interest in this ordinance showed up. Isn't that correct?
That's what I remembered. I haven't gone back and looked at the minutes. I haven't thought about it in 3 years, so I'm going by recollection.
All right. Have you read the county's brief in this matter?
Can you repeat your question?
Yes. Have you read the brief that the county filed in this matter?
Yeah.
One more exhibit, Your Honor, Counsel, Mr. Wendt. I'm going to ask that Interjects Exhibit 15 be put back up. Mr. Wendt, did you receive this document? It's the SEPA staff report.
It's not published yet, Counsel.
It's coming, sorry.
Excuse me.
Can you see it now?
Yes.
All right. Did you receive this document?
Yes.
Did you read it?
Yes. Well, wait, back up. This is the actual recommendation that came back after the SEPA determination?
No.
Can you move down on the document so I can see the document? Our office did probably receive that. I don't specifically remember reading that document.
How long have you been, have you ever been a SEPA responsible official?
Yes.
Is this project a matter of concern to the county?
Yes.
Is there any reason why you didn't read this document?
Well, Michelle Mercer is currently our SEPA responsible official. But back on that date, what date was this issued? Just trying to determine who the SEPA responsible official was.
We'll go to the top. I believe it was in May. There we go. May 15th.
That one? Okay, yeah. Well, and certainly if it was a Benton County project, for sure, absolutely. She would have been the SEPA responsible official for a project in Benton County.
Okay, so you don't know why Benton County, did Benton County comment on this MDNS, if you know?
No, we did not.
Why not?
Well, we have only so many resources to spend on projects like this, and so certainly we chose to spend it, on the project was incompatible. It's prohibited. We decided to spend our resources focusing on the land use issues of the adjudication rather than the SEPA review. With limited resources the county has, that's how we focused our time.
I have nothing further. Thank you.
No problem.
Mr. Kroll, any questions of Mr. Witt?
No, I do not.
Okay. And again, board members, or council members rather, if you have any questions, please raise your hand.
Did he help their comments or questions?
Ms. Anderson, you're not on mute, so just know that whatever side of our conversation is being heard by everybody. Thank you. All right. Mr. Young, go ahead and ask your question, please.
Good afternoon, Mr. Wendt. At the time that the county did its GMA land designations, what proportion of all the agricultural land in the county was judged to have long-term commercial significance?
The county designated, through the study that was done, I know we saw earlier 58% of the county was GMAAD. The entire 58% was designated that, and ag land, with our ag lands, our irrigated, our rangeland, and our dry land were considered equal.
So there were no agricultural lands that were judged as not having long-term commercial significance?
That is correct.
Thank
you. Any other questions, Mr. Young?
No further questions. Thank you.
Mr. Gonseth, please ask your question.
Thank you. So my question is your ag designation consistent with your surrounding counties and the rest of the state as only having one designation as opposed to a couple designations?
I can't speak for the other counties. I can tell you that, I guess I could. I'm not going to speak for Yakima or Walla Walla. I can tell you over in Franklin, that would be the case. It's very similar to that. Both Benton and Franklin are very similar setups in terms of their agricultural lands and having one designation.
Thank you.
Any other questions from the council? Chair Drew?
Thank you. Mr. Witt, you mentioned that there are census ordinance that banned major solar facilities from the agricultural zone. There are 2 other places under county jurisdiction where there could be a solar facility major that is allowed. Is that correct? That's the light industrial and the heavy industrial.
And the unclassified.
Is unclassified under your jurisdiction or under the federal government?
Part of it, the permitting is, in parts of it, it is, parts of it still does get permitting through Benton County.
What's the acreage of that part?
Thousands. I don't know. I would have to look it up.
Okay. But in the light industrial zone, there's 1,333 acres, correct? That's what I saw on the chart?
Probably, yeah.
And in the heavy industrial, there's 2,334 acres.
Okay.
So do you see actually the potential for any major solar facility to site within those districts?
Well, light and heavy, probably not the way it's currently set up. It could change as we're going through our periodic update, and that's what we're
at this point in time.
And certainly with the unclassified zone, and there's lots and lots of land out there with the federal government, and developers have been working with them to do these projects in Benton County, and those are projects we fully support.
Under Benton County's jurisdiction, you don't know the acreage of the unclassified, but of the classified that was listed, 1,333 acres in light industrial and 2,334 acres of heavy industrial. That is where you would direct major solar facilities, but then you just said that wouldn't be a good place for them.
No. We allow them in light, heavy, and unclassified.
But there is not the appropriate acreage there for a major solar facility, is there?
Where?
In light or heavy industrial areas. The acreage is too small.
I don't design solar facilities. If they can put one in there, that'd be great. We've talked to people out in some of our industrial lands about putting in solar facilities, and
So you don't know anything about what a solar facility needs. Is that correct?
No, that's not true. I'm just saying that there's different sizes. We have the Wautoma solar project is 300 acres. So, I mean, there are projects that you can place in some of those areas.
Okay. So, but overall,
pardon me, Your Honor, I'm having trouble.
Yeah, we're kind of speaking. We're kind of speaking over each other and not letting people fully answer questions. Mr. Bartholo, what part do you need repeated so we can get the record clear for you?
Let's see. last sentence of the witness, so I meet, there are projects that you can place in some of those areas. Chair Drew, okay, so, and then that's when I interrupted.
Okay. Mr. Wendt.
Let's just withdraw the rest of that.
Okay, that it is stricken. Thank you. Please move on. Any other questions, Chair Drew? Chair Drew, any other questions of the witness?
No, that's all. Thank you.
Okay. And then, Ms. Holt, any redirect of your witness?
If I could, just briefly, Mr. Wendt, if I share with you the comprehensive plan here, in just a second. Can you see that document?
Yes, ma'am.
Oh, wow.
Okay. And in that table 3.4 there, can you describe which areas are zoned as classified, or I'm sorry, unclassified?
The Hanford.
Could I have a repetition of the answer?
Yeah, I didn't hear the answer either. Would you please repeat that, Mr. Wendt?
Hanford, I believe it's Hanford and the Hanford Reach are both unclassified.
And then looking at table 3.3 above, for the Hanford site and the Hanford Reach, what is the acreage within those land use types?
Oh, pardon me. Your Honor, I don't have the end of that question.
Yes, Mr. Wendt, you need to wait until the answer is fully asked. You're kind of jumping the gun on it. Ms. Holt, please re-ask the question.
In the table 3.3, under Hanford site and Hanford Reach, what is the acreage there?
265,567, I believe, and the other for the Hanford Reach is 12,443.
That is all the redirect that I have for him. Thank you.
Thank you. All right. And Ms. Holt, please call your next witness.
For my next witness, I would like to call Michelle Mercer.
Very good. Good afternoon, Ms. Mercer.
Good afternoon.
All right. Do you have camera capabilities?
Yep.
Would you go ahead and turn it on? I'm not sure if you're in one of the screens that I don't have up.
My camera is on.
I can see it now. Thank you. You're on the second page for me. Have you been present throughout the entire of the proceedings?
I have.
Have you heard the instructions that were given all witnesses?
I did.
Do you have any questions about what's expected of you?
No, sir.
And please raise your right hand. And do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, under penalty of perjury?
I do.
You are under oath. The one thing I would ask that we've been experiencing with is, even if you know what the party's going to ask, don't answer immediately. Just wait until the question's fully asked. That way we have a nice, smooth transition of question and answer. Thank you.
Understood.
Ms. Holt, please begin.
Thank you, Your Honor. Ms. Mercer, can you say and spell your name for the record?
Michelle Mercer, M-I-C-H-E-L-L-E, last name Mercer, M-E-R-C-E-R.
Could you tell us about your educational background?
Sure. I attended Portland State University and graduated with a Bachelor of Science in Geography and a minor in Community Development, which is their equivalent of planning.
What is your employment title with Benton County?
I'm currently the Benton County Planning Manager.
How long have you had that role?
I've been in this role for 2 years, and I've been with the county for 9 years.
And what does your current role entail?
I currently manage a staff of 7, including the code enforcement officers, and I handle all of the long-term plans for the county, as well as helping customers at the counter and general land use planning activities.
Do you have any other past employment or other experience relevant to municipal planning?
Yeah, I currently serve as the president of the Washington State Association of Counties and Regional Planning Directors. I'm also on an advisory group, the Fish and Wildlife Biodiversity Area and Corridors Practitioner Group.
And then, do you have any personal experience with the agricultural community?
I do. Prior to working for Benton County, I was a farmer in Africa as well as a fish farming Peace Corps volunteer for the U.S. government. Prior to that, I worked in forestry nonprofits, natural resource conservation groups, and as a wildland firefighter for the Forest Service. I also am a fifth generation local farming family here in Benton County. Our farm is located in the southern part of Benton County, and we also have a winery and crosser.
Based on your personal, professional, educational experience, do you feel like you have an understanding of the interests and policies related to ag land on a county and state level?
I do. I feel like I'm uniquely positioned in this role at Benton County to understand the concerns and needs of the farmers while understanding the state's Growth Management Act and laws surrounding land use practices. And I try my best to marry the two where I see fit. I often have to explain to the agricultural community that some of their ideas aren't able to be implemented in the agricultural zone, and I am very well suited to explain why and let them know from a professional level, but then also empathize with them on a personal level as my family relies on farming as an economy as well.
So we're here today because of one of those ideas and requests. When did you first become aware of the Applicants Project?
I first heard about Interjects. I received a phone call from a resident who had received some sort of piece of mail, and he was inquiring with me regarding if I had heard about it or knew anything else of the project. And I believe that was in early July, about a month prior to the company reaching out to Greg and our generic planning department's email that I wasn't aware of.
Ms. Mercer, can you tell me the year, please? You said July, but that's rather...
July 20, I think it was July of 2021.
Please continue, Ms. Holt.
Thank you. And when did the resident or the neighbor reach out to you? Do you recall about what month?
That was in July. I want to say it was maybe July 7th.
And when they reached out to you, what was your takeaway with did they have any concerns? Were they just informing the county? What was the purpose of their call?
They were looking for more information and wondering what the county regulations were at the time for such a project.
Based on your understanding of the proposed project site, what is the classification of lands that are subject to these proceedings today under the Benton County Code?
The lands are zoned GMA Agriculture District.
Did you hear the testimony from Mr. Wendt regarding the county's history regarding GMAD districts?
I did.
Do you have anything to add regarding the county's history on designating GMAD lands that you believe will be helpful for the county, for the council today?
The only thing that I would add, since I've been here the longest, Mr. Wendt and Mr. McPherson, our county administrator, came over to run the planning department about 2 years after I started. And the only other things I have to add is that the county began significant changes once they started as new management in the planning department, because our previous codes weren't in compliance with the state rules and regulations. So we ratified quite a few county codes, including our comprehensive plan was shortly updated thereafter. And that really began the ball rolling with a lot of our updates to become compliant and practice good planning practices instead of prior planning practices that weren't necessarily the best.
And how involved were you personally with the updates to the planning provisions in the Benton County Code?
At that time, I was a junior planner, so I wasn't overly involved in the 2018 updates. I was on the periphery, and I was aware of the ongoings, but at that time it was primarily Mr. Wendt and Mr. McPherson who led the charge on those updates and that work.
Even from that kind of stepped back distance, are you aware of what efforts the county makes to reach out to the public and to solicit comment on these county code changes?
Yeah, so generally under state statute, we're required to do public notification for any project of any size, but depending on the type of project, they have different requirements. So when we have a site-specific project, we typically notify not only the property owners on record, but also the neighbors within a certain distance to the subject property. If it's non-project specific or non-site specific or a non-project, then no direct notice is required as it applies to the entire county. And to be able to send out 36,000 notices would be a cost burden to the county. So we publish in the newspaper, and that is our due diligence for notifying people of proposed actions when it comes to countywide.
Do you recall when the public hearing was held on this change to the Benton County Code, were there any persons that came forward to speak?
Yes, there were. There was a handful of interested parties who had direct ties to renewable projects or potential renewable projects.
And were those people residents of Benton County?
No, only a few of them were residents of Benton County. The others, as I mentioned, either had special interests or were developers looking to develop within the county. They weren't actual residents of our county.
Prior to the hearing, do you recall receiving any community outreach by other means? Email, phone calls, anything like that?
I'm sure there were at least a few phone calls. I don't recall. It's been quite some time, and my memory is not the best from that time.
I may share with you what has been marked as Exhibit 10. Can you see that document?
Yes.
There at the bottom of that first page appears to be an email from a Brent Strecker. Do you recall receiving that?
I don't recall it off the top of my head, but it's very common for us to receive emotional emails such as this from folks in the county when projects are happening.
Did you happen to go by the last name Cook in the past?
I did. I recently went through a divorce, so my last name reverted back.
Okay. So would that be you then on the CC line, Michelle Cook, with the email?
That is correct.
Okay. And is that comment from a member of the public as far as you know?
Yep, it appears that the person who wrote that is from unincorporated Benton County based on the address.
And is that comment in support of the change of the Benton County Code or against it?
It is in opposition. Or it's in support, I suppose. It's in opposition to renewable projects.
And so changing now the same document, going down to page 374, do you recall receiving that email?
I don't. I receive a lot of emails.
Does that email appear to be in favor of or against the change in the Benton County Code? And I can scroll down so you can read the rest if necessary.
No, it sounded like from my quick reading that the resident didn't understand the intent, so we had a conversation where I explained to her what it meant, and then she was in favor of the ordinance amendment to prohibit the renewable energy projects.
So, would it be fair to say that not everyone in the county is aware of these changes to the Benton County Code?
Yes, I would say that's true.
Would it be fair to say you did get some participation from community members?
Yes, we did. Even if they didn't show up at the hearing that night or that day.
And would it be fair to say that the change in the Benton County Code is in line with some of those community interests?
Yes, I believe that the changes that we proposed and that were adopted are in line with the majority of the county's 37,000 residents, not necessarily obviously in alignment with the people who have a vested interest in projects like this for economical reasons, but overall I would say the county is in support, especially the agricultural community. I know in my experience with the Horse Heaven Wind Farm, reaching out to the AVA associations and other special interest ag groups, they were opposed to such a project. The farmers who were in support of it were the ones who were directly financially benefiting from the project. However, their neighbors necessarily aren't in support of such a project.
And what is your understanding of why solar power generator facilities major were removed from having the option of getting a conditional use permit on GMAD lands?
They were removed because they are considered industrial in nature, and the amount of land that they take up is too great to meet the test of the 1 acre or less when it comes to non-ag uses. We have a provision in our code that's non-ag accessory uses, but they must be limited to less than 1 acre and meet a host of other tests. Projects of this size and scope are much larger than that, and obviously misappropriately convert ag lands that are meant to be conserved and protected under our charge.
If the council were to preempt that code and allow this facility, are there any conditions that you're going to recommend the council include in their recommendation to the governor?
I can't think of any conditions in the land use matter specifically that would enable the mitigation of a project of this size and scope. I know that there was lots of discussion today about other mitigation measures, specifically through the SEPA and environmentally based, and that's a completely different topic. While you might be able to mitigate for environmental issues, you can't mitigate for the loss of lands that are zoned and designated that are supposed to be protected and conserved. So unless we are able to find extra land in Benton County that meet the set of criteria laid out by the state to designate lands of long-term commercial significance, then I don't see a way to condition them under this specific and very pointed purview that we're discussing today.
And in terms of conditions, what is your understanding of the law on when the council makes their recommendation, what sort of conditions must be imposed? Are you aware of that?
Specifically, but after participating in one project already, my understanding is that the council has quite a broad view of their ability to be able to propose or recommend conditions. Whether or not that's upheld by the governor is a different matter, but they certainly can review all of the reports and assessments and the environmental impacts and make appropriate recommendations to mitigate projects.
There were conditions in the revised MDNS. Why didn't the county comment publicly on the original MDNS and propose conditions that would help those land use issues?
I don't believe that we chose to comment on the MDNS because we typically, as land use planners, aren't the most technical experts. We rely on our partners such as Fish and Wildlife and others to provide those technical recommendations or those technical conditions that should be imposed because it is environmental in nature. As much as I would like to be able to speak to wetlands and habitat and all of those things, I'm not the local expert on that, nor do I have the education for speaking to environmental impacts and mitigation. That would be in the hands of our technical counterparts. And so in reviewing the MDNS document, I felt like the agencies who needed to recommend conditions certainly did that in there, and I didn't feel that I had anything to add.
So if the MDNS had gone beyond environmental concerns to specifically land use preemption, would the county have commented?
More than likely.
Having the opportunity today, are there any conditions that you are asking the council to impose that address the county's concern with land use preemption?
There are not.
Does the county code ban solar and other renewable energies blanketly?
We do not. As was previously discussed with Mr. Wendt, we allow them in our industrial zones, although those are limited. We also allow them in the unclassified zone, and just this year in July or August, 8,000-acre solar project is being proposed at the Hanford site. I think that is an appropriate use of the Department of Energy's land and resources that they own. And so private developers are now seeking to site their projects there. That land has been disturbed historically and is a very appropriate place for projects such as this one.
Why is that area more appropriate than ag lands if, at the end of the day, the lands through the MDNS requirements could potentially be returned to ag lands?
I would say that's because the Hanford site has historically had, they've had disturbances and they've had energy projects there with the Hanford Nuclear Reservation that have compromised the overall health of that area. And while the DOE and partners are working hard to bring back environmental enhancement in some of that site isn't going to be restored 100% to a workable area that would be safe for any other use than energy or industrial type uses.
We've heard some testimony earlier. Do you recall testimony that this is a compatible use with surrounding area lands? Do you recall that?
I do recall the applicant's witnesses trying to make that case, yes.
Do you agree?
Do not. I believe that, I believe that it's not compatible with surrounding areas, although it may make a although it doesn't seem to have a large impact, I think when you parcelize and break up agricultural lands, there is long-term effects that happen from that. I don't think a lot of regular people who aren't aware of long-term land use patterns would necessarily understand that. I also feel like it's a disturbance to the soils underneath. We have yet to understand what the long-term impacts to soils that are shaded for 20 or 30 years will be. And so it's hard to say with certainty that it's going to be as vibrant of agricultural area as it is currently today under the Robert family.
Is there anything else that you'd like to share with the council today that you feel would be helpful in them making a decision?
I don't have anything too much more. I would like just to point out that the Washington Clean Energy Act has been brought up a number of times, and I think one of the important things to remember with that, especially when talking about preemption, is that the renewable energy that the governor has charged us with is to be consumed in Washington state. I don't know that the energy in this project is actually going to stay in state or even locally, and I think that's a very important idea to consider as the council, especially when many projects are happening, and you have to think collectively that we're impacting one county and the burden is being shifted on one county or a small handful of counties in the state when perhaps it's not even a need that's being met locally or on the state level. And I don't think it's appropriate personally or professionally to do that here in Benton County without taking a holistic approach and looking at the collective impacts that all of these projects in the surrounding areas have on land use and the health of our state.
Thank you. That's all the questions that I have for you.
All right. Ms. Anderson, any questions of Ms. Mercer?
I have no questions for her. Thank you.
All right. Mr. Crowell, any questions of Ms. Mercer?
I have no questions.
All right. Council members, if you do have questions, please raise your hand. Chair Drew, any questions before we release this witness?
I have no questions.
Okay, very good. And then, Ms. Holt, I do believe that was the entirety of your witnesses. Is that correct?
That is correct.
Does Benton County rest?
We rest.
All right, Mr. Crowell, you didn't have any witnesses or exhibits. Does Council for the Environment anticipate presenting any case?
No, Your Honor.
Okay. So with that, we can segue at this point to closing statements. Again, I propose we just take a 5-minute rest, let the councils compose themselves and get their closing statements ready, and then rejoin at 3:55. So the hearing will continue to run, so we're going to get about 10 minutes of dead air, or 7 minutes, and we will pick up at that point. So please be back at 3:55. All right, it is 3:55. Let's go ahead and move on to closing statements. We'll do another roll call to make sure everyone is present, and then we'll go ahead and segue into those closing statements. Ms. Anderson, are you present on behalf of the applicant? Doesn't look like it quite yet.
Yes, sir, I am.
Oh, there we go. Ms. Holt, are you present on behalf of Benton County?
I am.
Very good. And Mr. Crowell, present on behalf of Council for the Environment?
I am.
And Ms. Owens, if you go ahead and take the roll of the council again, please.
Absolutely. Chair Drew? Department of Commerce?
Elizabeth Osborne, present.
Department of Ecology? Department of Fish and Wildlife?
Mike Livingston, present.
Department of Natural Resources?
Lenny Young, present.
Utilities and Transportation Commission?
Daisy Brewster, present.
Benton County?
Dave Sharp, present.
Department of Transportation?
Paul Gunta, present.
That is the entire council.
Thank you, Ms. Owens. Mr. Botello, are you present as well?
I'm here, Judge.
Excellent. Okay, one final confirmation, there was no ex parte communication. I represent to all parties. I did not have any conversations with anybody whilst we were on that brief break. If anyone disagrees with that statement, please raise your hand and we will preserve it for the record. No hands have been raised. Let's move into closing statements. I do remind both, or all three parties rather, we've all agreed to 5-minute closing statements, and then 1 week after closing to submit post-hearing briefs. So with that, Ms. Anderson, do you wish to make a closing statement on behalf of the applicant?
Yes, sir, I do.
All right, then go ahead and begin. We'll estimate the time in general.
I will be under 5 minutes.
Thank you.
Thank you, Your Honor. I'll be brief. There is only one topic before this council today, and that is land use inconsistency, which drives the two issues the council has to resolve: the need for preemption and conditions for the SCA to recognize preempted local provisions. The SEPA issues are already covered in the final MDNS: soil monitoring and restoration, water supply and quality, dust. Notably, pursuant to SEPA Regulation 197.11.444, land use and shorelines are included in SEPA as well. Cumulative impacts, traffic, lights, noise, all of these have been addressed and mitigated by SEPA responsible officials for FSEC, and Benton County did not challenge any of that. There is nothing more to do on these issues during this adjudication. And FSEC's priorities, they're set forth in RCW 8050.010, and preemption, which should be guided and informed by those policies, is authorized by RCW 8050.110. If anything, the urgency of siting clean energy facilities has been brought into painfully stark focus with the passage of the Clean Energy Transformation Act, whose deadlines to transition Washington away from fossil fuel-generated electricity are bearing down quickly. And in no uncertain terms, when a county refuses to permit a renewable energy project, FSEC has the authority to do so. FSEC used its preemption powers in a similar situation involving the GMA years ago when Kittitas County tried to block a wind project using the GMA. The council should preempt again here. We have the same identical situation. It is telling that Benton County's GMAP previously authorized solar energy projects of this scale as a conditional use. And yet not one word of testimony was offered today in this adjudication that the change in the code was driven by any change in the comp plan. What changed was the county's mind about clean energy. Despite this, Energex has agreed to appropriate CUP conditions as set out in the MDNS in order to address the county's conditional use criteria and RCW 8050. Benton County, in its brief and as concurred with by the county's community development director, agrees that those are the appropriate conditions if FSEC exercises or recommends exercise of preemption powers. And indeed, Benton County is not seeking any additional land use conditions beyond the land use and shoreline conditions expressly called out as land and shoreline use conditions in the MDNS. Applicant has developed Wautoma to be sited on agricultural lands that have been declining in productivity and commercial relevance for decades. Its current and future water availability is questionable, and this project will help the landowners expand their ag activities through a smart water strategy that will result in them collectively using less groundwater, leaving more in the aquifer. And harvesting solar energy here is not displacing any ranchers, any farmers, or any viticulturalists in their ventures. It is providing them with the means to actually grow their agricultural business and profitability. Conversely, not preempting Benton County land use regulations will deprive the state of Washington of the renewable energy that it needs, and it will deprive these landowners of their best and possibly only chance of becoming profitable on their ag lands. FSEC's statutory mandate under 8050.010, including the precedent pressing need for more energy facilities in this state should drive your decision and justify preempting Benton County's ban on renewable energy in the GMAT. The Council is legally authorized to recommend preemption, and I would posit, if not here, then where? We respectfully ask that you do, in fact, recommend preemption approval and the imposition of all of the conditions in the staff's MD&S and all of the conditions in the applicant's Section A5 measures in the application for site certification. We will provide a post-hearing brief further explaining how and why preemption is FSEC's best choice for the Wautoma project. Thank you.
Thank you, Ms. Anderson. Ms. Holt, do you wish to make a closing statement on behalf of Benton County?
Yes, thank you, Your Honor. The Council has heard testimony from both parties that the local land use regulations do not currently allow siting of solar power generator facilities major. The parties also agree that FSEC has the ability to recommend preemption of those regulations. Where the parties disagree is whether there are sufficient proposed conditions that address state and county land use interests regarding the preservation of agricultural lands. There has been testimony that both the state and the local level have an interest in this. If the Council recommends preemption, the law requires that they make condition recommendations in its draft certification agreement that address these local interests. The applicant proposes that environmental conditions and the boost to surrounding area ag is enough. However, we have heard testimony from the county that none of the conditions in Table A5 of the application or the revised MD&S address the loss of ag lands during the life of the project. The exhibits, specifically the revised MD&S, in the record further show that even with all of the conditions imposed, return of the subject property lands to ag use is not a foregone conclusion. Benton County's position is that there are no conditions proposed to protect its interest in the loss of ag lands. If no such conditions are required in this case, we are setting a standard for future similar projects to move forward in a manner that will completely undercut the county's ability to protect its own interests and in a manner that is contrary to Chapter 8050 RCW. The county is recommending, or the county is requesting, that the Council recommend against preemption to the Governor. Thank you.
Thank you, Ms. Toll. Mr. Kroll, do you wish to make a closing statement on behalf of Council for the Environment?
Thank you, Your Honor. I do not.
Okay. So with that, we are going to close today's proceedings. Last couple matters of housekeeping I'd like to address. Ms. Anderson, I would ask that you immediately, if you haven't already done so, upload the new Exhibit 28 to what has been previously to the same manner in which you uploaded the other documents for the Council's consideration. Pre-hearing briefs will be submitted by all parties if they choose to do so by October 2nd by 5 p.m. In addition, I will make the audio of today's hearing available for the Council for their review. And with that, I will hand the closing of the proceedings off to Chair Drew and any final statements she wishes to make.
Thank you, Judge Girard, and thank you to everybody for participating in this hearing today. The Council will take all the information provided before making a determination, and we look forward to those briefs and also to Judge Girard's findings and conclusions, at which point we will then deliberate. Thank you very much.
Thank you all.
This meeting is adjourned.
Thank you all. The time is
if we're ready to do so, Judge.
I am. Thank you. The time is 4:05 and the record is closed. Everyone have a very good evening. Thank you all.